All fresh matters could. All fresh matters. Monday I'm not sitting, it makes me Tuesday. Or you want to move the other court, you can move. Tuesday, according to seniority, there are so many matters pending. We'll see. Monday, Tuesday, Wednesday, Thursday, any day. Wait, I'll come this. Put I'll give. Why are you standing there? Come this side. ಕೊಡಿ ನೀವಲ್ಲ ರೀ ಕೊಡಿ ಎಸ್ ಗಿಫ್ಟ್ ಬರ ಎಲ್ಲ ಕೊಡಿ ಪರವಾಗಿಲ್ಲ ನಾಳೆ ಅಂತೂ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ ಸರ್ ಕೊಡಿ ಪರವಾಗಿಲ್ಲ ನಾಳೆ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ ತಾನೆ ಶನಿವಾರ ನಾನು ಬರೋಲ್ಲ ಬಂದಾಗ ಬರುತ್ತೆ ಮಂಗಳವಾರ ಬುಧವಾರ ಯಾವತ್ತಾರ ಬರುತ್ತೆ ಬಿಡಿ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಸರ್ ಏನ್ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಳ್ಳಿ ತೊಂದರೆ ಇಲ್ಲ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗ್ಬಿಟ್ರೆ ಏನ್ ಪ್ರಪಂಚ ಬಿದ್ದೋಗಲ್ಲ ಬಿಡಿ ಎಸ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಯಾವಾಗ ನೋಟಿಸ್ ಮಾಡಿರೋದು ಯಾರು ಮೇಡಮ್ ಅದು ಯಾವ್ದು ಲಿಸ್ಟ್ ಆಗಿ ರೀಚ್ ಆಗ್ಲಿರ ಟ್ಯೂಸ್ಡೇ ಹಾಕಿ ಮೇಡಮ್ 2:30 ಯಾವ್ದಿಲ್ಲ ಕೊಡಿ What? Why proclamation? Why proclamation? You have not gone ashte. No problems. No problem. Yes. No, may let it be. Monday or Tuesday it will come. Yes. Yen escape ಆಗಿರೋರ್ಗೆಲ್ಲ ಏನ್ ಬೇಕಾಗಿಲ್ಲ ಅರ್ಜೆನ್ಸಿ. Yes. No problems. No problem. ಏನು ತೊಂದರೆ ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ ಬಿಡಿ. Yes. No sir. So appear, yes. Appear before the court, sir. Appear. Are you appear, sir? Yes. No, nothing. Yes. Vacating stage, all kottbidi. All vacating stage applications, please give. Not that side. Wait. Give. Kodis. Give everything. So, ಏನಿಗ ಅದಕ್ಕೆ ಏನ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ತಾನೆ ಬರತ್ ಕೊಡಿ if you have urgency move the other court on Monday, all right, which whoever has very terribly urgent cases move the in charge court on Monday. No 2:30 no problems Monday Tuesday when I sit or move the court on Monday. Yes. Fresh up pending. Body. No 2:30. Take bail. No problem. Yen madakagala sir. That's the procedure. What to do? Yes. Kodi. Sorry. Yen parayilla.
This is for petition who wants to go to abroad for education.
Go. Early kodi tondre illa. Yes.
This is for
Tuesday or Wednesday passport that.
This is for the end of the list, my lords. Kindly.
Give it, sir.
End of the list, my lords.
No, sir. Why,
sir? Because the accused is in custody, my lords. Love relationship. In the complaint, she specified she is in love, my lords. He's been in custody, my lords.
69.
64, my lords. They've invoked 64 because 69, my lords, they have diluted. They feel it is diluted, my lords. Please.
2:30. Yes.
February ಅಲ್ಲಿ 2 weeks later ರಿಸ್ಟ್ ಆಗಬೇಕಾಗಿತ್ತು ಮ್ಯಾಟರ್
ಕೊಡಿ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಮಲಾಡ್ಸ್ ಎಲ್ಲ ಕೊಡಿ ಪೆಂಡಿಂಗ್ ಫ್ರೆಶ್ ಏನಿದೆ ನೋ ಪ್ರಾಬ್ಲಮ್ ಕೊಡಿ ಸರ್ ಮಲಾಡ್ಸ್ ನೋಟಿಸ್ ಇಶ್ಯೂಡ್ ಕೇಸಸ್ ವಿಲ್ ಬಿ ಲಿಸ್ಟೆಡ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡಿ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಸರ್ ಎಲ್ಲ ಕೊಡಿ
ಮಲಾಡ್ಸ್ ಇಫ್ ಇಟ್ ಇಸ್ ಅ ಕಂಪ್ಲೇಂಟ್ ಬಿಟ್ವೀನ್ ಫಾರ್ಮರ್ ಟೆನೆಂಟ್ ಅಂಡ್ ದ
ನೋ ಪ್ರಾಬ್ಲಮ್ ಗಿವ್ ಇಟ್ ಸರ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ತಾನೆ pending
passport is rejected pending mallards they are vacating also
application haki for renewal of passport
they have also
application haki for renewal of passport
fresh ke apply madre reject but for this petition
petition is meant for that to vere
no mallards then petition the respondent's petition accused petition is came B report was filed landlord petition the FIR charge sheet was filed mallards your lordship has appreciated and stay the proceedings but for that malad FIR passport is rejected
on separate application separate application haki for renewal of passport I will
renewal illa fresh only I have to apply students she is a student
ಅದಕ್ಕೆ ಕೊಡಿ ಸರ್ application haki ಒಂದು
Vacating
May-
next week ಯಾವ್ದಾದ್ರು ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡ್ಬೋದು.
ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ನೆಕ್ಸ್ಟ್ ಡೇನೆ ಕೊಡ್ತೀನಿ.
Obviously.
Yes.
My lord, the respondent complainant has.
Give it, sir. Give the memos. I'm 2:30 ಯಾವ್ದು ಇಲ್ಲ. Give them unless you are arrested. ಕೊಡಿ.
My lord, this honorable
ಕೊಡಿ ಕೊಡಿ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ನೋ which bail code sir? ಇಲ್ಲಿ ಮಧ್ಯಾಹ್ನ ಕೇಳ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ ರೀಚ್ ಆಗ್ತಾ ಇಲ್ಲ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂತ. ವಿಶ್ವೇಶ್ ಶೆಟ್ಟಿ ಸಾಹೇಬ್ರ ರೀಚ್ ಆಗ್ತಾ ಇಲ್ಲ ಅನ್ಹರ್ಡ್ ಆಫ್ ಕೊಡಿ ಸುಮ್ನೆ ಅವೆಲ್ಲ ಬೇಕಾಗಿಲ್ಲ ಕೊಡಿ. ಯಾವ್ದು ಹಾಕ್ಬೇಡಿ ಮಧ್ಯಾಹ್ನ 2:30 ಇಲ್ಲ.
This honorable court directed to.
Give it sir. ಅಯ್ಯೋ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಸರ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
My lord, this honorable.
FIR was filed in the month of November till today. Hachi.
No problem. Give it sir. Please give it. Who is in custody?
Your Honor, he was taken into custody in the month of December. Post that, he's been harassed, calling to the police station.
He is still in custody or bail ಸಿಕ್ಕಿದೆಯಾ?
He's out on bail.
Thank you. Yes.
My lord, this honorable court.
No, nothing doing.
My lord,
Yes.
earlier
He's
petition
been
has
harassing
withdrawn,
by
my
the
lord.
police, Your Honor,
ಅದು
for
ಯಾವಾಗ ಬೇಕು?
Charge sheet Monday.
Tuesday madam ಅದು withdrawal charge sheet.
Tuesday it may be listed.
No sir. Give
My
it.
lord, this honorable court
It
directed.
will get listed. Give it.
My lord, charge sheet hapti.
ಏನ್ ಪರವಾಗಿಲ್ಲ. So what? But Act I will not even stay. Are you dreaming? No, nothing doing. I will not even stay it.
My lord, this
You
honorable.
will be worse off if you want the matter to be listed. Take your chance, no problem. Yes.
My lord, this honorable court.
Yesterday also I told you the same thing. Tomorrow again you move this matter, I'll get it posted and dismiss it. All right?
My
Yes.
lord.
There is substantial material on record, Your Honor.
Sorry?
Proving it to be commercial transaction.
No problems. But Act I will not interfere unless charge sheet is filed. Yes.
Your lordship,
ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ.
The petitioner has obtained an interim stay order. my lord.
Vacating stay ಹಾಕಿದ್ದೀರಾ?
Vacating stay,
ಕೊಡಿ.
my lord. The petitioners are reproducing the stay order for all the other.
Will you please vacating stay ಹಾಕಿದ್ರೆ ಕೊಡಿ. Yes.
your lordship,
Any
last
day
week,
next week, my lord.
your lordship, last week, your lordship had directed the matter to be listed this Monday.
Give it.
but
My lords,
next Monday ಹಾಕೊಂಡು.
2025,
ಅದಕ್ಕೆ ಸ್ವಲ್ಪ.
my lords,
Give
2025
it,
fresh
give
matter,
it.
my lords. December it did not reach. From there on, I have been trying
Next
to.
December we'll try.
No, my lords, kindly, my lords.
Give it sir.
Sir, fresh.
ಈಗ ಮೆಮೊ ಕೊಟ್ರೆ ಸರಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಮೆಮೊ ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ. Please give the memo. Please, all of you give the memos.
My lord, this honorable court directed to.
All of you give the memos here.
My lord, on submission.
No problem, give the memo. Yes.
My lord, this honorable court directed to pay.
Recall for what? Why recall, why warrant? 2:30 ತಗೊಳ್ಳಿ ಅದು. Sir, give it, yes. No problem, give it sir.
My lord,
No sir. Yes, give it.
honorable court is directed to pay.
ಈಗ ಇನ್ನು ಒಂದು ನಿಮಿಷ ಕೊಡ್ತೀನಿ. ಮೆಮೊಗಳೆಲ್ಲ ಕೊಟ್ರೆ ಸರಿ, ಇಲ್ದರೆ ಯಾವ್ದು ತಗೊಳಲ್ಲ. Give it. Give it. Give the memos. Give the memos. ಏನ್ ಸರ್? ಏನ್ ಸರ್? ಇಲ್ಲಿಗಲ್ ಡಿಟೆನ್ಷನ್ ಕರೆಕ್ಟ್ ಕೊಡಿ. ಬಂದಿಲ್ವಾ ಅದು ಇವತ್ತು? ಯಾವುದು ಮೈಸೂರು? ಅದು ಮೇಡಮ್ 2:30 ಹಾಕಿ ಮೇಡಮ್.
My
Your lord, the petitioners are the main priests of the male court in Narasimha Swami.
So what's the problem now?
They've been, the FIR has been filed for theft of a perjury sum
So
of
what? Give it.
3,500.
Yes,
My lord,
next
this
week.
honorable court directed to pay 20% of that amount in the deposit.
ಈಗ ಕೊಡ್ತೀರಾ ಇಲ್ಲ ಮೆಮೊನ?
13 crores is an amount.
ಕೊಟ್ಬಿಡಿ ಸರ್ ನೋಡೋಣ. ಎಸ್
They have not paid till.
ಒಂದ್ ನಿಮಿಷ ಆಗೋಯ್ತು. ಎಸ್ ಸ್ಟಾಪ್ ಆಲ್ ಆಫ್ ಯು. No, I am not going to get back to you for taking the memos. If you want to give it, period. Yes.
This is a POCSO case wherein a minor girl was hanged. Trial has been pending for over 11 years.
Speedy disposal kodi. Yes. Post it on Tuesday. Yes.
Lords, I am the complainant in this case, and prior to the petitioners obtaining the stay.
Vacating stay, you filed vacating stay?
Yes, ma'am.
Give it. Yes.
My lord,
Wait. Yes.
Your lordship, this is a matter wherein the husband of the complainant files a complaint that gets to be stayed, my lords. Subsequently, the wife has now come and filed a complaint for the same transaction, same agreement of sale, my lords. As well as what has happened is the.
Fresh matter.
Yes, my lords. 2:30,
No
my lords.
2:30.
My lords, the petitioner
Nothing
was
doing.
picked
Give
up.
it. Yes. There is no urgency
My
there.
lords, the petitioner.
Husband and wife, stop fighting first. Everything
My
will be
lords,
fine.
no, my
Nothing
lords,
doing.
I
Give
am
it. Give
not
it.
the husband, wife, my lords.
No 2:30. Give it.
My lords,
This matter.
No 2:30.
My lords, defreeze of account, my lords. For the
Give
defreeze
it.
of
Give
account,
it.
sir.
Yes.
Lordship, I've been, in my own complaint, I've been arrayed as an accused, Your Lordship. I've also asked for investigation in the matter. Instead, they've made me only an accused. And charge
Fresh
sheet if it
matter.
is filed, Your Lordship.
Fresh matter.
Yes, Your Lordship.
Kodi.
My lord, it is a tender matter, my lord. There is a special order to be listed before this court. Although I have a stay without
Tender
even
matter fresh. Special
blacklisting,
order. ಯಾವ್ದು
my
madam
lords.
ಅದು? Just check.
Kindly have it on Tuesday, my lord.
We'll see. Yes.
Vacating stay matter, my lord, date may be given.
Give.
Regarding a boat which was cheating on a boat.
Vacating
Any
stay, no
may be
date, but it will come. Yes. give it,
Your
yes.
Honor, the
Beyond 10 or 12, I can't take in a day. madam. No problem. Give it. Yes.
Your Honor,
Matter was filed on vacations 12th. It was
No
listed
problem.
with-
Give it, madam. Yes.
After that, it has went to the pending branch. my
No,
lord.
It will go there only if you move the vacation bench.
your
Yes.
lordship, this is the fresh matter.
Complaint has been given by the in-laws and house trespass on the single mother. She is unable to see the
ಆಯ್ತು
child.
ಕೊಡಿ ತೊಂದ್ರೆ
Your Honor, this is,
This is the.
Pending
first
matter ಆ?
ಇಲ್ಲ.
ಮತ್ತೆ
New
fresh
fresh
ಬರತ್
matter.
ಕೊಡಿ
18th I have
ನೀವು
filed
ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ
ಮಾಡಿದೀವಿ.
ಬಂದೇ ಬರುತ್ತೆ
But
ಬಂದೇ ಬರುತ್ತೆ ಉಳಿದಿರೋದು 430 ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಮಂಡೇ ಪೋಸ್ಟೆಡ್ ಟ್ಯೂಸ್ಡೇ ಪೋಸ್ಟೆಡ್ 300 ಇನ್ 130 ಮಿಕ್ಕಿದ ವೀಕಲ್ ಬರುತ್ತೆ ಅಷ್ಟೇ
your lordship, this is,
ಬರುತ್ತೆ ಸೀರಿಯಸ್ಲಿ ಹೌ ಮಚ್ ಕೆನ್ ಐ ಟೇಕ್ 1000
ಇಲ್ಲ,
ಇಲ್ಲ
ಇದಕ್ಕಿಂತ-
ತಾನೆ ವೇಟ್
ಇದಕ್ಕಿಂತ
ಇಟ್ ವಿಲ್
just
ಕಮ್
matters have been listed. That's all is
ನಿಮ್ಗೆ
fine.
ಮುಂಚೆ ಕಂಪ್ಲೈ ಮಾಡಿರೋದು ಬರ್ತಾ ಇದೆ ಬರುತ್ತೆ
your lordship,
Your lordship,
this is the fresh matter.
wait about 3 of you are speaking at once wait yes
ಲಿಸ್ಟ್ ಆಗುತ್ತೆ ಲಾರ್ಡ್ಶಿಪ್ ರೀಚ್ ಆಗುತ್ತಿಲ್ಲ ಮ್ಯಾಟರ್ 4 weeks ಆದ್ಮೇಲೆ ಲಿಸ್ಟ್
ರೀಚ್ ಆಗಿಲ್ದೇ ಇರೋ ಮ್ಯಾಟರ್ ಎಲ್ಲ ಟ್ಯೂಸ್ಡೇ ವೆನ್ಸ್ಡೇ ಹಾಕಿ
Your lordship, I have.
Give it.
Your lordship, this is the fresh matter, your lordship.
Give it,
They have
yes.
filed
Call
an
the
FIR
cases,
for
madam.
cheating, your honor.
no I have
Kindly
told no over it's period yes
Your
if you want to give the memo give the memo
lordship,
nothing vacating stay kodi no give it yes
Raj, may make one
if you
submission.
want to give the memo
Raj, one submission.
adjournment no adjournment
No,
in the morning direct or indirect
Yeah, my
yes.
lord, one submission.
Yes.
On 22nd, your lord had reserved the orders on.
ಯಾವ್ದಪ್ಪ?
Petition 742, promise to marry case. my lord.
ಯಾವ್ದ ಪ್ರಾಮಿಸ್ ಟು ಮ್ಯಾರಿ
Invitation card ಎಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದಂತ ಹೇಳಿದ್ರಲ್ಲ.
ಯಾವ್ದು ಮೇಡಮ್ ಹಾ ಏನ್ ಹೇಳಿ
Opposite counsel was.
ವಾಟ್ ಟೆಲ್ ಏನಾಯ್ತು
Raj, you had reserved it for judgment.
ಹಾ
And you told me to file any additional.
correct yes
My lord, I file it, I'll ensure it reaches your lordship.
where have you why did you file it in the registry should you not give it here
My lord, I filed it in the.
you said it's sensitive material and why did you file it in the registry
Yeah, my lord, I had instructions from senior to file it in the registry.
ಮೇಡಮ್ ತರಿಸಿ ಯಾವ್ದು
My lord.
get it here only first
your lordship, one submission.
ಆಯ್ತು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಮೆಮೋಸ್ ಇಲ್ಲ ಆಯ್ತು ಎಸ್ ಕಾಲ್ ದ ಕೇಸ್
Lordship,
ನೋ ಕಾಲ್ ದ ಕೇಸಸ್
One
ಎಸ್
request, one request, ma'am. One request, ma'am. One
ನೋ
matter
ಮೆಮೋ
urgency.
ಇಸ್ ಓವರ್ ಎಸ್
Not one matter urgency, my lord, 2025 stays there. Not employment prospects are affected. He is a
no problem give it
authorized officer.
give the memo no nothing on that
Without following the due procedure.
no problem sir it will come on Tuesday 2:30 ಏನಿಲ್ಲ why did you escape trial yes
My lords, directly, I am the co-accused, my lords. The
No,
charge sheet
no.
was filed and directly NBW was. found to be
nothing
issued.
nothing
Next date proclamation has been issued.
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ
Petitioner is ready to appear, my lords. Next date is on.
obviously you have to be ready to appear
Next date is on 27 or else there was no urgency, my lord.
2:30 ತೊಗೊಳ್ಳಿ
But I am not requesting for 2:30, for Tuesday, my lord.
ಬರುತ್ತೆ ಬಿಡಿ ಸರ್
Tuesday.
your lordship,
ಟ್ಯೂಸ್ಡೇ
one
ಆಗ್ಲೇ 300
submission.
ಇದೆ ಮಿಕ್ಕಿದ್ ನೋಡೋಣ ಆಮೇಲೆ
Wednesday, my lord.
Your lordship, one
ಅವತ್ತು
submission.
200 ಇದೆ ಥರ್ಸ್ಡೇ ಫ್ರೈಡೇ ವಿಲ್ ಸಿ
Your lordship,
Lordship,
this is the
dowry
fresh
death,
matter,
lordship.
your
ಸಾಕು ಎನಫ್ ಕಾಲ್ ದ
Fine.
ಕೇಸಸ್ ಎಸ್
Just one fresh matter, still number 1.
For petitioner, ma'am. I'm filing memo for withdrawal.
ಹಾ ಆಯ್ತಲ್ಲ ಸುದರ್ಶನ್ in terms of the learned counsel of the petitioner files a memo seeking to withdraw the petition
Only the thing is, I hope he has not filed at liberty to refile.
No.
Yeah.
Nothing is mentioned.
Liberty, it has to come here only so don't
Please, my lords.
Apology.
ಅಲ್ಲ ಅವ್ರಿಗೆ ಪೆಟಿಷನರ್ ಸಿಗ್ತಾ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಅದಕ್ಕೆ
Grateful, my lords.
Number 2.
ಎಸ್ ಸರ್
Yes, my lord. I'm sorry, last time I was a little late.
ಕರೆಕ್ಟ್ ಎಸ್
What I respectfully submit is, a private complaint is lodged under section 200 to the learned magistrate. Neither he has taken sworn statement, nor he has referred the matter to the police as required. Under those circumstances, the order passed by the learned magistrate and consequently the revision petition is not correct. I just invite, on this point, I invite my lord's attention to the one judgment of the Supreme Court, of course. Straight away, I take my lord's attention to paragraph 59, my lord. Instead of reading of all that,
ಎಸ್
the decision
ಪ್ಯಾರಾಗ್ರಾಫ್
59, my lord. 59. The decision in Manu Pawar versus so and so is rather successful. The court held that complaint is presented before a magistrate, he has two options. One is to pass an order contemplated by section 156(3). The second one is to direct examination of the complainant on oath and the witnesses present and proceed further in the manner provided by section 202. An order under section 156(3) is in the nature of peremptory reminder of or intimation to the police to exercise this plenary power of investigation under section 156(1). However, once the magistrate has taken cognizance and under section 190 of the code, he cannot ask for an investigation by the police. After cognizance has been taken, if the magistrate wants any investigation, it will be under section 202. Whose purpose is to ascertain whether there is prima facie case against the person accused of the offence and to prevent issue of process in a false or vexatious complaint intended to harass the person named. Such examination is provided, therefore, to find out whether there is or not sufficient ground for proceeding further. We do not intend to go into the question or the merits of the allegations and what procedure the magistrate should follow, as this is an aspect which the magistrate must
All right, I've
first
seen.
consider.
Yes.
First consider and decide judicially. And as per the law,
Now, what has happened here?
in this case, my lord, neither sworn statement is taken under section.
No, the complaint is analyzed. There is no merit in the complaint. Complaint is dismissed. Is that the case?
Yes.
All
yes,
right.
sir.
After
Now, in this
dismissal
case-
of the complaint, you file a revision. Revision affirms it.
We have filed the documents here also
Ah.
to point out that a prima facie case is made out because the affidavit that is sworn to by the other side, that is accused, is totally false because they say we are the only heirs of the deceased. Now a suit is pending for partition. In that case, they have contended that the property is theirs on account of the allotment made and subsequent changes. Therefore, the learned judges may not be correct to say there is no prima facie case when these documents were placed before the court. I just take my lord's attention to the documents which I placed before this honorable court on the last date of hearing.
Yes.
Last time. Yes. May I take, before that, my lord, I take my lord's attention to the complaint. that
What is the
lodged.
relationship between the complainant and the
They're
respondent?
all close relatives, father, brothers, sisters, sister's son, and so on. Suit for partition.
Now, what have you challenged in the?
In the complaint, my lord finds the complaint at page 13 of these documents dated 21/3/2022. My complaint is before the honorable court. I just take my lord's attention to the relevant paragraphs. Of course, paragraphs are not numbered, but however, I take my lord's attention to 4th paragraph. Without the knowledge of the consent of the legal heirs of Sri H.M. Mallikarjunappa and without mentioning anything about the two daughters, Sri H.M. Mallappa, H.M. Jayadevappa, Chandrasekharappa, have given a false statement, indemnity bond, stating that Sri Mallikarjunappa had only 3 sons and they are the sole legal heirs of Sri H.M. Mallikarjunappa. This acts to cheating, fraud, misrepresentation of facts, criminal conspiracy to illegally acquire the valuable property and to have unlawful gain. Therefore, under the circumstances, I request your good self to register the FIR against H.M. Mallappa, H.M. Jayadevappa and Sri H.M. Chandrasekharappa for cheating, misrepresentation, so and so. This is my complaint. And to say that there is no dispute about the relationship, I have placed my lord, genealogical tree on page 12. H.M. Mallikarjunappa, his wife, Srimati Lingamma, both are dead. He has got Sharadamma, Mallappa, Jayadevappa, Chandrasekhariya, Uma Devi, and Basuraj. Now we are the children of Srimati Uma Devi. Whole attempt is made in swearing to a false affidavit for the reason they don't want us to claim the particular site, which is the subject matter, one of the subject matters in the suit. And secondly, they have produced the indemnity bond also stating that they are only legal heirs and execute the indemnity bond, which my lord finds it at page 3. That's all.
Ashtana.
So one procedural aspect, another factually finding that there is no prima facie case is also wrong because the documents are there obtained under Right to Information Act from the BDA. And therefore, my respectful submission to my lord is the learned judge.
I'm afraid you'll run the risk of the suit itself getting dismissed.
Complainant's mother, my lord, died on 24/2/1984. Uma Devi. Now he claims that his mother was entitled to a share. And he has filed a suit stating that mother was
That
entitled
is
to a
suit,
share.
let
Please,
the
my lord.
suit go on.
And now, my lord, he files this complaint, my lord, practically stating that the registered partition deed.
Partition date is 8/4/2002.
Please, my lord. It itself is fraudulent and other allotments are fraudulent.
That anyway, that is
Please,
in the
and
suit.
please, my lord. IA was also filed for injunction. Initially, expert have granted. That was finally after hearing it is dismissed, my lord. Our contention is daughter is on that date, my lord. She was dead after dead. Daughter who had already died is not entitled to share after the even of the.
Then it revolves around allotment of a particular site, is it?
Exactly, my lord. Our contention is, my lord, she had already died before the commencement of the act. Amendment Act, my lord. Therefore, she was not entitled to. This is, my lord.
That is in the suit you
Please, my
contest,
lord.
sir.
An attempt, my lord, to coerce us to yield to the demands. And kindly see, my lord, page number 11, page 50, ink page number 52. At what time, exact time this is filed, my lord? Because
election time.
Election time. Because, my lord, one of the parties was XMLA, my lords. They wanted to create this and give publicity, my lord. Got a FIR registered. And, my lord, I beg to humbly submit. This is a case where the learned magistrate analyzed everything and exercised the proper powers under 153 CRPC.
The petitioner is before the court calling in question twin orders. One of the learned magistrate rejecting private complaint in PCR 4431 of 2024, the other by the Court of Session affirming the said rejection in criminal revision petition 328 of 2024, heard so and so. Facts in brief, germane, are as follows. The petitioner stands as a relative of the respondents, alleging foul play, cheating, or abetment to commit offences, seeks to register a private complaint before the concerned court invoking section 200 of the CRPC, seeks a reference of the matter for investigation at the hands of the learned magistrate. The learned magistrate, while passing an order on whether the matter should be referred or otherwise, rejects the plea of reference but proceeds further and rejects the complaint itself on the score that there are on a purely civil dispute involving a title or share of the property, the criminal law is sought to be set into motion. The said rejection of the complaint is tossed by the petitioner before the revisional court. The revisional court, in terms of the impugned order dated August the 30th, 2024, rejects the criminal revision petition, affirming the aforesaid order. It is these two orders that has driven the petitioner to this court in the subject petition. The learned counsel R.B. Sadashivappa, appearing for the petitioner, would vehemently contend that when clear case of conspiracy, cheating, or forgery is projected in the private complaint, the learned magistrate had no jurisdiction to entertain, not to entertain the complaint and reject it at the threshold. It is it was a matter of investigation in the list that the learned magistrate had to refer to under section 156(3) of the CRPC. He would seek to place reliance upon the judgment of the apex court in the case of 2023-14 SCC page 1. Per contra, the learned senior counsel, the PP Hegde, would submit that, would in defense of the order so passed, would submit that the petitioner calls into question a particular partition deed by setting the criminal law into motion with the partition deed of the year 2002, and claims a share in the share for his mother who died in the year 1984. Before the Amendment Act itself came into force, the mother was no more. Therefore, there is no question of granting a share to the son. The learned senior counsel submits that those are the matters that are pending before the competent civil court for adjudication. Therefore, the criminal law that is sought to set into motion in the teeth of the pendency of OS 3264 of 2022 is rightly rejected by the concerned court. I have given my anxious consideration to submissions made by the respective learned counsel and have perused the material on record. The afore narrated relationship between the parties is a matter of record. The petitioner seeks to institute a suit in OS suit in OS 3264 of 2022, claiming 1/6 of the share in respect of the suit schedule property, which is a site, which is a particular site, and several other suit schedule properties. The site is allotted to the grandfather of the petitioner in the year 1981, when the petitioner was 4 years old. Time passes by, and the mother of the petitioner, grandmother,
His mother only died, my lord.
mother of the petitioner dies in the year 1984. Long after the death of the mother, a partition takes place in the property of the properties on 8/4/2002. Long thereafter, i.e. 22 years thereafter, 20 years thereafter, a suit is instituted by the petitioner seeking relief of partition from the hands of the concerned court, where the present respondents are the defendants in the said suit. In the teeth of the pendency of this suit, seeks to set the criminal law into motion on the same cause of action, on the same allegations, except amplifying and glorifying them by dressing it with a color of crime. The color of crime. This is turned down by the concerned court, dressing it with color of crime by invoking section 200 of the CRPC before the learned magistrate. This is and an investigation under section 156(3) is sought. The concerned court, on the following reasons, rejects the said plea of reference under 156(3), but holds that the complaint itself merits dismissal and resultantly dismisses it from page 6 to 12 in pagination 6 to 12 madam is so and so. This is called in question by the petitioner before the revisional court. The revisional court further elaborates the reasons to reject the revision petition by the following order, page 8 to 27. The issue now would be whether the concerned court has power to reject a complaint if the complaint does not make out overwhelming criminality in a given case, or it is a cloak of crime clothed, or it is a civil case clothed in a cloak of crime. It is tried that the learned magistrate exercises his power, the magistrate would exercise its power under section 200 of the CRPC. 202 or 203 of the CRPC reads as follows. Section 203 permits the concerned court to either accept the 200 permits the concerned court to accept the complaint and further refer for investigation under 156(3), or take the matter forward under 204 to examine everything itself. So between the two provisions lies a provision, i.e. section 203, which empowers the learned magistrate to dismiss the complaint if the complaint does not make out any overwhelming criminality for setting the criminal law into motion. This is what is exercised by the concerned court following the judgments of the apex court. The revisional court, as observed herein above, seeks to follow an order passed by the coordinate bench in criminal petition 1422 of 2021 to affirm the dismissal of the complaint. Law does not prevent the concerned court to reject a complaint at its threshold. It is not that every complaint that is filed before the concerned court would merit reference and for investigation under 156(3) or proceedings to be taken under 204 of the CRPC. 203 is a provision that the concerned court is entitled to invoke, which is invoked, and there is no warrant of interference with the orders rendered by both the courts, which are on reasons cogent. Finding no merit, the petition stands dismissed.
Please. Grateful.
Number 3.
Prepare for the petitioner, my lord. The petitioner is the complainant.
Yes, sir.
The prosecution has filed an application under section 242 of the CRPC to produce 3 documents which were not part of the charge sheet at the time of filing charge sheet as secondary evidence now, my lords. Those 3 documents are the notary register, no objection.
That is rejected.
That has been rejected.
Already rejected earlier. And a liberty is given to them, the prosecution, to get this verified with the forensic and then refile it.
That's all right. 207 you can always claim.
But however,
Well, reserve liberty in 207 to seek all those documents if the forensic formalities are concluded by then.
but if my lords may kindly see page number 38 for a moment. The reason why it was not available at the time of filing charge sheet. IO's report was obtained, my lord. They have submitted that though said register was received from the FSL in the said police station, at the time of shifting the said police station to another place, the said register was misplaced.
I think, good sir.
Not identical
Reason may be
circumstance.
observed. What to do? Yes.
In identical circumstance, my lord has already allowed one of, I have produced on the last date of.
Lord, liberty granted is at page 42.
138 proceeding.
Forgery, cheating and forgery.
420 minutes.
This is certificate ಆಮೇಲೆ ಕೊಡ್ಬೋದಾ ಅಂತ ಅಷ್ಟೇ. Not the issue. 63 certificate and the evidence act 63, 64, 65 with the document ಕೊಡ್ಬೇಕು ಅಂತಲ್ಲ. It can be given later point. That's what I have held.
However, as part of secondary evidence, it may be allowed permitted, my lord.
No, 207 you file an application. 91 207 ಏನ್ ಬೇಕಾಗುತ್ತೆ. ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ we come back.
42 ನ liberty ಕೊಟ್ಟಿದ್ದಾರೆ.
So the petitioner is before the court calling in question the order of the concerned court which rejects the application filed by the petitioner under subsection 2 of section 242 of the CRPC, read with section 65 of the Evidence Act, seeking certain documents that were not a part of the charge sheet with particular reference to the report of the Forensic Science Laboratory. The concerned court has rejected it on 22/11/2024. The time has gone ticking. the liberty is always available to the petitioner to file an application and either in section 207 or 91 of the CRPC to seek those documents that are not a part of the charge sheet after the commencement of the trial. More particularly, the provision under section 207, which the apex court clearly holds that the accused would be entitled to accused or complainant.
Complaint.
The parties to the crime would be entitled to certain documents which are not a part of the charge sheet also for to prove the case or the defense for the accused. Therefore, reserving such liberty to the petitioner to not to file to avail of such remedy as observed herein about the appropriate time, the petition stands disposed.
Please, grateful.
Obliged.
For the petitioner, Lordship.
Yes, sir.
Lordship, 509 is the offense, Lordship. May I take Lordship to page number 16? Second paragraph in a public speech.
ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇಲ್ಲ.
ಇಲ್ಲ ಸ್ಟೇ ಆಗಿದೆ ಲಾಸ್ಟ್.
ಓ ನೀವು ಬರ್ತಾ ಇರೋದು ಫಸ್ಟ್ ಟೈಮ್?
ಇಲ್ಲ ಅಂದ್ರೆ ಹಿಂದಿನ ಟೈಮ್ ಅದಿದೆ, ಲಾಸ್ಟ್ ಟೈಮ್ ಸ್ವಲ್ಪ ಅದು 230 ಅಂತ ತಿಳ್ಕೊಂಡಿರೋ ಸಮ್ ಇದೆ.
ಸ್ವಲ್ಪ ಮಿಸ್ ಆಯ್ತು. ಎಸ್.
Insult woman.
ಮೈಕ್.
Insulting modesty of woman, my lordship.
ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ಪೇಜ್ ನಂಬರ್ 16 ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ಪಬ್ಲಿಕ್ ಸ್ಪೀಚ್ ಅಲ್ಲಿ ಅಕ್ಕ ಅವ್ರ ಅಂತ ಅಡ್ರೆಸ್.
ನಿಮಿಷ.
And the present complaint is by the party worker.
ಈಗ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ. List the matter on 31st July. Entry order subsisting will continue to the next date of year. ಅವರ್ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ.
5.
ಎಷ್ಟಿದೆಯಾ ಮೇಡಮ್? ಎಷ್ಟು ಏನು ಬರ್ತಿಲ್ಲ. Arun Shamsar, yes.
In a temple festival, my lord, some exchange of words taken place, for which, my lord, case and counter case.
First time
stay agide.
Kodi ಏನು?
Case and counter
State
case.
ಮಾತ್ರ.
Case and counter case. Now the counter case, my
Counter
lord,
case ಏನಾಯ್ತು?
accused number 2, my lord, petition number 2 filed case against the complainant and others. That has been ended up in B report.
ಚಾರ್ಜ್ ಶೀಟ್
ಇದ್ರಲ್ಲಿಲ್ಲ, ಇದು ಸ್ಟೇ ಇದೆ.
ಸ್ಟೇ ಉಂಟು. ಇದು ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕ್ತಾರೆ ಬಿಡಿ.
My lord, I don't think so, my lord, because political rivalry.
Opposite.
That is the reason.
Yes, ಹೇಳಿ.
There is no injury, nothing, my lord, only they exaggerated the
complainant is served or what?
served under present.
Yes, go on.
Served
We'll
under
close it. Yes.
Only allegation is, my lord, that there was exchange of words, my lord. That has been given, my lord, some exaggeration.
Page. Where is the complaint?
Complaint is at, my lord, page, type to copy is at page
17.
21.
17.
21 is the type to copy.
21. ಏನು 115?
Lord, 189 clause 2,
No,
191
191.
2, 54, 115, 351.
ನಿಮ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ
350. Lord, that is at page, Lord, 26 is the FIR.
ಸೇಮ್ offenses, atrocities.
Atrocity on the extra. But they did not take the complaint first, my lord. First they registered the against me.
Atrocity ಹಾಕಿದ್ಮೇಲೆ ತಗೊಂಡ್ರು.
ಅಲ್ಲ, first ಇದಾಗ.
Yes. The petitioner, yes madam, we'll close it. The petitioner is before the court calling in question registration of a crime in crime number 41 of 2020 petitioners petitioners registration of a crime in crime number 41 of 2025 registered for the following offenses, page 14 offenses is the madam. The heard so and so. Heated exchange of words between two rival members of political parties results in two crimes being registered. One in crime number 42 of 2025 registered by these petitioners against the complainant, and the impugned crime in crime number 41 registered against the petitioners by the complainant. The complainant, though served, remains unrepresented as always. It is the case of the complainant that on a particular day,
2/3/2025.
On 2/3/2025, certain derogatory words are spoken against the complainant or the members of the complainant's political faction. Likewise, the same abuses are hurled against these petitioners. One results in a crime that is registered as observed herein above by the petitioners. The gist of the said crime registered by the petitioners against the complainant is as follows, page 28. In the same breath, a complaint comes to be registered against these petitioners, which reads as follows, page 21 to 23. A perusal at the complaint would not indicate even a semblance of the presence of the ingredients of the offense that is indicated in the as offenses in the crime in crime number 41 of 2025. So did the complaint registered by the petitioners also against the complainant. Both end up in investigation. One investigation in crime number 42 of 2025 results in a B report being filed by the police on the score that there was no ingredients of the allegations that are alleged against them. But the subject petition has remained, the investigation in the subject case has not taken place on account of the subsistence of the interim order. The issue would be on perusal at the aforesaid complaint whether it would make out even a prima facie case of the ingredients of the offences alleged. If the offences are noticed qua, what is alleged is only glorification of the incident to become the offence. Therefore, in the light of the judgment of the apex court in the case of state of Haryana versus Bhajanlal, even if the complaint is taken as true, it would not meet the ingredients of the offences. Except the registration being an action suffering from want of bona fides or mala fide as the case would be. The apex court at paragraph 102 is held as follows. In the light of the said judgment permitting further investigation when in the case at hand, more so in the teeth of a B report filed in the counter case on the same allegations, the crime requires to be obliterated. Allowed cost. Great. Yes, next.
Complainant is served unrepresented.
ಅದು ಬರದ್ನಲ್ಲ ಮೇಲೆನೆ ಆಸ್ ಯೂಶುವಲ್ ಅಂತಾನೆ ಹೇಳಿದೆ. ಇವ್ರು ಕಂಪ್ಲೇಂಟ್ ಆಗ್ತಾರೆ ಅಷ್ಟೇ, ಯಾರು ಬರಲ್ಲ ಇಲ್ಲಿ. ಇನ್ನೊಂದು ಉಂಟಾ ನಿಮ್ದು ಸಪರೇಟ್ ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಏನಾದ್ರು ಇದೆಯಾ? ಇಲ್ಲಲ್ಲ, ಇದೆಯಾ? ನಿಮ್ದು ಸಾರಿ, ಎಸ್ ಸರ್. ಇದೇನು ಬೇರೆ
57 and 191A, 191 and 192 mala. Complaint is at annexure page, in page 11 document.
ಆಶೀಶ್ ದವೆ.
Yes.
ರೆಸ್ಪಾಂಡ್ ಕಂಪ್ಲೇಂಟ್ ಯಾರು?
Somoto.
ಇದೆ ಆಶೀಶ್ ದವೆ ಇದೆ ಇಲ್ಲಿ. ರಿಪೋರ್ಟ್ ಆಗಿದೆ. Yes.
But the punishment prescribed is less than 3 years. There is no 173 complaints of BNS. And the allegations also, my lord, post.
ವಾಪಸ್ ಕಳಿಸ್ಬೇಕಾ?
ಇಲ್ಲ ಬೇಡ. On merits also, my lord. On merits also, my lord, the lady was caught stealing something and she was tied to a tree. Then, my lord, the petitioner and other people come and he makes a comment like this. ಸಾರ್ವಜನಿಕವಾಗಿ ಕಟ್ಟಿಹಾಕಿದ ಹೊಡೆದದ್ದನ್ನು ಸಮರ್ಥಿಸಿಕೊಳ್ಳುತ್ತಾ ಸಾರ್ವಜನಿಕರಿಂದ ಇಂಥ ಅಪರಾಧ ಮಾಡಿಸಲು ದುಷ್ಪ್ರೇರಣೆ ಮಾಡಿ ದ್ವೇಷ ಭಾವನೆಯಿಂದ. So only allegation.
The petitioner is before the court. Obrella.
Obre.
Calling in question registration of a crime in crime number 34 of 2025 for the following offences. Madam, page 7 ಅಲ್ಲಿ.
Even state also filed vacating state.
Vacating stay ಹಾಕಿದ್ದೀರಾ? Then we'll vacate the interim order. Yes. Heard so and so. It is the case of the prosecution as it is a suo motu complaint registered on 22/3/2025 that the petitioner makes a statement against a particular lady who was caught committing theft. The people around would catch the lady red-handed and tied her.
The people tied her to
The people are said to have tied her and committed an act of assault. ಅವ್ರ ಮೇಲೆ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ಇಲ್ಲ, ಅವ್ರ ಮೇಲೆ ಏನ್ ಮಾಡಲಿಲ್ಲ.
ಯಾಕೆ
She was tied to the
The
tree.
other case has been registered.
ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದೀರಾ ತಾನೆ?
ಅದಾದ್ಮೇಲೆ ಇವ್ರು ಬಂದು public
ಆಯ್ತಾಯ್ತು.
abatement of offense.
The petitioner, after which makes a statement on the police that they have taken 5 to 6 hours to take action against the people who tied the lady. Tying.
He justified the catching of.
Catching of thief, of course, that's all right. The after 5-6 hours, the petitioner makes a statement that the people were justified in catching hold of the thief, but the police were not justified in coming 5 to 6 hours late to the spot. This became a crime for the aforesaid offences. The crime has sprung on the score of registration of the complaint. The complaint reads as follows. A perusal at the complaint would not indicate any offense, any ingredient of the offense under 191 or 192 of the BNS. 353.
ಇಲ್ಲ, 353 ಇಲ್ಲ. 191, 192 and 57 of the. One 191 is for writing.
146, 147, 148.
Unlawful. Except the statement that is made would not mean that the ingredients of section 191(1) or 192, which deals with unlawful assembly, would be met in the case at hand. Permitting further investigation into the said case would undoubtedly amount to an abuse of the process of the law and result in miscarriage of justice. It would become apposite to refer to the judgment of the apex court in the case of Bhajanlal para 102 Haki, madam. In the light of the offences not, in the light of the allegations not meeting even the iota of ingredients, permitting further investigation is not warranted in the case at hand. Allowed cost.
7.
Respect to the distribution of cake inside the premises where
Cake.
123(1) of Representative People's Act.
ಯಾರ್ ಬರ್ತ್ಡೇ ಇತ್ತು?
ಯಾರ್ ಬರ್ಡೇನೆ ಇರ್ಲಿ, ಎಲೆಕ್ಷನ್ ಟೈಮ್ ಅಲ್ಲಿ ನನ್ನ ಜಾಗದಲ್ಲಿ ಪ್ರಿಮೈಸಸ್ ಒಳಗಡೆ ಮೀಟಿಂಗ್ ಮಾಡ್ತಾ ಕೇಕ್ ಹಂಚಿದ್ದಕ್ಕೆ ದೇ ಹ್ಯಾವ್ ಬುಕ್ಡ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 171(h) ಆಫ್.
ಯಾರು ಬಂದಿದ್ರು?
ಯಾರು ಇಲ್ಲ ಸ್ವಾಮಿ, ಪಾರ್ಟಿ ವರ್ಕರ್ಸ್ ಬರ್ದೆ.
ಫ್ಲೈಯಿಂಗ್ ಸ್ಕ್ವಾಡ್?
ಫ್ಲೈಯಿಂಗ್ ಸ್ಕ್ವಾಡ್.
ಅವ್ರಿಗೂ ಕೇಕ್ ಕೊಟ್ಟಿದ್ರೆ ಆಗ್ತಾ ಇತ್ತು.
ಅವ್ರು ಈಸ್ಕೊಂಡಿಲ್ಲ
ಮತ್ತೆ ಏನ್? Yes, the petitioners are before the court calling in question. ಇಲ್ಲಿ ನನ್ನ ಜಡ್ಮೆಂಟ್ ಕೊಡಿ. ತಂದಿಲ್ವಾ? Why?
Sorry.
ಒಂದು 10 ಬರ್ದಿದ್ದೇವೆ ಇದಕ್ಕೆ. ಎಸ್.
Otherwise also this.
Otherwise
I'm
ಬೇರೆ.
sorry about
Yes,
it, my lords.
The petitioners are before the court calling in question proceedings in CC 1518 of 2019 registered for offences punishable under section 171H of the IPC and 123(1) of the RP Act. Same.
Thumb judgment.
JP Nadda case. Gowda appearing for the petitioner and the learned HCGP for the state. On an incident that happens on 12/4/2019 at around 8 ಕಾಲ್ ಬೆಳಗ್ಗೆನೆ ಕೇಕ್ ಕಟ್ ಮಾಡ್ತಾ ಇದ್ರಿ. At around 8:15 AM, the accused number 1 is said to have burst firecrackers in AM ಅಂತ ಯಾಕೆ ಹಾಕಿದ್ದೀರಾ ಮತ್ತೆ? ಅದು ತಪ್ಪು. Yes. Firecrackers at about 8:15 PM. 8:15 PM, firecrackers in violation of the code of conduct and also had distributed cake in the building premises to the party workers. Therefore, it became an offence under section, therefore it became the ingredients of the offences under section 171H and the 123(1) of the Representation of People's Act. The learned counsel appearing for the petitioner submits that the police, after in the subject petition, the learned counsel appearing for the petitioner submits that the cake is distributed is a fact, but only to the party workers inside a particular premises, and that would not amount to bribery as obtaining under section 171E for it to become an offence, 171B for it to become an offence under 171H of the IPC or 123(1) of the Representation of People's Act. The learned counsel would thus seek quashment of the proceedings. The learned HCGP, on the other hand, would submit that the offence is clearly made out, therefore the... Sorry? See, ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು.
Judgment by oversight.
ಅವ್ರು ಕೊಟ್ಟಿದ್ ನೋಡ್ದೆ ನಾನು, ರೋಹಿತ್ ಕೊಟ್ಟಿದ್ ನೋಡ್ದೆ ನಾನು, ಕೊಡಿ ಇಲ್ಲಿ ಪರವಾಗಿಲ್ಲ. ಓ ಏನ್ ನೀವು ಇಲ್ಲೇ ಇದೆ, ಅದು ಕೊಟ್ಟಿದ್ ನೋಡ್ದೆ. ಎಸ್, ಅವರು ಇಟ್ಕೊಂಡಿದ್ದಾರೆ, ಅವ್ರದೊಂದು ಕೇಸ್ ಇದೆ ಅದಕ್ಕೆ.
ನಾವ್ ಅರ್ಥ ಮಾಡ್ಕೊಬೇಕು ಸಾಹೇಬ್ರಿಗೆ.
ಪರವಾಗಿಲ್ಲ
ಎಲ್ಲಾ ಕಡೆ
ಇಲ್ಲಪ್ಪ, ನಿಮ್ ಕಡೆ ಮಾತ್ರ ಇರೋದು. Yes. So and so. I have given my anxious consideration to submissions made by the respective learned counsel. The afore narrated facts are vehemently opposed on Madi Madam. Per contra, the learned HCGP would vehemently oppose the petition contending. Very bad. The learned HCGP would, however, refute the submissions to the counsel for the petitioner. The four narrated facts are not in dispute. They are, in fact, a matter of record. The issue is whether it would really amount to an offence under section 171H. The interpretation of section 171H or 123(1) need not detain this court for long or delve deep into the matter. This is JP Nadda 1. There is JP Nadda 2.
Course.
171H, so and so. In the light of the interpretation of 171H and what would amount to bribery during an election and the election and the facts obtaining in the case at hand would not meeting even the threshold of the ingredients of 171B or 123(1), permitting further proceedings would become an abuse of the process of the law and result in miscarriage. Allowed cost. Next.
Great.
ಇದು ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ ರೋಹಿತ್ಗೆ, ಇದು ಬೇಡ ಇದು. Yes.
So sorry, man.
ಪರವಾಗಿಲ್ಲ. Yes.
8.
I appear for the respondent, my lords. Lords, a small submission. Lordship.
Small submission? Why are you showing small submission?
Lords, your lordship may kindly
It's still
delete the name
11:30.
of, my lords. It's our petitioner is serving as a MLA, my lords.
Hmm.
So we do not have authorization to take up matters pertaining to MLA and MP, my lords.
Petitioner?
It's an MLA.
ಅದಕ್ಕೆ ಬಂದಿರ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್.
Yes, your lordship. But we do not have authorization to take up matters pertaining.
What should I do now? Issue notice?
Lordship, ಇಲ್ಲ, my lords. Your lordship may kindly delete the name of Sri B.B. Patil.
That's not a problem. Judge sir ಏನಿದೆ?
But this is the case, my lord, where, but the learned special judge, my lord, was pleased to direct investigation, further investigation, additional investigation, and now, my lord, that additional investigation report is also rejected. So fourth round, my lord, investigation is directed.
7A?
Yes, please, my lord.
ಏನ್ ಎಲ್ಲಿ ಸಿಗಾಕೊಂಡ್ರಿ?
My lord, petitioner, my lord, is not the accused, but on the allegation that, my lord, a boy carrying about 25 lakhs, my lord, near the Vidhan Soda, but was caught. Ultimately.
Boy was caught.
Yes.
Whose boy was that?
No, that boy, my lord, carrying 25 lakhs in a bag was caught by the police. So motor case came to be registered against accused number 1. Charge sheet was filed. But after, my lord, filing charge sheet, he filed an application seeking discharge. But that application came to be
So
rejected.
why were you, who is the petitioner?
He is not MLA, but that accused, that the
ಅಲ್ಲಲ್ಲ,
boy,
ನೀವು 2019 ಅಲ್ಲಿ MLA ಆಗಿದ್ರಾ?
ಹೌದು ಅಷ್ಟೇ, ಅದೇ ತಪ್ಪಾಗಿರುತ್ತೆ. He was
ಸರಿ.
minister at that time.
You did not tell me who is the boy.
But a boy, some other person, but who was.
Why is some other boy?
But he was carrying, 25 lakhs and he was
ಅದೇ ಮತ್ತೆ
arrested.
ಸ್ಟೋರಿ ರಿಪೀಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ. ಬಾಯ್ ಯಾರು ಅಂತ ಕೇಳಿದೆ ಅಷ್ಟೇ ನಾನು.
But he claims that, he was working as on contract basis in the office of the present petitioner.
ಅಷ್ಟೇ ಹೇಳ್ಬೇಕಾಯ್ತು.
ಅಷ್ಟೇನೆ case.
ಅವ್ರು 4 ಸರಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ದಂಗೆ 4 ಸರಿ ಅದೇ ಆನ್ಸರ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ. ಈಸ್ ಅ ಬಾಯ್ ಅಂತ.
ಹೌದು, ನಮ್ಗೆ ಟೋಟಲಿ ಅನ್ಕನ್ಸರ್ಡ್.
ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ ಬಿಡಿ ಏನು.
Last time, your lordship was pleased to direct notice to the other side.
I didn't know that BB Patil is not authorized to accept a
But
special
in the
court
meantime,
notice.
what I request your lordship, not if there is possibility of.
7A sir, wait, we'll see. ಅವೆಲ್ಲ
But
ಸ್ಮಾಲ್
notice was already
ಕೇಸಸ್,
ordered.
ಪ್ರೊಟೆಸ್ಟ್ ಎಲ್ಲ ನಡೆಯುತ್ತೆ. Not 7A. Petitioner to
But
serve.
he is not in the name, he is not in the FIR,
ಬೇಕಾಗಿಲ್ಲ.
not in the charge sheet.
Who is not in the charge sheet?
No, present petitioner.
Then where did you come?
But it is not,
ಅಲ್ಲ, you are not in the FIR, not in the charge sheet. ಹೆಂಗ್ ಸಾಧ್ಯ?
but it is an observation, not in the course of the order passed by the learned special judge, saying that, you have placed charge sheet only against accused number 1, not against the present petitioner. That is the, but if your lordship kindly turn to page 15 of the order.
Which is the first investigation conducted and charge sheet filed where you are not accused?
But I am not the accused, not.
Date ಹೇಳಿ ಸರ್, ಯಾವುದು? Which is the first charge sheet?
First charge sheet, that is page 25. But there are.
Date sir.
Date, not I will find out. 29/12/21, no, that is the 8/1/2019.
8/1/2019 first charge sheet.
Yes, page 25. Then.
Not an accused.
Not
Further investigation ordered.
Ordered.
Page
Page 58.
Date of the further investigation.
But page 58, Lord.
Date.
ಬಂದೆ.
ಡೇಟ್ ಅಂತ ಕೇಳಿದ ತಕ್ಷಣ ಲೇಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ.
Yes, Lord. That is 16/6/25.
25.
Yes, Lord.
That is further investigation order.
Yes, Lord.
Second ಆಯ್ತು. Next.
Then, Lord, additional report. That is rejected, Lord, by the impugned order. That is passed, Lord, on 26/5/26. Lord, that is also rejected. Lord, fourth time, Lord, investigation.
Third time, third ಯಾವ್ದು ಬರಲೇ ಇಲ್ಲ.
Third ಆಯ್ತಲ್ಲ.
ಯಾವಾಗ ಆಯ್ತು? Second
investigation, further investigation, additional investigation, and that is rejected, now not further investigation.
Well, that is rejected and by whom?
By the learned special judge. That your lordships will find, on page 17, but it starts, from page 9.
That is rejected by the judge and further investigation is ordered for the fourth time. ಅಷ್ಟೇ ತಾನೆ. Yes. The learned counsel. the petitioner to serve on, who is authorized to take?
Arbati.
Learned Counsel Venkatesh Arbatti is directed to accept notice for the respondent Lokayukta petitioner to serve set of papers upon the council forthwith list the matter on 3rd in the fresh
But
matter.
there is some urgency in the matter.
ಯಾಕೆ ಎಲೆಕ್ಷನ್ ಆಗೋಗಿದೆಯಲ್ಲ,
ಅಲ್ಲ ಎಲೆಕ್ಷನ್ ಅಲ್ಲಿ
ರಾಜ್ಯಸಭಾನು ಆಯ್ತು, ಇನ್ನೇನ್ ಬೇಕು?
ಕ್ಯಾಬಿನೆಟ್ ಎಕ್ಸ್ಪೆನ್ಷನ್ ಇದೆ ಅಂತ
ಓ
ಪಾಸಿಬಿಲಿಟಿ.
ಹೌದು ಸರ್, ಇದಕ್ಕೆ ಅಡ್ಡ ಬರ್ತಾ ಇದೆಯಾ?
ಬರ್ಬೋದು
ನೋಡೋಣ. 3rd ಇನ್ನು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ 25 lakhs sir.
No, how many times? 3 times already over. Not this 4th round.
So what?
No, indirectly, not they are trying to not implicate. Not my not latest judgment not of the Supreme Court not on the point is if not the after investigation cognizance is taken, then Lord, it becomes the power of the police to investigate under 173(8). But court cannot direct not the
further investigation.
But yes, no, that is the
what sir?
So moto. So moto.
Court, if report is filed before the court, it is open to the court to order further investigation. Accept the report, do it. Yes.
But that is the first round. 2017 Supreme Court note says.
Third
node. Cognizance is taken.
Third noduva. Yes. 3rd fresh matters list. Ivatte copy serve madbidi.
Please tell.
Next.
9.
ಇದೇನು ಎಲ್ಲಿ ಬೈದ್ರೆ?
ಇಲ್ಲ
ಇಲ್ವಾ?
Complainants. Complainants petition.
Complainants petition.
It is connected with serial number 19.
ಆಯ್ತು, 19 ಜೊತೆನೆ ತಗೊಂತೀನಿ. ಪಾಸ್.
10.
Rent recovery case. Complaint last page, rent recovery.
Complaint last page.
Your lordship sees page number 10. Last paragraph goskara idella sune bariyodu.
ಒಂದು ನಿಮಿಷ.
Page number 10. ಮನೆ ಬಿಡಿಸ್ಕೊಡಿ ಪ್ಲಸ್ ರೆಂಟ್ ಕೊಡಿ.
ಒಂದು ನಿಮಿಷ. Page number 10 is your pleading. 10 is interim prayer. ಲಾಸ್ಟ್ ಲೈನ್ ಇನ್ ದಿ ಇಂಟ್ರೆಸ್ಟ್ ಆಫ್ ಜಸ್ಟಿಸ್ ಅಂಡ್ ಈಕ್ವಿಟಿ ಅಂತಿದೆ. ಅದನ್ನ ನೋಡ್ಲಾ?
ಇಲ್ಲ ಬೇಡ.
ಮತ್ತೆ
ಮೇ ಬಿ my lord there is some annexure A my lord. annexure A ನಲ್ಲಿ 3rd page.
annexure A is page 12. ಅದರಲ್ಲಿ ಲಾಸ್ಟ್ ಲೈನ್ ಬರೋದು page 14 ನಲ್ಲಿ.
I'm sorry my lord.
Yes sir.
It's an old file my lord there.
ಅಲ್ಲ ಪರವಾಗಿಲ್ಲ, ನೀವೇ ಹೇಳಿದ್ದು 10 ನಲ್ಲಿ ಲಾಸ್ಟ್ ಲೈನ್ ನೋಡಿ ಅಂತ, ಇನ್ ದಿ ಇಂಟ್ರೆಸ್ಟ್ ಆಫ್ ಜಸ್ಟಿಸ್ ಅಂಡ್ ಈಕ್ವಿಟಿ ಅಂತ ಇದೆ.
Lordship sees my lord the last paragraph. The relief what the gentleman wants from police is ಮನೆ ಹತ್ರ ಇನ್ನು ಬರಬಾರ್ದು ಪ್ಲಸ್ ರೆಂಟ್ ಕೊಡಿಸಬೇಕು.
Appropriate legal actions also requesting provide security for life and so the anti-social act pay arrears of rent. Crux ಅಲ್ಲಿರೋದು.
ರೆಂಟ್ ರಿಕವರಿ ಕಂಪ್ಲೇಂಟ್.
ಈಗಲಾದ್ರೂ ರೆಂಟ್ ಕೊಟ್ಟು ವೆಕೇಟ್ ಮಾಡಿದ್ರೆ ರೆಂಟ್ ಕೊಟ್ಟು ವೆಕೇಟ್ ಮಾಡಿದ್ರೆ ಮುಗೀತು.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರಿದಾರಲ್ಲ, ರವಿರಾಜ್ ಅಂತ ಯಾರಿದ್ದಾರೆ?
ಇದಾರೆ, ಅವ್ರಿಗೆ ಬತ್ತ ಮೋಸ್ಟ್ಲಿ ಖಾಲಿ ಮಾಡಿದ್ದಾನೆ ಈಗ. I think I am instructed to say my lord he has vacated also long ago. At the time when this case happened my lord he was not.
Maybe 2018 na?
ಹೌದು.
Why is it still pending?
It was my lord before the regular bench, then he became my lord MLA.
ಗನ್ಮ್ಯಾನ್ ಕೂಡ ಥ್ರೆಟ್ ಮಾಡಿ.
ಗನ್ಮ್ಯಾನ್
ಗನ್ ಇಟ್ಟು ಥ್ರೆಟ್ ಮಾಡಿದ್ರೆ ಗನ್ಮ್ಯಾನ್ ಥ್ರೆಟ್ ಮಾಡಿದಾನೆ ಮನುಷ್ಯ.
ಓ.
For the owner complaint.
ಅದಕ್ಕೆ ಕ್ರಿಮಿನಲ್ ಲಾ ಫಾರ್ ಸೆಕ್ಯೂರಿಂಗ್ ದಿ ರೆಂಟ್ 506B ಇದೆ.
ಸುಮ್ಮನೆ ಇದೆಲ್ಲ ಸ್ಪೈಸ್ ಅಪ್ ಮಾಡಿ ಹಾಕಿದೆ.
Anyway, heard the learned senior counsel Shyam Sundar appearing for the petitioner. There is no representation on behalf of the respondent. The order sheet would indicate that the respondent has been continuously absent. The matter is of the year 2018, languishing in the court for 8 years. Therefore, as a last chance, list this matter on 3rd in the fresh matters list. In the event there would be no representation on behalf of the respondent, like, orders would be passed on hearing the counsel appearing, senior counsel appearing for the petitioner.
Greatly.
Yes. Interim order subsisting would continue till the disposal of the petition. Huh?
ಮಾಡಿದಾರಂತೆ. That's what I'm expected to say.
ಅದಕ್ಕೆ ಅವ್ರು ಬರ್ತಾನೆ ಇಲ್ಲ. 8 ವರ್ಷ ಆಯ್ತು.
His purpose is served.
ಆಯ್ತು ಸರಿ.
Hearing on IA 11.
Dispensation connected. ಏನಿದು?
This is my lords under the SC ST Act, this.
Atrocities Act.
But sir, this land was acquired for nice project. Yes,
I am aware for the response.
Yes, sir.
But the complaint is filed alleging that the respondents before your lordships were owners of land to the measuring about 2 acres in survey number 86. Their case, my lords, is that in the year 2007, the respondent number 3, that is the finance manager, at the instance of first and second respondent who are the persons managing directors of the company, etc., barged into their land and forcibly evicted them and demolished a particular building. That is their case. In the year 2007, complaint is filed in the year 2017. The complaint is filed on 16/7/2018.
18.
Nearly after about 11 years. But initially, the learned sessions judge directs the deputy commissioner to give a report. And a report is filed. May I request lordships to permit me to read to about 4 lines of that report, which lordships will get it at page 73, annexure G, last few sentences of that report. Lordships may permit me. ತನಿಖಾ ಸಮಯದಲ್ಲಿ ಸಂತ್ರಸ್ತರನ್ನು ವಾಸದ ಬಗ್ಗೆ ವಿಚಾರಿಸಲಾಗಿ ಅವರು ಪ್ರಸ್ತಾಪಿತ ಜಮೀನಲ್ಲಾಗ್ಲಿ ಕೊಡಿಗೆಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಾಗ್ಲಿ ವಾಸ ಇರುವುದಿಲ್ಲವೆಂದು ಸಂತ್ರಸ್ತರು ಹೇಳಿರುತ್ತಾರೆ. ಸದರಿ ಜಮೀನು ಕರ್ನಾಟಕ ರಾಜ್ಯ ಪತ್ರ ಅಂತಿಮ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ 27/10/1998 ಗೆಜೆಟ್ ನಂತೆ ಕೆಐಡಿಬಿಗೆ ಭೂಸ್ವಾಧೀನವಾಗಿರುವುದರಿಂದ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ತದನಂತರ ಕೆಐಡಿಬಿಯಿಂದ ಅನುಮತಿ ಪಡೆದು ನೈಸ್ ಕಂಪನಿಗೆ 2002ನೇ ಇಸ್ವಿಯಲ್ಲಿ ಲೀಸ್ ಅಗ್ರಿಮೆಂಟ್ ಆಗಿರುತ್ತೆ. ಮುಂದುವರೆದು ಹೆಚ್ಚಿನ ತನಿಖೆಗಾಗಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ದೂರ ಸಂವೇದಿ ಅನ್ವಯ ಕೇಂದ್ರ ಕಚೇರಿಗೆ ಪತ್ರ ಬರೆದು ಆಧುನಿಕ ತಂತ್ರಜ್ಞಾನದ ಮುಖಾಂತರ ಅವರ ಬಳಿ ಇರುವ ಲಭ್ಯವಾದ 2004 ಮತ್ತು 2011 ಪ್ರಸ್ತಾಪಿತ ಜಮೀನು ಚಿತ್ರಣವನ್ನು ಸ್ಯಾಟಲೈಟ್ ಇಮೇಜ್ ಪಡೆದು ಪರಿಶೀಲಿಸಲಾಗಿ ಪ್ರಸ್ತಾಪಿತ ಜಮೀನಿನಲ್ಲಿ ಯಾವುದೇ ಕಟ್ಟಡ ಇರುವುದು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ ಎಂಬ ಅಂಶವನ್ನು ತಿಳಿಸುತ್ತಾ ವಾಸ್ತವಾಂಶ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿದೆ. Now, this is the position. In spite of that, learned magistrate, no reasons are assigned, now takes cognizance, directs investigation. 2007 incident, 2017 complaint, land is not acquired in favor of the state government.
Connected matter ಏನು?
Connected matter.
Same,
Lord, she has not taken cognizance.
Connected matter ಏನು ಅಂತ ಹೇಳಿ.
There is a direction to, initially there was another order passed under section 202 that was challenged, but this is the main one.
Which is the main one?
This is what I am now.
4657.
That's
all right. Yes.
For the page number 20 is their prayer.
28.
23 minutes. What they have sought is not the referring the matter to the not of the commissioner of police. That is the order dated not of the.
What happened after this?
Now yet to inquire not to ascertain the truth. Meantime, not they have come up before this court, not and took this.
Refer agilva.
Fact, not referred. Matter has been referred to the not of the commissioner.
What happened to the report?
Not yet to ascertain the not of the truth and not reported back to
what
the
do you
court.
mean yet to ascertain the truth? Investigation ಆಗಿಲ್ವಾ?
ಇನ್ನ ಇಲ್ಲ ಬಿಡ್ತಾನೆ ಇಲ್ಲ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಕ್ಕೆ.
ಅಲ್ಲಿ 156(3) ಮ್ಯಾಟರ್ ರೆಫರ್ ಆಗಿದೆ.
May take page number 38 minutes.
To take cognizance of the alleged offences 156(3).
Of the report of Deputy Commissioner, Bangalore.
ಈಗ what is under challenge is page 38, is it?
Yes.
What is under challenge is page 38?
Yes.
The order of reference?
Yes. Yes, yes.
All right. Yes.
In this petition. Connected petition.
Fact is this, not that, not the fact. What they have done is not the. They have forged not of the
ground as before. Is abuse of the process of the court and quashment of the complaint. That is.
On merits is concerned.
Yes, sir.
May I take note to my objections? Page number not of the 7. 7 is the not of the grant certificate. Not this land has been granted to not of the respondents hearing.
Lord, the grant register, page number 7 is the grant, not of the certificate.
All right.
Certificate.
Hmm.
Not of it's granted to SC/ST. Not of the page number 10 is the not of the Darkast register.
Hmm.
To show not it is the name of the not of the petitioner's respondent's father.
All right.
Not Darkast register. Not 29, not serial number. Not this document has been forged in the not of the government itself.
Government it is forged.
I'll take notes to that also. That
Government has indulged in forgery.
yes,
Allegation.
colluding with these persons.
Aye,
Not the- that is page number 37. Not
Right.
page number 37.
Hmm.
Not last not that.
Hmm.
The same land records were not the forged.
Hmm.
It is not granted to me.
Page 37.
37. 37. Last not the 363 for 81. Not wherein not they have shown not the survey number 86 and all. Not in the grant register not earlier not the original grant register is shown not the my name. Not the Tahsildar not the colluding with some persons. Not see himself not the approached the DC. Not the doubting the grant. Not the kindly the DC has passed the order not that is page number 31. Page number 31 not 33 is the relevant portion. May I read? Official memorandum L&D so and so dated 2/9/1983 was pleased to pass an order granting the land in favor of their father Sri Selvaraju on survey number so and so, new survey number 86/3 Kodigirelli village on the Tahsildar Bangalore North so and so. Next paragraph. I have considered the evidence available, especially those on behalf of the respondents, which goes to substantiate the possibility of grant made in favor of the late Selvaraju. That circumstantial evidence in the form of Darkast, mutation entry, RTC do tend in the way to the that there must be.
This has become final.
Yes, not this is not the.
This has become final.
Yes, I'm on page number 33. Lords, afterwards, my lords, they trespassed into based on this forged document. They trespassed into the land of the respondents hearing. Where these respondents were running small school in the name of SP.
So small school.
Yes.
Amale.
They demolished that school, trespassed into the land, demolished that school, and they disfigured the entire land. It is a SC/ST land.
Ido small school.
Earlier, that demo after demolition which has been not.
Adena small school.
Adralli adannella demolition madidare. Including JCB and all. Now the matter the trial judge perusing the record and as well as order of the DC. Pleased to refer the matter. He has not convicted anybody. Only they have.
Convict Amale.
He has only referred for the inquiry and report. Not feeling heat of that, they come up before this.
Oh, because they are guilty, adike bandidare.
But this is
Ashtena. But
I am also told, subject to what, that this gazette notification, which was subject matter of acquisition, was challenged before this honorable court. I'm just placing it. And also before the honorable Supreme Court. And it was upheld.
A notification date.
Yes.
Challenge ಆಗಿದ್ದು.
I am not file it along with the memo by 2:30.
ಮಾಡಿ.
After serving a copy of that.
ಅದಿದ್ರೆ ಆಯ್ತು.
The investigation at least report
And it is only reference under 156(3).
That's true, my lord, but we have said, my lord, this total thing is not quashment of the complaint, the use of the process.
You first give me that. You have the all the three.
Yeah.
Since it is a serious
Gazette
offense,
correct, sir. Gazette notification, challenge before this court, challenge affirmed by apex court.
Yes.
When was it? When was the order of the apex court?
Lord, this is in the year 2011 itself, much earlier.
Much earlier to the registration of the complaint?
Yes, but much earlier.
We'll see.
I'll place it.
What is that?
12.
ಯಾವ್ದ್ರಲ್ಲಿ?
My application.
Reserval, entry mount and disposal of the petition. ಏನ್ ಅಪ್ಲಿಕೇಶನ್?
Discharge application reject ಆಗಿದೆ.
ಎಲ್ಲದರಲ್ಲೂ?
ಅಲ್ಲ, ಇದು ಒಂದರಲ್ಲಿ ಮಾತ್ರ.
ಬೇರೆದೆಲ್ಲ ಕನೆಕ್ಟ್
ಬೇರೆದ್ರಲ್ಲೆಲ್ಲ ಅವರು ಲಿಮಿಟೇಷನ್ ರೈಸ್ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ನಂದ್ರಲ್ಲಿ 420 ಇರೋದು ಫಸ್ಟ್ ಐ ಹ್ಯಾವ್ ಟು ಆರ್ಗ್ಯೂ ಆನ್ 420.
420 ಲಿಮಿಟೇಷನ್ ಬರಲ್ವಲ್ಲ?
ಅಲ್ಲ, ಅದಕ್ಕೆ ಲಿಮಿಟೇಷನ್ ಬರಲ್ಲ. ಸಪೋಸ್ ಮೈ ಕಂಟೆನ್ಷನ್ ಇಸ್ ಅಕ್ಸೆಪ್ಟೆಡ್, then MMDR ಮತ್ತು ಉಳ್ಕೊಳ್ಳುತ್ತೆ. Then limitation issue will arise. ಅದಕ್ಕೆ ಅದು ಡಿಸೈಡ್, ಆ ಲಿಮಿಟೇಷನ್ ಇಶ್ಯೂ MMDR ಡಿಸೈಡ್ ಆದ್ರೆ
ನನ್ನ ಹತ್ರ ಇರೋದು.
ಆ ನಂತರ ಇದನ್ನ ಕೇಳ್ಬೋದೇನೋ ಅನ್ಸುತ್ತೆ.
ಆಮೇಲೆ ಮಾಡು. Then we'll take it on 10th. Please. 10th, but 17th July. In the same stage, interim order, if any, will continue to the next date of hearing.
Lord, my other two matters were also part of this.
It's a different, my lord. They are saying that, my lord, while getting interim order, my lord, they submitted like that. It's a connected matter. Now, my lord, it's a not connected matter.
Interim order is granted on. Sridhar Prabhu sir. Interim order is on the connection, na?
No. Independently. It is independent, but he wanted this to be connected. I am also supporting his contention. He now wants to oppose me, my lord, because I am supporting him.
Early, 17th, yes. Interim orders, if any, will continue to the next year. Avurdu seri.
Alla, avurdu separate.
Avatte ಮಾಡುವ.
ಅಲ್ಲ, ಒಂದ್ಸರ್ತಿ separate, ಒಂದ್ಸರ್ತಿ.
ಇಲ್ಲ, ಎಲ್ಲಾದ್ರೂ ಒಟ್ಟಿಗೆ ಲಿಮಿಟೇಷನ್.
ಯಾಕೆ ವಾರಿಂಗ್ ಹಸ್ಬೆಂಡ್ ಅಂಡ್ ವೈಫ್ ತರ ಮಾಡ್ತಾ ಇದೀರಾ ನೀವು?
ಅಲ್ಲ,
17 ಕೇಳುವ ಎಲ್ಲ.
ಪ್ಲೀಸ್.
ಈಗ ಜೊತೆಗಿದಾರಾ ಇಲ್ವಾ ಇವರು?
Grateful.
ಈಗ ಸೀರಿಯಲ್ ನಂಬರ್
ಲಿಸ್ಟ್ ಆಗಿದೆ ಅಲ್ವಾ?
ಲಿಸ್ಟ್ ಆಗಿದೆ.
ಹಂಗೆ ಇರ್ಲಿ ಬಿಡಿ.
Yes, 38.2 and that they are there.
Let it be like that.
38.2.
Great. Yes, next. 30.
Number 13.
13 also.
My lord, 13 to 13.5, I had argued on the last occasion. Mr. Harnelli was supposed to reply.
Sir.
Yes,
ಅವರಿಲ್ವಾ?
ಇದಾರೆ.
ಎಂಗೇಜ್ ಮಾಡಿಲ್ವಾ?
ಮಾಡಿದ್ರು.
ಮತ್ತೆ ಹೇಳ್ಬೇಕು ತಾನೆ.
ಅವರು ಎಲ್ಲಾದ್ರೂ ಆದ್ಮೇಲೆ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. ಸೀರಿಯಲ್ ನಂಬರ್ 25 ಆದ್ಮೇಲೆ ಮಾಡ್ತೀನಿ.
ಮುಂದಿನವರು ತಗೊಳ್ಳ?
Had given the synopsis also.
Had given the synopsis also. Last time ಪ್ರತಿ ಕೇಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾವುದು ಡೀಟೇಲ್ ಕೊಡ್ಲಿಲ್ಲ ಅವರು.
ಕೊಟ್ಟಿದ್ದಾರೆ ಲಾಸ್ಟ್ ಟೈಮ್
ಕೊಟ್ಟಿದ್ದಾರೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 25 ದಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ಅದು.
ಅಲ್ಲ 25 I have got nothing to do.
ಅಲ್ಲ 13 ಅಲ್ಲಿ I think each case.
Yes, and he wanted it again. I have asked my colleague to send it to him. He had misplaced in 13.5.
Now it has become a covered matter. Sir, 3ನೇ ತಾರೀಕು ತಗೊಂತೀನಿ. ಅಷ್ಟಲ್ಲಿ ನೋಡು. We'll take it on 3rd. Heard the learned senior counsel Murthy Dinayak appearing for the petitioner. List on and Ashok Harnandi. List the matter on 3rd. In the same stage. Interim orders will continue.
Grateful.
14.
Number 14.
I seek a kind indulgence of 1 week, my lords. I just received the instructions, my lord.
What instruction? Yeah, what is challenge?
Cancellation of bail, where 11 people have been given bail. In predicate offense, there is a bail. In ECIR,
ಆಯ್ತಲ್ಲ ನಿಮ್ಗೆ ಅವ್ರ ಟೈಮ್ ಕೇಳೋದು ನಿಮ್ಗೆ ಒಳ್ಳೇದು.
ಅಲ್ಲ, ಎಷ್ಟು ಸಲ ಈಗ 9ನೇ ಸಲ ತಾವು ನೋಡಿ ಎಷ್ಟು ಸಲ ಟೈಮ್ ಕೇಳಿದ್ದಾರೆ ಅಂತ.
ಎಷ್ಟು ಜನಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಬೇಲ್?
ಎಲ್ಲರಿಗೆ ಎಕ್ಸೆಪ್ಟ್ 1.
ಎಲ್ಲರಿಗೆ ಅಂದ್ರೆ ಎಷ್ಟು ಜನಕ್ಕೆ?
11.
ಇನ್ನು 11ನೇ ಸರಿ ಕೇಳಿಲ್ಲ ಅವರು, 9 ಸರಿ ಮಾತ್ರ ಕೇಳಿದ್ದಾರೆ. ಅವ್ರಿಗೆ ಇನ್ನು 2 ಸರಿಗೆ ಎಂಟೈಟಲ್ಮೆಂಟ್ ಇದೆ.
7 times.
7 ಇದು ಇದೆಲ್ಲ ಯಾಕೆ ಕೇಳಿ? 4 times ಕೇಳ್ತಾರೆ ಅವರು. Yes, madam.
My lords,
What instructions in cancellation of bail? You know, I am very slow in cancellation.
I bow down, my lords. I have.
Then we'll dismiss it.
Number of appearance.
Yen bail?
Please, my lord.
What's the offense?
My lords,
Money laundering.
I don't have the benefit of the file, my lords. That's the only difference.
Why? What's wrong with the order granting bail?
My lords, I don't have the benefit of the file, my lords. That's
Don't have the benefit of?
the file, my lords. That's the only reason.
You come without the file.
My lords, I have filed my memo for appearance.
Where is the file?
My lords,
How can you appear without a file?
It's because the file is.
Take some file and stand. What is this?
My lords, we request a week's accommodation.
No problem, I'll grant, but finally,
Please, I.
place the matter on 3rd in the same stage.
7th.
No, only Fridays. 3rd or 10th, whichever you want.
10.
All right.
Oh, sorry. 7th.
ಅದೇ ನಿಮ್ಗೇನ್ ಸ್ಪೆಷಲ್?
ಅಲ್ಲ, ಗೋವಾಗೆ ಬೇರೆ
ಗೋವಾಗೆ ಹೋಗ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ, ಪೋಸ್ಟ್ ಆಗಿದೆ ಮ್ಯಾಟರ್ಸ್. ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೋಸ್ಟ್ 7th.
No, ಗೋವಾಗೆ ಈ ಟೈಮ್ ಅಲ್ಲಿ ಹೋಗ್ಬಾರ್ದು.
ಅಲ್ಲ, ಮ್ಯಾಟರ್ is posted already. Because 1 to 4th it is Punjab and Haryana, it is posted. But Chandigarh.
Oh, you are all over the country, is it? Sit here and appear on VC. Yes. List the matter on 10th in the same stage. It is made at the request of the council appearing for the petitioner. It is made clear. Huh?
9th, 10th ಅಲ್ಲಿ
ಮತ್ತೆ 10th. No.
10th ಅಲ್ಲಿ
You ask her to appear. No problem. Don't worry.
7th or 8th.
ಏನ ತೊಂದ್ರೆ ಆದ್ರೆ ನಿಮ್ಮನ್ನ ಕರೆಸ್ತೀನಿ. ತೊಂದ್ರೆ ಇಲ್ಲ. Ask her to appear. Anyway, she is also coming with you. ಇಲ್ಲಲ್ಲ. Oh, yes. List the matter on 10th in the fresh matters list. 17th in the fresh matters list. Fresh matters list. At the request of the council appearing for the petitioner, with the council for the petitioner, making it clear that no further adjournment would be granted in the matter, as it is the 7th time an adjournment is being sought by the petitioner.
Much.
15.
Non-compliance ಅಲ್ಲಿ ಇದಾವೆಲ್ಲ.
Objection is not
Complied.
complete.
Learned counsel of the petitioner submits office objections have been complied with, office to verify and not relist the matter for compliance. Yes.
Lord, the order passed by the learned the special judge taking cognizance for offences punishable under section 323, 341, 504, 506 and under section 31 of the Scheduled Caste and Scheduled Tribes Act. But the petitioner belongs to the SC category. Section 3 is bar, my lord. But with regard to certain incident that took place on 3/5/2013, where the complainant was candidate for MLA in that Robertson constituency, KGF. And the petitioner was also belonging to the same party. And there was the exchange of.
I think that a reserved constituency na.
ಹೌದು.
ಮತ್ತೆ ಎಲ್ಲರೂ ಅದನ್ನೇ ಇರ್ಬೇಕು. ಮತ್ತೆ petitioner also belongs, so complainant also
ಅಲ್ಲ
belongs.
ಯಾಕೆ ಅಂತಂದ್ರೆ but now the cognizance is taken for the offense punishable under section 310 of SC/ST Act.
That is old ordinance. 310 ಇಲ್ಲ ಈಗ.
ಅಲ್ಲ
310 is 31 R&S.
Yes, ಅಲ್ಲ ಇಲ್ಲಿ 10 ಅಂತ ಇದೆ.
2015 amendment ಆಗಿದೆ.
13 offense.
13 offense. ಹಂಗ 310. Yes.
So now the offense cognizance is taken for the offense punishable in section so and so. Since the petitioner is also not belonging to the person, SC/ST category.
ಬೇರೆ offense ಇಲ್ವಾ?
There are 3 other, that is 323, 341 and 504 IPC.
Yes, sir.
In respect of petition number 2.
Petition number 2 ಯಾರು sir?
He is the accused number 2. Accused number 1. He is the.
ಒಂದು ನಿಮಿಷ.
Both petition is there for this court. The accused number 1 and 2.
ಒಂದು ನಿಮಿಷ. ಏನ್ ಹೇಳಿದ್ರು? ಕಂಪ್ಲೇಂಟ್ ಇದಾ?
Complaint is page number.
Page 25.
25. 25. The petition accused number, petition number 2, accused number 1 is the belonging to Okaliga caste.
ಆಯ್ತು.
He is the abused the caste of the complainant.
ಎಲ್ಲಿ ಮಾಡಿದ್ರು ಸರ್?
And assaulted the complainant.
Assaulted.
Assaulted also, wound certificate also in the part of the charge sheet.
ಏನ್ wound
In spite
certificate?
of it, the B report is filed.
ಏನ್ wound certificate ಇದೆ?
Reasoning the para number, page number 12, para
Oh,
number
that was
10.
challenged before this court, it is sent back, is it?
Earlier, the cognizance they taken by the B report, the complainant
Oh,
advocate.
that is set aside.
Complainant advocate, the witness examination chief is conducted. That is not settled. The remanded matter, the judge only recorded the sworn statement of the witnesses. The PW 1 to 3 examined, including PW 1. The reasoning before trial court lordship, the page number 9 onwards started, para number 10. Even also the wound certificate also extracted. Wound certificate also extracted. 2 injuries they in the face.
110 na?
Order dated.
Page. Wound certificate ಎಲ್ಲಿದೆ?
ಇದು ಹಾಕಿಲ್ಲ, petition ಅಲ್ಲಿ ಹಾಕಿಲ್ಲ. ನಾನು ಆರ್ಡರ್ ರಿಲೈ ಮಾಡ್ತೀನಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಸ್ ರಿಲೈಡ್ ಸೊ
wound certificate ಎಲ್ಲಿದೆ? ಬೇಕಲ್ಲ?
ಎಂಟೈರ್ ಚಾರ್ಜ್ ಶೀಟ್ ದೇ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್. ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್.
ಆಯ್ತು, ಯಾವ ಎಲೆಕ್ಷನ್ ಟೈಮ್ ಆಯ್ತು?
But allegation is only he pushed. As a result of pushing, allegation is that he suffered heart pain, chest pain.
ನಿಮ್ಮ ಹತ್ರ ಇದೆ wound certificate ಕೊಡಿ.
ಇಲ್ಲ, wound certificate they mentioning that 2 injuries.
ಮೇಡಮ್ ನಿಮ್ಮ ಹತ್ರ ಇದೆ?
ಇಲ್ಲ.
Contusion.
B report has been filed.
Trial court order.
ಮುಕ್ಕು ನುಗ್ಗಲು.
In spite of it, the 3/5/2016, the FIR registered. And for Lordship 6/5/13, the B report is filed. Within 2 days, the B report filed.
ಅದೆಲ್ಲ ಮಾಡ್ತಾರೆ ಅವ್ರು.
But with regard to this case and counter case,
ನೀವು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಹೌದು, ನಾವು
ಅದೇನಾಗಿದೆ?
That they withdrawn the allegation before this court.
matter was settled. But he promised that he will withdraw this complaint.
No, no.
It is at
ಟರ್ಮ್ಸ್ ಆಫ್ ಸೆಟಲ್ಮೆಂಟ್ ಇದೆಯಾ?
No, no, sir. That order is extracted in this.
ಟರ್ಮ್ಸ್
trial
ಆಫ್
court.
ಸೆಟಲ್ಮೆಂಟ್ ಇದೆಯಾ?
Trial court only the order is
ಅದರಲ್ಲಿ even
extracted.
mention ಮಾಡಿಲ್ಲ. Accused number 2 himself.
Para number 14 and 15, Lordship. The trial court is extracted that
ನಿಮ್ಮ
order.
ಮೇಲೆ ಯಾಕೆ ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರಿ?
They only withdraw the allegation.
ವಿಡ್ರಾ ಅಲ್ಲ, ಸೆಟಲ್ಮೆಂಟ್.
It is not settlement, Lordship. That order also they
Why
quoted
did you
in para
withdraw?
number 14 and 15.
Why did you withdraw?
Before the Saman court, the gentleman has made a promise that it was only in the report. He said that we will settle this matter in the company, then that matter.
ಎಲ್ಲಿಯಾದ್ರೂ ಸೆಟಲ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಆಗಿದೆಯಾ? ಯಾವ್ದಾರ ಆರ್ಡರ್ಲಿ, ಯಾವ್ದಾರ ನೀವು ಮೆಮೋಲಿ ಏನಾದ್ರು ಹಾಕಿದ್ದೀರಾ?
ಹೌದು. Page number 15 ಅಲ್ಲಿ ನೋಡ್ಬೋದು ಸರ್. Page number 15 ಅಲ್ಲಿ
ಎಲ್ಲ ಅದು ಪೊಲಿಟಿಕಲ್ ಕಾಮೆಂಟ್ರಿ ಹೇಳ್ದಂಗೆ ಬರೀ ಓರಲ್ಲಿ ಎಲ್ಲ.
At that time, it was only a B report.
Page number.
Then after the settlement of the then he has filed a protest memo.
ಓ, ನಿಮ್ ಸೆಟ್ಲ್ ಆದ ತಕ್ಷಣ ಅಲ್ಲಿ ಪ್ರೊಟೆಸ್ಟ್ ಹಾಕೋದು ಆಬ್ವಿಯಸ್ಲಿ. ಏನ್ ಸರ್?
Para number, page number 15.
ಈಗ 2029 8 ಎಲೆಕ್ಷನ್ ವರ್ಗೂ ನಡೆಸ್ಬೋಣ ಇದ್ನ? ನೆಕ್ಸ್ಟ್ ಎಲೆಕ್ಷನ್ ವರ್ಗೂ ನಡೆಸ್ಬೋಣ ಇದ್ನ?
ಇಲ್ಲ ಸರ್, B report we are
Then B report.
challenging B report.
ಇದೇ ಕೆಲಸ. ಎಸ್.
The reason.
ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್ ಬರಲ್ವಾ?
ಬರಸ್ ಸ್ವಾಮಿ.
ಯಾಕೆ?
Insofar as accused number 1.
ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಯಾರು?
One is Lakshman and he is the belonging to Okkaliga caste.
ಎಸ್ ಸರ್, ಅವ್ರದ್ದು
He
ಹೇಳಿ.
is the abuse of the victim, the complainant.
3110 2013 ಅಂದ್ರೆ ಇದು?
ಹೌದು.
ಯು 10 year ಪ್ಲಾನ್ ಇದು ಅಲ್ಲ, 13 years ಆಯ್ತು. 15 year ಪ್ಲಾನ್.
Initially revision petition they challenge. That is stay by this honorable court. Thereafter the matter sent back to trial court.
We'll close it here. No stay, nothing. Yes. ಎಲ್ಲಿವರೆಗೆ ನಡೆಸಬೇಕು ಅಂತಿದ್ದೀರಾ?
The prima facie is indicate that.
What prima facie?
The accused number 1 abuse in public place.
ಇವ್ರ ಕಂಪ್ಲೇಂಟ್ ನ ರಿವೈವ್ ಮಾಡಕ್ ಹೇಳ್ತೀನಿ. Will direct complaint to be revived. Settlement and close ಆಗಿದೆಯಲ್ಲ, ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದೆ.
Page number 15 is Sami. They extracted before trial court.
Will revive that complaint also. ಎರಡು ನಡೀಲಿ. ಇಲ್ಲಿ ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಹೋಗಿ ಪ್ರೊಟೆಸ್ಟ್ ಪಿಟಿಷನ್
We are not settling. We are not settling.
Whatever.
They only withdraw the allegation before this court. Page number 15, trial court they extracted the order.
Extracted the order.
Page number 15. Criminal petition number 3552 of 16. The 12/9/2009 observed the order. The stated party arrived compromise interviewing the well wisher.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
Page number 15, some trial court order. B report challenging the order. Dismissal order.
Page 15 of the petition na?
ಇಲ್ಲ, separate order ಇವ ಕೊಟ್ಟನ. ನಾನು ಕೊಟ್ಟನ. B report challenging order. Page number 15 ಅಲ್ಲಿ ಇದೆ. Para number 4, that page number 16 ಅಲ್ಲಿ ಇದೆ. The complainant withdraw all the allegation against petitioner.
Parties have arrived at a compromise at the intervention of the well-wisher, mutually settle their disputes, and in terms of the respondent number 2 has withdrawn all the allegations made against the petitioner leading to the prosecution in so and so. When the efforts are carefully appreciated, accused number 1 permitted compound the offense. ಅದ್ರಲ್ಲಿ ಇಬ್ರು ಅದರಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಯಾರು, ನೀವಾ?
Complainant is the accused number 1.
Himself withdraws the allegations, then obviously the set of allegations. ಇದು B report ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರಾ?
B report is rejected.
Is it not unfair on your part when you entered into a compromise saying they will, all the disputes are to be settled, and go and file a protest petition in B report? Is it not unfair? As simple as that.
No, they assaulted me and the.
Why did you enter into a compromise?
No, sir, that they filed false complaint. Also, they withdraw the allegation against
me. Valla arrived at a compromise with the well-wishers that they mutually settled their disputes in terms of the said settlement.
Part of that.
ಒಬ್ಬರದೇ ಅಲ್ಲ.
Case number.
ನಿಮಗೆ ಅಸಾಲ್ಟ್ ಮಾಡಿರೋದು ಗೊತ್ತಿರ್ಲಿಲ್ವಾ ಇದು ಮಾಡ್ಬೇಕಾರೆ? ಏನ್ ಅಸಾಲ್ಟ್ ಮಾಡಿದ್ದಾರೆ?
In face, the two injuries they injured.
ಏನಾಗಿದೆ? ಎಲ್ಲಿದೆ ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡಿ.
One certificate charge sheet.
ಎಲ್ಲ ಎಲೆಕ್ಷನ್ ಟೈಮ್ ಅಲ್ಲಿ ಬ್ಲೋಯಿಂಗ್ ಎವ್ರಿಥಿಂಗ್ ಔಟ್ ಆಫ್ ಪ್ರಪೋರ್ಷನ್.
Allegation is not only petitioner pushed.
ಆಯ್ತು, ಎಲ್ಲಿ ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್? ನೀವು ಇಲ್ಲ, ಇವರು ಇಲ್ಲ, ಯಾರು ಇಲ್ಲ.
ಇಲ್ಲ, ಅಲ್ಲಿ ನುಗ್ಲಾಗಿದೆ.
ಎಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ ಈಗ. ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಲ್ಲ, ಪೇಪರ್ಸ್ ಇಲ್ಲ, ಡೇಟ್ಸ್ ಇಲ್ಲ, ಇವೆಂಟ್ಸ್ ಇಲ್ಲ.
I requested my.
That is why matters are pending like this.
On page number 13, they extracted the own certificate also.
2013 in the 2026 ವರ್ಗೂ it is pending.
Very same order, own certificate also extracted.
ಎಲ್ಲಿದೆ?
Page number 13 ಅಲ್ಲಿ ಇದೆ. Very same order. The trial court extracted same own certificate. Page number 13.
He had sustained simple injuries.
Page number 13. Medical records indicate that sustained two injuries simple in nature, injured mentioned below.
Get the papers.
Please, madam.
Atrocities Act against
Accused number 1.
whoever it is. Accused number 1 will remain. Assault will see. Third, yes. ನೀವು ಡೇಟ್ಸ್ ಅಂಡ್ ಇವೆಂಟ್ಸ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಎಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾ ಹೋಗ್ತೀನಿ. ಎಲ್ಲದರಲ್ಲೂ ಅಷ್ಟೇ. 10 ವರ್ಷ ಪೆಂಡಿಂಗ್ ಇದಾವೆಲ್ಲ. ನೆಕ್ಸ್ಟ್. ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಸರ್.
16.
ಅರ್ಬಟ್ಟಿ ಅವ್ರೆ, ಇನ್ನೊಂದ್ರಲ್ಲಿ ಯಾವ್ದೋ ನೋಟಿಸ್ ತೊಗೊಳಕ್ ಹೇಳಿದೀನಿ ನಿಮ್ಗೆ. ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ ಸಮಥಿಂಗ್ ಕಾಪಿ ಕೊಡಕ್ ಹೇಳಿದೀನಿ. ಎಸ್.
Lord, the private complaint has been filed alleging disproportionate assets. And when the complaint was filed at page 100, time cognizance is taken, cognizance is not taken, my lord. Last time I did not correct.
Cognizance is not taken.
Cognizance is not taken. This is the order referring it for investigation. The first order, my lord.
But the interim order is granted on the ground that sanction is not required.
Sanction is not
Sanction to refer the matter for investigation ಬೇಕೇ ಆಗಿಲ್ಲ.
Lord, that initially, when he filed the complaint, he said, I will produce it along with the sanction on the basis of this Ayyappa's case, my lord, where the.
That is still pending.
Yeah.
ಇನ್ನೂ ಡಿಸೈಡ್ ಆಗಿಲ್ಲ.
ಅದೇ ಆಗಿಲ್ಲ. ಅದರಲ್ಲಿ at page 100, he himself withdrew the complaint saying that I will represent it along with the sanction. Then, my lord, afterwards, he did not produce the sanction. Then the court passed an order saying that you keep the complaint pending, then let him take a sanction. Now, you also decide whether sanction is required or not. Now, the lower court holds that the sanction is not required under 197 because he is no longer in office.
197 ಸ್ಟೇಜೇ ಬಂದಿಲ್ವಲ್ಲ ಇನ್ನು.
197 ಇದರಲ್ಲಿ the remand was on the ground that he should redo it, reconsider the issue of sanction. Now he has given a finding that sanction is not required. And secondly,
no, one moment, sir. Private complaint.
Private complaint.
Private complaint is referred to investigation.
Yes.
The ground is at the time of reference sanction is required.
Yes.
Is that the ground?
That is also ground. That is the ground on which he withdrew the first complaint. That is why kindly see page 100. That is not kindly see page 100. He said, I will represent it along with sanction.
Who is the complainant?
Served unrepresented. And secondly, my lord, kindly see section 175(4) also. Now the process.
PNSS.
Now he will have to, my lord, now when he receives the report, then he will have to give opportunity to the public.
No, that is, that if I send it back now.
There are 2 points.
ಈಗ ಅದಕ್ಕೆ ಸ್ಯಾಂಕ್ಷನ್ ಬೇಕಾಗಿಲ್ಲ.
But
for 197 will not become applicable now at all because it's not yet reached the stage of cognizance.
But the court has earlier remanded the matter.
All misconception. Because 197 comes only when cognizance is to be taken. That stage has not come.
19
For
also-
reference under 156(3), no sanction is required.
That view still holds, is not overruled.
I know, it's 2012, it's referred in 2018, ಇನ್ನೂ ಏನಾಗಿಲ್ಲ.
But ಅದೇನು ಇನ್ನು another thing is, he himself says, I'll represent it with sanction.
Yeah,
And
that's the
withdraws
problem.
the complaint.
That is the problem. ಈಗ ಏನಾಗಿದೆ ಈಗ?
ಈಗ the learned judge Lord has passed a detailed order at page referring to all the issues, because kindly see page.
In disproportionate assets,
Disproportionate, page 169. He has given a finding that no sanction is required, and that is why I am referring it for investigation.
Correct ಆಗಿದೆ. Nothing wrong.
No, he says no investigation. Sanction is required at any stage.
At any stage
Not
ಇಲ್ಲ.
at this stage. He doesn't say not
At any stage ಇಲ್ವೇ ಇಲ್ಲ. At the stage of taking cognizance on the report of investigation, sanction is required. Whether he is in office or demitted office does not make any difference.
Now he says that because he has demitted office, sanction is not required.
Lapsing ಇದೆಯಲ್ಲ.
Lapsing also not a, Managipet also says this for the previous period, PCR is of the year 2016.
Sanction is required. Cognizance stage ಅಲ್ಲಿ.
For 197 maybe my lord, if the offences
197 ಗೆ ಅದಕ್ಕೆ ಮುಂಚೆ ಏನ್ ಬೇಕಾಗಿಲ್ಲ.
Your lordship may observe that.
It's only referring for investigation.
That referring for investigation also kindly see, my lord, 175.
170 ಯಾವಾಗ ಆಗಿರೋದು ಇದು? 25
ಅಲ್ಲ, ಈಗ 25 ಅಲ್ಲ ಆಗ್ಯಾವ.
PCR of 2016.
Under 531, no inquiry is pending. He will have to follow the procedure under the new act. Now he cannot refer it for investigation also.
Doubtful for the earlier events which are remitted back now to direct following BNSS.
But kindly see, because the remitted is on the ground that you have to proceed from the stage of receiving the complaint.
Where is the order remitting by this court?
Yes, yes.
Page?
One second.
ಇಲ್ಲ ಇದೆ. Annexure G 151.
167 relevant portion says is remanded to the court to consider the complaint filed by the afresh from the stage of filing of the complaint.
ಆಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರು?
ಆಮೇಲೆ now the present order is passed at 169.
That has taken 5 years from 2020 to 2025.
This order
is of 16.
Is of
No, that is
2020.
2020, sir.
2020.
This is Kunnaur's 2020.
Then the matter came to Bangalore, my lord, to the special court. It was in Shivamogga. This remand order. Thereafter, matter came to Bangalore 21.
ಆಯ್ತು, PCR 38 of 21.
Now under this blood, now because he has to proceed from the stage of filing of the complaint, he has to necessarily follow, even assuming so, he will have to receive the report from the officer superior to him.
That is under 175, sir. That's under BNSS.
Yes, kindly see, my lord, section 531 of the BNSS. 531, nothing is pending. If the case is to be proceeded from the stage of filing of the complaint.
No, it was pending, of course, 2021 in the.
No, but only where inquiry investigation is pending, then only the old act will follow. No, nothing is pending as on this date. No inquiry is pending, no investigation is
This will have wide ramification. It will be difficult to accept. We'll see. Judgment is ಕೊಡಿಲಿ. Judgment ಇದೆಯಾ? We'll answer. List on 3rd. ಕೊಡಿ. ಅಯ್ಯಪ್ಪ ಗೊತ್ತು. No, when proceedings are pending for 4 years, prior, long before the commencement of BNSS, while passing an order, should you consider 175(3) or under the old?
I'll produce it.
That I'll have to answer. I'll answer that. 3rd, yes. Ayyappa, I know. That's still referred and not yet decided.
ಈ ಕೋರ್ಟಿಗೆ ಬರ್ಬೇಕಾದ್ರೆ ಎಲ್ಲ ನಿಮಗೆ ಗೊತ್ತಿರುತ್ತೆ ನಿರ್ಧಾರ
No, that also I myself held in one of the cases, and next week that's it.
I'll produce it on the next.
Yes, yes. ಯಾವುದು ಮೇಡಮ್? Date next week, 3rd.
My lord, interim order may be.
Continue, sir.
Serial number 17, I repeated for petitioner. 17.1 and 17.
ಎಲ್ಲರೂ ಹೇಳಾಯ್ತು, ಆಮೇಲೆ ಹೇಳಿ.
May I pray for an adjournment, my lords?
Police report awaited. Post immediately after service of notice upon the respondent. Interim order subsisting will continue to the next date of hearing. Next.
18.
My lords,
What have you challenged here? Cancel. You sought cancellation of bail?
no.
Then?
The impugned order
Discharge.
is correct. We'll comply with the office objections within a week.
A week's time is granted to comply with the office objections. In the event the stand complied, list on 17th in the fresh matters. Next.
My lords.
19.
Inquire, this is what inquiry report. Yes, sir. 8 and 19. 9 and 9. Yes.
Sorry. But petitioner had filed a complaint on the allegation that he had filed a nomination for the contesting director's post in the sugar factory. Now, my lord, the allegation is the respondents, my lords, have forged his signature and withdrawn the nomination. Then, my lords, the police did not register. I filed a writ petition, direction was issued, FIR was registered and investigation was done.
Oh, you are the complainant?
I am the complainant. Now, my lord, the FSL report secured by the police would indicate that the forgery has been committed. My lords, the learned judge, I filed a protest petition, my lords, without the recording of Sohn's statement. My lord, the order has been passed accepting the B report. That
The report accepted and closed?
Closed.
You are not heard?
My lords, I filed objections, but I had no opportunity of leading the evidence by Sohn's statement. Though the learned judge, my lords, at paragraph 10 says.
Page.
My lords, in page 11 is the impugned order. The relevant portion, my lords, where the FSL report in my favor has been extracted in page 19. The learned judge finds fault with the investigation report, saying that they have not done the investigation properly. Evidence has not been collected. Then the option was for him to order for further investigation instead of not accepting the B report. Paragraph 10, my lord. The impugned order.
Page?
My lords, in page 19, my lords are seeing 19, serial number 19.
27592.
Serial number 19. May I request, my lords, this. The other one, serial number 9.
9 beka, 19 beka?
9 togoli. My lords, in page 19, paragraph 10. The above, the FSL gave a clear opinion. Further, in regard to the handwriting opinion of the accused number 4, expert opinion says no opinion is expressed. When the expert was summoned and sought clarification, expressed not expressed, she submitted a report and given an explanation stating that there is no sufficient characters to put up. Fact of the matter is, there is a report that my signature has been forged. Now, the learned judge would say that police have not recovered the CCTV footages. They have not summoned the other witnesses to examine. And therefore, my lords, the IO is justified in B report. Now, before this, my lord, I had filed the connected matter, expressing doubt over the.
It was a case for further investigation, not acceptance of the B report at all.
If you serve the copy upon me, my lord, I'll file my objections.
39 can be closed.
Huh?
39.
19, my lord.
19,
transfer of investigation, my lord, during the pendency of the investigation.
During pendency, my lords, due to the conduct of,
This can be in the year 2023, they have filed, my lord.
First, we'll answer this, whether it was a case for further investigation or acceptance of the B report.
then my lords, your lordship.
B report could not have been accepted straight away.
Your lordship, remand it back, my lord.
Let's send it back to consider, to hear him, if the necessity is.
No,
to
my lord, he has
further-
already filed this protest petition, my lord. My lord, after filing of the B report, my lord, 3 notices have been sent, my lord.
We'll give one opportunity.
My lord, he has filed his protest petition.
That's all right.
Arguments is.
It is a case for further how can the court record everything that he has not produced, is not produced? If it is not produced, not secured,
I may
case
be
for further
permitted, my lord.
investigation.
I may be permitted.
Signature, the handwriting expert opinion, he says that accused number 1 has not forged this document.
Not in the complaint, my lord, he would say.
ಅಲ್ಲ,
an expert-
FSL not forged ಅಂತ ಎಲ್ಲಿದೆ?
Para 10 only, ma'am.
Para 8. it
FSL
starts.
report and expert says the dispute signature form A was not made by the de facto complainant.
My signature is forced is a fact.
Note that the
What kind of investigation has to be done? Learned judge would find fault. They should have done for further investigation.
So it's a case for further investigation.
But I'll file
Or
my
hearing
objections.
him properly and passing orders.
I'll file my objection. This.
File your objections, no problem.
Let the copy be served.
ಕೊಡ್ತೇನೆ.
ಎರಡರಲ್ಲೂ ಕೊಡಿ.
ಇಲ್ಲ ಒಂದರಲ್ಲಿ ಇದ್ದಾರೆ ಅವರು.
ಅಲ್ಲ 19 may be closed, my lord. Serial number 19.
Close why?
ಅಲ್ಲ
Here
19
I have.
sought for CBI inquiry, my lord. Transfer of
ಇಲ್ಲಿ
investigation.
ಫರ್ದರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ ಆಮೇಲೆ ಸಿಬಿಐ.
ಅಲ್ಲ ಎರಡು ಒಟ್ಟಿಗೆ ಮಾಡೋಣ.
ಅದು ಕ್ಲೋಸ್ ಆಗಿಲ್ಲ ಸರ್. ಯಾಕಂದ್ರೆ my lord, that is on the different complaint. They have given a complaint to the chief secretary of the government. When which has not been considered, my lord, the
I
challenge.
think my
challenge in
friend
this
is very
petition.
eager to get the close 19 matter.
ಕ್ರೈಮ್ ನಂಬರ್ 142 ಎರಡರಲ್ಲೂ ಅದೇನಾ?
ಹೌದು ಸೇಮ್ ಸರ್ ಒಂದು ನಿಮಿಷ.
ಒಂದ್ ನಿಮಿಷ. ಸೇಮ್ ಕಂಪ್ಲೇಂಟ್.
Same complaint.
If I am directing further investigation is that CBI ಯಾಕೆ ಇಲ್ಲಿ?
On the same day lordship may closes.
ಅಷ್ಟೇ ಇವತ್ತು ಒಂದ್ ಬೇಡವಾ?
ಅದು they want to keep, my lord, the litigation allegations survive against me, my lord. Since, my lord, I am expecting the cabinet birth now.
ನೀವ್ ಯಾರು?
ಅಲ್ಲ I am respond number 7, my lord.
ಅದ
Accused number 1 in the crime.
ಇಲ್ಲ ಇಲ್ಲಿ ಎಲ್ಲರೂ ಕ್ಯಾಬಿನೆಟ್ ಗೆ ಬರೋದು.
This writ petition is filed agreed by the non-consideration of the representation by the chief secretary of the government.
I made a request for referring this matter to CBI.
ನೀವು ಮಿನಿಸ್ಟರ್ ಆಗ್ಬೇಕಾ?
ನಾವಲ್ಲ ಅವರಲ್ಲ.
ನನಗೆ ಸಂಬಂಧ.
7 ನೀವಾ?
That is a qualification.
My lord, in the year 2023, they filed this writ petition. My lord. Not single posting memo they have moved. For 2 years, my lord, they have not complied with the office objections. They were very much aware that, my lord, the investigation was under
ಇದು
progress.
ಸಿಬಿಐ ಗೆ ಆಮೇಲೆ ನೋಡೋಣ.
ಅಲ್ಲ, that may be closed, my lord. Unnecessary.
ಯಾಕೆ ತೊಂದರೆ ಇಲ್ಲ. ಅಲ್ಲಿ ಇನ್ನು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಫರ್ದರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕೇಸ್
My lord, that I will file my objections in that case.
ಅವತ್ತೇ ಮಾಡಿ.
ಅಲ್ಲ, this may be closed, my lord.
ಆಯ್ತು ಅವತ್ತೇ.
Both may be connected.
ಅವತ್ತೇ ಮಾಡೋಣ. That
Tag better, sir.
you file your objection, but this I am going to remit it back to the concerned court. This I will close definitely next. Third,
ಆಗ್ಬೋದು. Both may be connected.
both 9 and 19, tag them together, list them both on third.
20.
20, my lord, the allegation is that I have published.
Office objections.
Sorry, my lord. 153, my lord.
Accepting the submission of the council, office objections overruled.
Grateful. 153, my lord, is the news report published. I was not the editor when this newspaper report is published, my lord. I have 3 submissions.
One ನಿಮಿಷ ಶ್ರೀಧರ್.
Sorry.
It's what has happened. Complainant was a MLA, is an MLA.
Oh.
Complainant.
All right.
The situation then, my lords, was a little unclear. It went to the Sessions Court, 499. Sessions Court has taken cognizance in a 499 because the special court was then set up.
ಹೌದು.
Now, of course, it has been moved to the regular magistrate court. My lords, my only worry is, if your lordships look into, ultimately, my lords, the cognizance taken is by the Sessions Court. There was one other matter.
It has to go back to the court of the
Because
magistrate
one
to
other-
take cognizance. ನಾನೇ ಬರ್ದಿದ್ದೀನಿ ಕೊಡಿ.
In fact, no,
that's not my ground
one
also.
matter.
I'm submitting on merits.
One more matter was
One is,
decided
sir, could you-
identical, not your, I don't have your lordships.
I have myself held it. I have sent it
Another
back
thing.
saying
Yes.
Sessions Court could not have taken cognizance. It should have gone before the magistrate.
This was recently, my lords, where it was still.
499, 500, correct.
That's why instead of going into merits. my
ವಾಪಸ್
lords,
ಕಳಿಸ್ಬಿಡೋಣ ಅಲ್ಲಿಗೆ. Let it, from the stage of taking of cognizance, let it be done there. We'll follow this and close it.
In fact, there's one more connected matter that also. but
Yeah, I'll
it's
set,
not listed.
ನಾನು ಒಂದು ಬರ್ದಿದ್ದೇನೆ ಇದನ್ನ. Last time when I was sitting in
I'll
this
check
very
it.
same roster. The petitioner is before the court seeking the following prayer. Heard the learned counsel for the petitioner Sridhar Prabhu and the learned senior counsel Ken Panindra appearing for the respondent complainant. The petitioner, the respondent complainant,
Lords, I am the complainant.
the respondent complainant institutes proceedings before the concerned court for offence punishable under section 499 and 500 of the IPC. On the setting up of the special court, the matter is transferred to the court of session for the purpose of decision of the issue in the list. The court of session takes cognizance of the offence and issues summons to the accused. This is what is called in question in the case at hand. The learned senior counsel for the respondent would submit that the court of session, the matter ought not to have been placed before the court of session, as the learned magistrate had to deal with it as the offence was the one punishable under section 499 and 500 of the IPC. In identical circumstances, the learned senior counsel would submit that the coordinate bench, in terms of its order dated 19th February 2026, has remitted the matter back to the back to the jurisdictional magistrate back to the magistrates court constituted under the special constituted by the very same order constituting the special court of session.
No, back to the regular magistrate.
Regular magistrate na ibran madidare adralli. Anyway, yes.
Here, Lord, because the complainant
same so and so. The coordinate bench has held as follows. Full akpudi, it's only 4 paragraphs. In the light of the said order passed by the coordinate bench, the matter is now remitted back to the concerned court to pass from the stage of answering the complaint stroke taking of cognizance as the case would be ordered according.
Is it relegated to the special court or not?
No, relegated to the court of magistrate, like what the coordinate bench has done. Yes, next.
In fact, there's one more matter, my lords, by A2 regarding the same thing.
Number quote pudi.
It was directed to be logged. I need your lordships.
It was direct.
A number.
Back down. It's by A2. In fact, A1's petition is dismissed.
Third hakana. Third
A1's petition is
Adu
dismissed.
close mad. Yes. Next.
21.
Petition in this case, please. Petition is by a witness who has been examined as PW 44 in a sessions case, please. Plus, his statement under 164 was recorded, course of investigation. In the trial, please, he turns hostile. And the learned judge, plus, in his order at page number 618, please, says that acting under section 340, the registrar of civil court is hereby directed to register the case of perjury against the police officer PW 24 Shivanand Chaudhary. Then there is a petition PW 44 Babu Kapil.
Yes, madam.
I'll take instruction on that.
Interim order ಇದೆ ಹೆಂಗೋ?
Interim order ಇದೆ.
Heard the learned senior counsel Ravi Binayak appearing for the petitioner. Office objections stand overruled. The learned counsel B.V. Vidyalata seeks 2 weeks' time to secure instructions and make submissions. List on 24.
There's one submission, my lords. Writ petition would not be maintainable.
Why?
Lords, the order challenging is under against section 340. Lords, there is 341, you would have to file an appeal.
341 would arise.
340 CRPC.
If there is a finding.
Please.
Perjury.
340.
Please. 341, your lordship may kindly see.
341.
Please.
We have not reached that stage at all, please, Viraj.
1 minute.
Shall I read, please? Appeal. Any person on whose application any court other than a high court has refused to make a complaint under subsection 1 or subsection 2 of section 340 or against whom such a complaint has been made by such court may appeal to the court to which the former court is subordinate within the meaning of subsection 4 of section 149. The complainant can prefer an appeal or the person against whom the proceedings are initiated.
Both of you can file an appeal.
Both of us can file a appeal, please note. Then, and the superior court may thereupon, after notice to the parties concerned, direct withdrawal of the
Complaint itself can be challenged in appeal.
Please.
Complaint itself can be challenged.
Correct. Why are you
Or
here?
have to file an appeal.
Unless I am not a accused in the case, I am not a complainant in the case. I am a witness.
Perjury barode witness.
Applicable only to the witness and the complainant.
Witness also is there, yes.
Witness is not included over here, please.
That's perjury barode witness.
Oh, very good.
Unless it says.
Accused cannot be prosecuted for perjury.
Any interpretation of this?
1 second, please. Page 562. That we read. Plus that we read, please. Further, it is hereby directed to register city civil court to register a case of perjury against 340. Plus, we have not yet reached the stage wherein 340 is registered. It is neither registered, it is only a direction issued to the officer concerned to register a complaint. No registration of the complaint, nor any cognizance of the 340, nor any initiation of any proceeding at all.
We'll see.
We are at the threshold.
Interim order hengo ide.
Interim order is there.
2 weeks.
2 weeks.
Maintainability will answer at the threshold.
Yes, madam.
List the matter on 17th in the fresh matters list. Office objections overruled. Keeping open the question of maintainability. List the matter on 17th. Interim order subsisting will continue till the next date of hearing.
I mentioned, Lord, there are 2 other connected matters. I'll just supply the petition numbers.
Connected matters how? Same accused?
Same accused.
Same proceedings?
Same proceedings.
Kodi.
Different accused.
Copy Munchana Vidulata madam.
It's already, we'll supply a copy.
And even to Rahul, yes.
Please, please.
Admission 22.
Appeal by the complainant under 138.
For the respondent.
There was a conviction order. In the appeal, there has been an acquittal. There is an IA for leave to appeal, my lords. In last time I
Leave to appeal
submitted.
ಬರಲ್ವಲ್ಲ ಇದಕ್ಕೆ?
Leave to appeal ಬೇಕಾಗಿಲ್ಲ.
ಬೇಕಾಗಿಲ್ಲ. With the latest judgment of the apex.
I passed it on, my lords, last occasion.
Yes, yes. 1320.
Lords?
1320. ಅದೇ ಅಲ್ವಾ? ನಾಗರತ್ನ ಮೇಡಮ್.
Now, it's on merit. Now, the court below, in the appellate court takes up a defense, which it was not the case of the accused, says you have not established that you had the means to fund him.
Oh, you are on the means now.
That's how the acquittal comes about.
What's the amount?
25 lakhs.
25 lakhs. ನಿಮ್ಮ ಹತ್ರ ಇರ್ಲಿಲ್ವಾ?
That we have produced receipts to show, my lord, that I had mortgaged jewelry and passed on. And that is not even the defense, my lords. That can't be a defense. Signature is accepted. Then the defense taken below the
signature is accepted.
Signature is
Instrument
accepted.
is accepted.
He sets up a plea saying that the check was lost in 2018. I had given a complaint to the bank. He produces a document. Bank man, we examine the bank officer. Bank officer says
evidence ಆಯ್ತಾ?
Evidence agi he was convicted. In the appellate court, my lords,
appellate court reverses it.
Appellate court reverses it and says you have to establish that you had the means. That runs contrary to all settled positions.
My lord, that is the defense which you have taken before the sessions court, my lord. My lords, once the acquittal order is passed, my lord, the presumption of the innocence gets reinforced, my lords.
Absolutely no problem. That is not,
My lords, the allegation is
Panindra
this.
sir is not on that.
Allegation is this, my lords, they have advanced 25 lakhs rupees, my lords. No loan agreement, my lord, no promissory notes, my lord, no receipt.
Check ಯಾಕ್ ಕೊಟ್ರಿ?
Check is lost, my lords, in our MLA office, my lords.
What
That
did
is
you,
our
did you
contention which
complain
are
about
taken.
loss of check?
Yes, my lords, they have complained before the
Where?
bank, my lords.
ಯಾವತ್ತು?
Bank
Where is the communication?
Communication is exhibit D1, my lord. Maybe call for the records, my
We'll call for the records.
The
yes.
bank officer says that communication, she says, because they asked, I gave it on a photocopy certified of a letter. And my lords, when I issue a notice, the first thing they could have done is file a police complaint saying that they have misused the check. Nothing
Financial
of that sort.
capacity is also not
No,
proved, my
this
lord.
financial capacity was a ground that was taken before the trial court.
Lords, with great respect.
No, for the first time and before the appellate court you can. I'm not saying that. But court cannot impose itself.
ಇಲ್ಲ, my lords. ನಾವು
My lords,
written
what we
arguments ಎಲ್ಲ we
established-
have
ಹೇಳಿದಿರಾ
taken.
ಎಲ್ಲ?
Yes, my lords.
Anyway,
The two IAs will not survive. my
well,
lords,
sir,
sir.
the application is preferred seeking leave to appeal by the complainant.
What is this?
In the light of the judgment of the apex court in so-and-so 2025 SAC online SC page 1320, 1230, no, 1320.
132.
1320, the leave to appeal, the for application seeking leave to appeal is not necessary to be considered as the apex court holds. Against the acquittal, the complainant has a right to file an appeal. The stay, you know?
Ah, my lords.
Stay not so.
That's why I said.
Yes. So therefore, the application.
Well, that it does not survive.
Application 1 of 2026 is disposed as having become unnecessary. IA 2 of 2026 is disposed as withdrawn. Yes. Registry is directed to secure the entire trial court records by way of telephonic instruction. List on 24th. Yes.
23.
Please. Lord, sir, I'm appealing for the petitioners, Lords. Milords, in this case, Milords, earlier, Milords, complaint came to be filed before the learned JMFC, Milords. Instead of transferring Milords directly, he records the source statement, evidence and all, Milords. After that, he transfers it, Milords. So based on that, Milords, that is my first ground.
Yes, Deepak.
It is properly taken, so cognizance was taken after proper order was passed. It was
No,
filed
if
before the.
it is without jurisdiction.
It was filed in during the COVID situation.
ಅದಕ್ಕೆ ಕೋವಿಡ್ ಅಲ್ಲಿ ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ಬೋದು.
So it was filed in the Ranebel court and it was transferred to the proper court. Cognizance was
Cognizance ತಗೊಂಡ್ರದ್ದು ಯಾರು?
taken in the special court only.
What is the problem, sir?
But Milords, the evidence is recorded, and after that, Milords, almost 2 months, Milords, few hearings have been taken place. Then he transfers it, Milords. So it has-
Any other ground you have?
Milords, my ground is that, Milords, the conduct of the complainant, Milords, he is having such reputation to file false cases, and he has filed against 100 people, Milords, and where we can't recognize who has said anything. And
What's the offense? What's the offense alleged?
Please, Milords. The offense,
354.
They entered into the advocate house and
452.
100 of people in.
ನೀವು ಅಡ್ವೊಕೇಟ್
ಅಲ್ಲ ಸ್ವಾಮಿ petitioner advocate. Practicing Ranebel courts.
ಆಯ್ತು.
He is having a fan club against a certain
Fan
party.
club?
Yes, Milords.
Advocates are fan clubs, huh?
He is that party itself, Milords. He states that he is a Virodi of that certain party.
ಏನಿದೆ ಬೇರೆ ಗ್ರೌಂಡ್ ಏನಿದೆ ಹೇಳಿ. 307 ಹಾಕಿದೆ.
Only the material was that cognizance taken.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿದೆಯಾ? ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿದೆಯಾ?
ಅಲ್ಲ ಸ್ವಾಮಿ PCR it was
Oh,
filed
PCR
and material
ಈಗ
was placed and
cognizance ತಗೊಂಡಿದ್ದಾರಾ?
ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. During that, after summons, issue of summons, they have come before this.
Milords, let them take a fresh source statement, Milords. Then
No,
let
not
them proceed,
necessary. That
Milords.
ground-
Matter may be limited back to the special court.
No, that ground is not. Special court ತಗೊಂಡ್ರದು cognizance. Yes, we'll see.
Please, Milords.
17th.
ಅಲ್ಲ ಸ್ವಾಮಿ ನೆಕ್ಸ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ ನಡೀತಾ ಇಲ್ಲ. ಸ್ಟಾಪ್ ಆಯ್ತು.
ಪರವಾಗಿಲ್ಲ. ಏನು
6 years.
ಭಯಂಕರ offense ಏನಲ್ಲ ಬಿಡಿ ಬನ್ನಿ. Yes. Heavens are not going to fall. Yes.
153 and 505 minutes.
ಎಲ್ಲಿ ಜಡ್ಮೆಂಟ್ ವಾಪಸ್ ಕೊಟ್ರ ಅವರು? ಎಸ್ ಲತೀಫ್.
Yeah, given the citations. But here the video not which was placed with the IO and the entire the contents were not extracted. Only some contents of the speech was delivered in the public.
153, 505.
How? And some parts are extracted in the complaint.
Who is the complainant?
Complainant is
happens
also
to be a party worker. My lords.
Party
He
worker.
was not at all present.
Unrepresented?
No, he's representing. Latif is representing.
Oh, Latif a party.
Yes, tough opponent, my lords.
But there was a direction from this court to secure the antecedent of the petitioner even on the date last.
ಏನು
ಎಲ್ಲ ಏನಿಲ್ಲ, he's an
antecedent
MLA.
ಅಂದ್ರೆ ನಿಮ್ದು 10 ಕೇಸ್ ಇರುತ್ತೆ.
ಹೌದು. After 2023, they have registered. There was not at all a case before that.
Kindly see the complaint allegations. He made specific reference about the two communities and he compared the two communities.
ಯಾವ್ದು antecedents ಅದು?
No.
ಇದೇ crime ಅಲ್ಲ.
This case.
Mansriya, my lords, and aftermath of making that speech, my lord, that's my lordship has held in Suresh case and also in JP
No,
Natta
those cases, there is no specific reference about two community or religion. Here he has provoked one of the communities against another and made specific allegation against.
Can I just read the complaint? ಆ ಥರದ್ದು ಏನೂ ಇಲ್ಲ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ.
ಮಾಡು, ನಿಧಾನಕ್ಕೆ ಮಾಡು. ಎಂಟ್ರಿ ಮಾಡಿದೆಯಲ್ಲ?
ಇದೆ.
Yes. 24th.
Entry mode.
Entry mode would continue. Next, same stage.
25.
This batch of matters, my lord.
This was the one which I heard reserved and then.
Yes, these batch of matters, my lord, with respect to each consignment, my lord, a separate FIR registered or by my lord by way of a private complaint.
The limitation ಹೇಳಿದೆ.
On ground is limitation. Wherever my lord MMDR and forest offences are invoked, only MMDR and forest offences are invoked, then my lord.
ಎಲ್ಲಿ synopsis each case.
Court. Third the copy just now, my lord, on my colleague.
ಇದೆಯಾ? ಅದು ಇವ್ರದ್ದು.
There are 16 cases, my lord. I've clubbed everything. With respect to each one, my lord, I have prepared some. My lords may take up the first two matters, my lord, that will cover all the other 14, my lord. In the first matter, my lord, what is invoked is only MMDR. So insofar as MMDR and forest offense are concerned, punishment was only 2 years. Then, my lord, it is hit by limitation. Then, my lord, that is only with respect to limitation is concerned. In the second matter, my lord, what is invoked against me is the offences under IPC, that is theft and cheating. To invoke against me, my lord, they have connected me to the minor by way of saying, my lord, it's under criminal conspiracy 120B. Now, to invoke 120B, my lord, there is no statement, no independent witness, no agreement also insofar as, my lord, the minor and the transporter is concerned. Because, my lord, the MDPs, my lord, are issued insofar as the name of the minor, not insofar as the transporter is concerned.
Mineral dispatch permit.
Mineral dispatch permit. To connect me to the minor, they say, "Vada sanchu nadasi."
No, this side heard at length. Sumar dina kelidde.
And have heard it, my lord. So, insofar as IPC offences, it's 120B, which connects me to the minor. In everything else, my lord, it is hit by limitation. The third ground, my lord, is there is a decree granted by the competent civil court, which says that, my lord, the petitioner was not involved in the day-to-day affairs of the company. So they cannot mechanically invoke vicarious liability because firm was made.
Where is that civil court?
Yes, in the every petition, my lord, in the
page one petition ಹೇಳಿ.
In the first petition, that is 5265. Lord, that's at Annexure D, page 56, is the GPA which was executed, and thereafter, my lord, the decree, my lord, is
page 56.
Page 56, Annexure D. This is the GPA.
Yes.
And thereafter, the decree granted by the competent civil court, my lord, is at Annexure E, page 87. This is one of the common grounds, my lord, raised across all the 16 petitions. My lord. And the fourth point, my lord, is so far as the trial court, my lord, after by way of made a discharge application, filed a discharge application. I have been discharged, my lord.
Who has been discharged?
The
petitioner.
Yes, in similar offences.
Putting?
With respect to each consignment, my lord, separate offence. So these are other offences, my lord, wherein I was arraigned as an accused. page 51.
This has become final?
Yes, not a challenge. In two petitions. These are, my lord, consignments, my lord, which were not
Again,
challenged.
27th April.
Yeah.
Time is there.
But bring it to your lordship's knowledge.
If that is so, my lord, they can file in the discharge application before the trial court pass an order, each and every documents of the.
Anyway, ಹೇಳಿ.
Of course, of persuasive value.
ಅದು ಬಿಡಿ.
And on the
ಇದು
same
ಯಾವ
ground.
persuasive ಅಲ್ಲ. Anyway.
120B on the same ground, 120B and.
ಕೊಡಿ ನಿಮ್ದೆಲ್ಲ ಹಾಕಿ ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿದಿರಲ್ಲ.
This case, my lord, the first point is the civil court decree, my lord. In that case, my lord, it's a collusive suit. After filing the.
Suit bidi sir, forget about the suit. Now come on, merits here.
Day-to-day affairs, my lord, after that, my lord, he participated, he only.
So that also you come on limitations, sir.
Yes, sir. Limitation, my lord, is a IPC offense and as well as the MMDR Act.
See, bari MMDR iro ಕೇಸ್ಗಳು ಹೋಯ್ತಾ?
No, my lord, because of this is, my lord. We initiated a preliminary inquiry. After that, my lord, came to know that, my lord, completion of the preliminary inquiry, then we came to know that, my lord, they committed an offense.
Oh.
And thereafter.
When did you begin preliminary inquiry?
That is each and.
Alla, when did you begin? The one case ತಗೊಳ್ಳಿ. Criminal petition 5265. When did you begin preliminary inquiry?
Only one case, my lord, in that case.
ಸದ್ಯಕ್ಕೆ ಒಂದೇ ತಗೊಳ್ಳಿ illustration.
Yes, sir. I will give that detail, my lord.
ಏನ್ ಡೀಟೇಲ್ ಹೇಳಿ ಮತ್ತೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಇಲ್ಲ ಇದರಲ್ಲಿ.
5265 ಫೈಲ್ ಇತ್ತು. 5278 ಕಾಮನ್ ಇಂದ ತಗೊಂಡಿದ್ರು, ಅದನ್ನ ಮಾತ್ರ ತಗೊಂಡ್ ಬಂದಿದ್ದೆ.
ನೀವು ಏನು ಇದೆ ಹೇಳಿ.
ಅದಕ್ಕೋಸ್ಕರ.
ಬಿಕಾಸ್ 2 ವರ್ಷದಿಂದ ಕೇಳಿದ್ದೀನಿ ಇದನ್ನ, ಮತ್ತೆ ಕೇಳಿದ್ದೀನಿ, ಮತ್ತೆ ಕೇಳಲ್ಲ.
ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದೆ. ಇದರಲ್ಲಿ 5265 ನಲ್ಲಿ ಅದರ ಡೇಟ್ ನಾನು ಕೊಡ್ತೀನಿ. 469 is applicable, my lord, because of this reason. I will give date, my lord, only the MDR Act. I will give specific date, my lord. It's a 469 is applicable. One moment, kindly see. They are saying that, my lord, is a 468. During the course of preliminary inquiry, my lord, we initiated preliminary inquiry so many cases as per the direction of the Supreme Court. In some of the cases, my lord, they are not at all committed an offense, and we are not filed any private complaint or charge sheet or anything in those cases. When we came to know that, my lord, is a preliminary inquiry, they committed an offense. Then only we filed after knowledge, my lord, then only we filed a criminal complaint. 469, my lord.
ಅದೇ knowledge.
Yes, my lord.
Knowledge bitre, you will say I got it yesterday anta.
Yes, my lord, it's a similar set of facts in a medical case. After the FSL report, my lord, then only they came to know that, my lord, that's they committed an offense. Supreme Court also, my lord, this honorable High Court decision also is there, my lord. I will say that. When the came to the knowledge on that point of time, my lord, they have to it's a limitation will start, not from the date of the initiation. And there are, my lord, more than 300 cases. In the
16 cases.
No, 300 cases. We started a preliminary inquiry. Only 120 cases or 130 cases, my lord, we initiated a proceeding because remaining cases is concerned, my lord, there is no offense at all. That's why, my lord, only after completion of the preliminary inquiry, we came to know that the offense. And in some of the cases, my lord, we filed the FIR, not only the MMDR Act. We started the.
As simple as this. Incident is of the year 2009. No problem. Supreme Court permitted you to initiate and continue proceedings in the year 2015. Correct? To register cases. You take your own sweet time to conduct preliminary inquiry. 2021, you register the complaint, 6 years after the said incident. Now, in cases where MMDR and forest offenses are there, maximum punishment is 2 years. 468 will straight away apply in those cases where you have registered the complaint itself after 6 years, after the apex court gave you permission.
No, well, it's my submission for this aspect. If it is a filed a FIR for the offense punishment 409, 420 and the remaining IPC offense, during the course of investigation, we came to know that, my lord, those offenses not
ಎಲ್ಲಿದೆ
committed.
FIR ಎಲ್ಲಿದೆ?
That's why, my lord.
ಈ ಕೇಸಲ್ಲಿ ಯಾವ FIR ಇಲ್ಲ. Offenses, for example, in is 21 read with 41 and 41A of MMDR. ಆಯ್ತಾ? Forest and ಇದು. If you go to the next case, ಅಲ್ಲಿ 420 ಇದೆ, ಅಲ್ಲಿ will go on merits. So wherever the offense is 2 years, that will go.
Charge sheet is filed only insofar as the MMDR Act. Charge sheet means.
ಅದೇ ಚಾರ್ಜ್ ಶೀಟ್ ಎಲ್ಲೆಲ್ಲಿ MMDR ಆಗಿದೆ ಅಲ್ಲಿ ಹೋಯ್ತದು.
If it is an FIR is there, on that point of time, my lord, it will not go.
See, 420 FIR ಅದೆಲ್ಲ ಇದ್ರೆ, we will
Yes, madam.
consider it separately.
Yes, that's why
Now,
I.
wherever MMDR offense is there and the other offense are there, of the forest will go
Yes,
on limitation.
Now, my lord, they.
Others ಏನ್ ಹೇಳಿ?
Now, my lord, they gave a synopsis and the comparative table, my lord, I will submit.
ಮತ್ತೆ adjournment ಇಲ್ಲ ಸರ್
No,
ಇದ್ರಲ್ಲಿ.
my lord, I will not take any adjournment. I will submit a synopsis, sir. That's all, my lord. In
Right.
all these cases. And if it isn't filed a FIR in this case, 420 or 409, on that point of time, my lord,
420, 409 I will consider. ಅದಕ್ಕೆ limitation ಬರಲ್ಲ.
that's why.
468 ಬರಲ್ಲ ಅದಕ್ಕೆ.
Yes, my lord. If it is there, only the complaint is for MMDR Act. On that point of time, my lord, 468 is also not applicable, my lord. It's a FIR is 468, sorry, 420 and 409.
420, 409 ಇದ್ರೆ 468 ಬರೋದೇ ಇಲ್ಲ ಸರ್.
ಬರೋದೇ ಇಲ್ಲ.
Because they are 7 years.
Yes, my lord.
Yes.
Yeah, ಇದರಲ್ಲಿ FIR ಹಾಕಿದಾರೆ ಅಂತ ಮಾಡಿ ಕಂಪ್ಯಾರಿಟಿವ್ ಟೇಬಲ್ ಮಾಡಿ.
ಆಯ್ತು ಕೊಡಿ.
ಎಲ್ಲದು.
ಆಯ್ತು ಎಲ್ಲದರಲ್ಲೂ ಕೊಡ್ಲಿ ಬಿಡಿ. Not reserved. Yes.
And wherever the IPC offense, my lord, remaining cases, IPC offense is there.
That we'll see. That you have made your submissions.
And as civil court decree, my lord, I have to submit, my lord, they participated in the day-to-day affairs.
At a later point in time it was.
Yes, my lord, they are saying that, my lord, force of
ಈ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರಿಲ್ಲ. ನಿಮ್ದು ಇರ್ಬೇಕು ಸಿನಾಪ್ಸಿಸ್ ಆಲ್ರೆಡಿ ಇಲ್ಲ.
ಮೂರ್ ಜನ ಅಡ್ವೊಕೇಟ್ ಚೇಂಜ್ ಆದ್ರು ಆ ಕಡೆ
ನೀವೇನ್ ಚೇಂಜ್ ಆಗಿಲ್ವಲ್ಲ.
ಮೂರ್ ರೀತಿ ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿದ್ರು, ಅದಕ್ಕೋಸ್ಕರ ಚೇಂಜ್ ಆಗ್ತದೆ.
ಸರಿ ಆಯ್ತು. ಎಸ್ ನೆಕ್ಸ್ಟ್
26.
For the petitioners in this case, the petitioners were the directors of a sugar factory, please note. This is Saubhagya Lakshmi Sugars. The factory availed loan of 232.
Charge sheet is filed.
Charge sheet is also challenged. I filed an application for amendment. That came to be allowed. I have filed a fresh petition also. Plus the company availed a loan of 232.88 crores.
Offense ಏನು?
Plus 420. Non-discharge of the liability. They go to the NCLT, initiate proceedings. NCLT proceedings are closed. Payments are made over there.
Where? Before the NCLT?
Before the NCLT. The entire debt, please, they issue a certificate that it is received in full final satisfaction of the amount that was due. And initially, please note, the complaint was for offense under 406 and 420. And now, please note, they reduce it to only 420 and 406 is deleted, please.
Yeah, Apex Bank complaint.
Apex Bank, please note.
I am the complainant. But now
ಈಗ ಕಂಪ್ಲೀಟ್ ದುಡ್ಡು ಬಂದಿದೆಯಾ?
I'll just take instructions.
The learned senior counsel, Shri Ravi B. Naik, appearing for the petitioner, would submit that the proceedings, the contemporaneous to the registration of the crime proceedings were initiated or pending before the NCLT. Before the NCLT, complete payment has been made to the Apex Bank. Notwithstanding the same, the crime is sought to be pursued by the respondent complainant. The learned counsel appearing for the complainant would seek a week's time to secure instructions and make submissions with regard to the receipt of the entire payment.
Discharge certificates, please.
The learned senior counsel would now join issue to contend that no instruction need be sought at all, as the discharge of the loan certificate is issued by the bank themselves. However, the counsel is given a week's time to secure instructions with regard to the documents produced by way of a memo dated 8/6/2026. Third.
Yes, great.
27.
Bring for the petitioner. Complaint by the flying squad.
Offense?
Offense, my lord, 188 IPCs, along with 79 of JJ Act.
ಕೊಡಿ.
Incident, my lord, on sir,
That is
judgment.
judgment. Enter ಮಾಡಿದ್ಯಾ?
Not to frame charge on things.
We'll direct framing of charges now. What is judgment?
Download ಮಾಡಿ sir.
Download ಮಾಡ್ಬೇಕಾ?
Download ಮಾಡಿದೆ network ಬಂದಿಲ್ಲ.
The petitioner is before the court calling in question registration of,
Sorry.
calling in question proceedings in CC 33038 of 2023 registered for offence punishable under section 79 and 188 of 79 of the Juvenile Justice Act 2015 and 188 of the IPC. The complainant yaru?
Flying squad.
The issue at this junction, the issue revolves around a narrow compass, as the complainant is the flying squad. For an offence to become punishable under section 188, the complaint ought to be registered by the person who has notified the said government order, a public servant who has notified the said government order, and the flying squad is not the one who has done it, and not the one who has done it under as obtaining under section 188 in the case at hand. The issue need not detain this court for long or delve deep into the matter. There are several judgments will quote for the aforesaid reasons allowed quashed.
Bless.
Network ಸರಿ ಹೋದ್ಮೇಲೆ ತಂದ್ಕೊಡಿ ನೋಡೋಣ. Yes.
Okay.
No representation, list on 17th. Next.
29.
Appearing on behalf of
Ken
the
Girish,
petitioners. My lord, a crime is registered for alleged offences of 153A, 506 and 505(2). For a speech, public speech in...
ಅದಲ್ಲ ತಾನೇ ಇದು?
ಇಲ್ಲ.
Gold ಅದಲ್ಲ ತಾನೇ?
ಇಲ್ಲ. It is covered by my lord's judgment.
The petitioner is before the court calling in question the registration of a crime in crime number 32 of 2024 registered for offences punishable under section 153, 504,
Not ಇನ್ನೊಂದ್ಸಲಿ ಮಾಡಲ್ಲ affidavit.
ಏನಾಯ್ತು?
Hate speech ಇದೆ ಮನೋಜ್. Let them file not to.
Hate speech ಬರ್ದಿರೋದು. Yes. ಅವ್ರು ಮಾಡೋದೆಲ್ಲ ಅದೇನೆ. Alleged.
Allegations.
ಅದಕ್ಕೆ ಒಂದು affidavit ಹಾಕಿದ್ರೆ similar.
The so and so. The petitioner heard the learned counsel Girish Bharadwaj appearing for the petitioner. The complainant has remained, though served, has remained unrepresented. Therefore, the counsel of the petitioner and the state are heard. The petitioner is alleged to have made a speech on 5/3/2024 and on 4/3/2024 and complainant is said to have, petitioner is said to have made a speech on 4/3/2024, which becomes the fulcrum of the complaint on 5/3/2024 for the aforequoted offences. The register of aforequoted offences, the complaint then becomes a crime in crime number so and so. The registration of the crime has driven the petitioner to this court in the subject petition. Since the entire issue has now sprung from the complaint, I deem it appropriate to notice the complaint. The complaint reads as follows, page 12 and 13. Whether the subject complaint would become the ingredients of section 153A or 505(2) is considered by this court concerning this very petitioner in on 30th January 20. ಇದೆಲ್ಲ ಚಾಲೆಂಜ್ ಆಗಿಲ್ವಾ? So and so. In the light of the issue standing completely answered despite the vehement opposition of the learned HCGP, I deem it appropriate to follow suit and obliterate the crime against the petitioner. Allowed and quashed. Grateful. Next.
30.
This is also 153A. The station officer received
188
153A.
153 ಜೊತೆಗೆ 188 ಇದೆಯಾ?
295 minutes. Station officer received through WhatsApp, then register a complaint. In fact, the
Respondent idara
ingredients.
served. Yaru flying squad. Who is the complainant?
Complainant is the station officer. He says that I received through WhatsApp and register FIR.
ಇದರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರಿ? ರೆಕಾರ್ಡ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲಿ? Records are there, we'll look at it, we'll take it on third. Third, the learned senior counsel will examine and appearing for the petitioner. Third in the fresh matters list, yes. Interim order will continue to the disposal of the petition, yes, next.
31.
For petitioner's counsel.
ಏನಿದು connected ಇಷ್ಟೊಂದಿದೆ?
Yes, my lord. Two FIRs are registered for the same offense, my lord. Alleged offenses that my lord, during elections. The certain comments have been made, some Twitter post has been
for
done.
in the first matter for the complainant R2. Incident is same, but two others have filed complaints. That's the only thing. They don't deny the incident. Their entire petition, lords, at least government say that,
but that
these people also had indulged in certain things, so balance it. That can't be a
Election manifesto, the exchange of pictures in Twitter. Ultimately, Twitter post has been deleted.
But the video was quite thing, where they show my lords, 3 eggs in a nest, and a fourth egg is.
It's political party against a political party.
Yes,
maybe, but the issue is this:
completely
3 eggs they show with my lords 2 leaders, and the fourth egg is put. The fourth egg hatches and throws out the other 3 eggs. 3 eggs are towards SC, ST, and backward class. The fourth egg is of minority community. That, my lords, whether that attracts, it would attract 153, if not anything.
Bilal Ahmad Kalu.
Lords,
Bilal Ahmad Kalu.
lords, that also, my lords, we are also.
That is again followed in 2024.
Lords, we have the compilation.
All judgments.
We also have the compilation.
Oh, now political party versus political judgments versus judgments. Kodi. Kodi, ಎರಡು kodi.
We already filed along with this.
ಅದೇ ಬೇರೆ ಕಲರ್ ಇದೆ ನಿಮ್ಮ ಹತ್ರ?
Spiral.
ಅದೇ ಸ್ಪೈರಲ್ ಇಲ್ಲ. ಓ, ಕಲರ್ ಬೇರೆ.
ಕಲರ್ ಬೇರೆ.
ಇಷ್ಟೊಂದಿದೆಯಾ?
Let's have given the para numbers. Lords, we can just pass on the propositions. Bilal Ahmad, my lords, which your lordships considered. There they say, my lords, intention is enough. In absence of violence is not a.
Absence of violence is not at all.
Intention is there. That's the only.
Propensity to generate that violence.
But that is the, if your lordship see, more so at the time of election.
Well, only at the time of elections.
Ultimately,
that is the crucial point.
His client succeeded.
No, that is the
education rush exam time ಅಲ್ಲಿ ಇರುತ್ತಲ್ಲ.
Lords, I have given the judgment.
We'll see. ಎಲ್ಲ ನೋಡ್ಕೊಂಡ್ಬಿಟ್ಟು next week ಬರೆಯುವ.
Of course, I understand these are.
I'll tell you, Pranindra. These things that are ನಿಜವಾದ crime ಏನಿದೆ? We have duty to write people, right? ಇದಕ್ಕೆ ವಯ ಕೆಲವೆಲ್ಲ ಹಂಗೆ ಪ್ರೊಟೆಕ್ಷನ್ ಮಾಡ್ತಿದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ಸ್ಟೇ ಇದ್ರೆ ಅದು ನಡೆಯಲ್ಲ. Continued. IO ಎಲ್ಲದರಲ್ಲೂ. IO, UFO until further orders. Yes.
appear for the respond number 2 in this matter, my lords. May request
ಅರುಣ್
for
ಶ್ಯಾಮ್ ಸರ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
request for matter
17th.
to be placed.
ಅವರು ಅದೇ ಕೇಳಕ್ ಬಂದಿದ್ದು. ಹರ್ಡ್ ದಿ ಲ್ಯಾಂಡ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಎಲ್ಲಾದ್ರಲ್ಲೂ ಅರುಣ್ ಶ್ಯಾಮ್ ಅಂತ ಹಾಕಿ ಆಮೇಲೆ 17th IO ಟಿಲ್ ದೆನ್.
33.
33 and 34 ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? Pass over, but 17th both entry mode will continue. Yes.
35.
Yes, Swami. Bail ಕೊಟ್ರೆ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
That has been withdrawn, please.
ಇದ್ಯಾವ 35 ಮಾತ್ರ ಇದೆ, 0.1 ಇಲ್ವಲ್ಲ?
Only one matter, please, your lordship.
Where we have sought for quashment and discharge application having been rejected, we filed this petition on the ground that the ingredients to constitute the offence is lacking, my lords.
Offenses under what?
SC/ST Act, 3(1)R of the SC/ST Act, and 504 of the Indian Penal Code. These are the two offences.
ಎರಡೇ offense.
So we have by and large, my lords, the two main protagonists here would be, my lords, two former MLAs of the same constituency. Now the allegation is
ಈಗ ಎಲ್ಲಿ ಅಬ್ಯೂಸ್ ಮಾಡಿದ್ರಿ?
at the public view only agidya, and whether the presence of the victim was there. These are the 2 points to be seen, my lords. In my respectful submission, as we'll demonstrate from the charge sheet material, the victim was not at all present when the so-called abuses were heard. And the whole allegation is, the president of that particular constituency, my lords, the minister in charge, he was coming to the constituency. Along with him, my lords, I was in the car.
ಓ, ಇದು ಕಾರಲ್ಲಿ ಕಟ್ಔಟ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಅದ ಕಲಬುರ್ಗಿ?
ಅಲ್ಲ, ಕಲಬುರ್ಗಿ ಅಲ್ಲ, ವಿಜಯನಗರ constituency ಅಲ್ಲಿ.
Agri Bommanahalli.
So when he comes there, my lords,
This is my entry model, I guess. Because it bail hotly, Ravi Binayak had appeared, I guess.
Earlier.
Penal council, yes, that is the case. All right, 23.
So when I was traveling with him in the car, my lords, the hoardings that were put there did not reflect my photographs. So according to them, I was,
That began the issue. Attempt to murder, I think, was alleged. 307 was, all that was dropped later.
504 and 3(1)R, these are the two of them. Now, at 2 places it's supposed to have taken place, and from the charge sheet material, both the places we can show, my lords. That one place where they say he abused, nature of abuse is lacking, what the abuse is. The other place, admittedly, victim was not there. His nephew is the one who sets the law in motion 3 days after the incident.
Glorified incident,
Lordship,
attempt to murder, ella.
No, that is all in the FIR stage. In the charge sheet, please, lordship, 307 has been dropped.
Ella dropped, bari R&S.
Insofar as the public view is concerned, please, your lordship, request your lordship, page number 106.
Swami avare, public view. In a public place or a place of public view with an intention to insult.
Certainly, I will
three
point
ingredients should be there.
I will point out.
Cast is ಬೇರೆ ಏನಿಲ್ಲ.
I'll
Cast
point
is
out.
remark with an intention to insult.
Certainly.
To the victim to humiliate him or insult him in public.
That's what, all three I have written. Yes. That Shailesh ಅಂತ ಒಂದಿದೆ ನೋಡಿ, ಅದರಲ್ಲಿ I have written intention to insult should be there.
Compilation.
Swami.
May I read?
And also the note, well, gives the back.
Shailesh Kumar, yes.
From the memo of citations also, the relevant portion we have marked it also, like. So nephew feels aggrieved that his uncle was abused, and that leads to this 3 days.
But ಇದರಲ್ಲಿ under the Atrocities Act, if you see the definition of insult, it is to you and not to the next man.
It's a continuous offense, please, my lord. My lord,
Continuous
when
ನಿಮಗೆ
the-
ಯಾವಾಗ ಮಾಡಿದ್ದಾರೆ ಸರ್?
No, madam, I'll point out, please, my
ಹೇಳಿ.
lord, from the complaint allegation, please. I invite your lordship's attention to page number 106.
ಆಯ್ತು, ಇನ್ವಿಟೇಷನ್ ಆಕ್ಸೆಪ್ಟೆಡ್ ಹೇಳಿ.
Yes, please. Kindly see paragraph number 3. ಮುಂದುವರೆದು
ಎಲ್ಲಿಗೆ ಮುಂದುವರೆದು?
complaint averments I am reading.
Page
106. 106.
Yes, sir.
ಮುಂದುವರೆದು ಎಲ್ಲಿ ಹೋದ ಆ ಸೋ ಅಂಡ್ ಸೋ MLA, ಐ ಆಮ್ ಜಸ್ಟ್ ಸ್ಕಿಪ್ಪಿಂಗ್ ದಟ್ ಅಬ್ಯೂಸಿವ್ ವರ್ಡ್.
ಆಯ್ತು.
ಅಲ್ಲಿ ಸೋ ಅಂಡ್ ಸೋ ಎಂದು ನಮ್ಮ ಮಾಮನಿಗೆ ಬೈದಿದ್ದು, ಮತ್ತೆ ಕೆಲವರು ಇದ್ದರಲ್ಲ ಸೋ ಅಂಡ್ ಸೋ ಇವರು, ಅವನ ಜೊತೆಯಲ್ಲಿ ಇದ್ದವರು ಸಿರಾಜ್ ಶೇಖ್ ಧಿಕ್ಕಾರ ಎಂದು ಕೂಗೋ ಗಂಡಸರು ಎಲ್ಲಾ ನನ್ನ ಹತ್ತಿರ ಸೋ ಅಂಡ್ ಸೋ. ದೀಸ್ ವರ್ಡ್ಸ್ ಆರ್ ಆಲ್ ಹೈಲಿ ಅಬ್ಯೂಸಿವ್. ಐ ಆಮ್ ಜಸ್ಟ್ ಸ್ಕಿಪ್ಪಿಂಗ್ ಆಲ್ ದೋಸ್ ವರ್ಡ್ಸ್ ಪ್ಲೀಸ್. ಆಕಿ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಟೀ ಕುಡ್ಕೊಂಡ್ ಬಿದ್ದಿರೋಳು, ಆಕಿ ಲಮಾಣಿ ಹಾಕಿ
ಸೋ ಅಂಡ್ ಸೋ ಅನ್ಬಿಟ್ಟು ಓದ್ತಾ ಇದ್ದೀರಾ ಮತ್ತೆ?
ಅಲ್ಲಿ ನಾನು ಆ ಪದಗಳು ಓದ್ತಾ ಇಲ್ಲ. ಐ ಆಮ್ ಜಸ್ಟ್ ಸ್ಕಿಪ್ಪಿಂಗ್ ದೋಸ್
ಪದಗಳು ಓದ್ಬೇಡಿ. So and so ಪದಗಳು will give you a so case or a good case ಹೇಳಿ ಸಾಕು.
No, please, it's a good case, please. In the public view, in the presence of hundreds of party workers and the supporters, and that Malad, the accused has abused him in the most abusive, words, and also taking the caste name Lamani Ake.
Right.
No, because these words are very, very, very important. ಲಂಬಾಣಿ ಜಾತಿ ಎತ್ತಿ ಅವಹೇಳನಕಾರಿಯಾಗಿ ಸಾರ್ವಜನಿಕವಾಗಿ ನಮ್ಮ ಮತ್ತು ಸಮಾಜದ ಗೌರವಕ್ಕೆ ಧಕ್ಕೆ ಆಗುವಂತೆ ಅಲ್ಲದೆ ನಮ್ಮ ಕಾರ್ಯಕರ್ತರಿಗೆ ಬೈದನು. ಮುಂದುವರೆದು just reading the contents of the complaint.
You are what?
De facto complainant.
Yes.
I'm the de facto complainant. I'm the nephew of the CW6, please, my lord, who is an ex-MLA, and the accused is an ex-MLA. And no doubt it is an accepted, admitted fact that they are political rivals, no doubt, but they belong to same political party. And that on the previous evening also, please, my lord, he has noticed that certain wordings are erected, wherein his photographs were not found. That was the reason. Now the intention is that, please, my lord, to abuse him in the public view. Not one incident, please. Pursuant to that also, please, my lord.
Continuing cause of action.
Yes. No, pursuant to that, the accused and the complainant and the other persons, they proceeded near the place where the KDP meeting was being conducted. Even in the KDP meeting also, please, your lordship. And this man has abused him in the filthy language. That's the reason the learned trial judge, while dismissing the discharge application, has adverted to all those facts. May take.
Where do I get the order?
Yes, please, your lordship.
Discharge.
I would point out from the relevant order, please, your lordship. May take lordship attention
relevant
to.
Order, relevant para in the order.
Yes, please, your lordship. Page 56. Para 16.
Para?
16, 1-6.
ಇಲ್ಲೇ ಇದೆ.
Yes. Fourth line onwards in para 16.
One moment.
Ink page 56, print page 23.
Yes, sir.
Fourth line. In the aforesaid instance, it is noticed that the first incident has taken place near Ramanna Daba, Railway Gate, Agri Bommanalli. And also it was committed in the presence of party workers. And subsequently, the second incident had taken place when the party workers were welcoming the district in charge minister near Railway Gate. And the last incident had allegedly taken place near the college premises where KDP meeting was being conveyed. Hence, all the incident has taken place at the public place. Now, kindly peruse the next paragraph also, please, your lordship. Para 17, in the middle, on perusal of their statements, it indicates that the abuses being held by accused person by using filthy language against the caste of Bhima Nayak is forthcoming. No doubt, it does not indicate the particular abuses being held by the accused person against the complainant. However, the ingredients indicate of insulting the complainant and also his maternal uncle. Not only that, the CW6 was subjected to this abuse, even the complainant was also abused by the accused, and therefore the contentions which is now being raised by the learned senior counsel does not stand, please, your lordship. Now in the next paragraph also, please, your lordship, in page number 58, from top third line, thereafter On the very next day, that is on 12/8/2023, when the district in charge minister had come to attend a meeting, he was being welcomed by the party workers at 11 a.m. in the morning. It is also noticed that the statement of witnesses consistently indicates that they had welcomed him, and at that time CW6 Bhima Nayak was requested to sit in the back seat of the car in which the district in charge minister was traveling. On noticing the same, the accused got enraged. It was in the presence of CW6 immediately.
So discharge is rejected on the ground that it was,
Yes.
all three ingredients are met, saying it is in the
And
public view,
also,
public place, intention,
and
custody.
video footage is also available. That was also provided to the investigating officer. And there is a RFSL report also to say that it is authentic and continuous. The report is very clear.
Yes,
I
sir.
place reliance on certain judgments also, please.
Kodi,
Your
kodi,
Lordship.
alla kodi. Yes, Chota sir. Gunjan, not Gunjan. Gunjan is 26.
This is 2025 SCC online SC 215. My lords.
215 is that Kurdu.
Yes, my lord. That,
Ah.
in that paragraph 11 may be noticed, my lord, because they use the
That is follow. Where is, you not got Gunjan? 2026.
They use the
That's
word
reported also. 2026 315. Yes.
to the victim. Now here admittedly the
Adu
review
ashte.
says, my lords, it is my uncle who was insulted in my presence. That
Oh,
my
in
respect to
Gunjan's case, the apex court quotes Ritesh Pius, confirms it.
my lords really not public
Yeah,
view.
yes. But in public view is there.
Public view is there, but
Public view is
itself
there.
is not there.
See, public view is there. We'll have to, it now boils down to two factors, whether it is to the victim, custodious, intentional. Ishte. Otherwise, public view, definite, no doubt about it. Yes.
That, my lord, insofar as the complainant is concerned, please, my lord. So in the very complaint contents also, please, my lord, even the son-in-law of the CW6 was also abused. That is also being noticed by the learned trial judge in the impugned order also, please, my lord. And there is sufficient material, please, my lord. Both of them have been subjected to
We'll see,
castiest
we'll
abuses,
see,
please, my lord.
What exactly it is. All to say 3 days later that my uncle was abused. That is the complaint.
All the family
And my
members,
lords, in
including the
fact-
complainant,
in fact,
please, your
when
lordship.
registering this FIR, 11 IPC offences including 305.
That I'm aware, because I was the one who granted.
And subsequently on investigation, only 504.
I still remember in 23, I think Professor Ravi Verma Kumar had appeared and Ravi Binayak later. Yes. Bail rejected. Bail was challenged.
That they withdrew, my lord.
That they withdrew.
That
That they withdrew. Yes.
Synopsis kuda kottidini ನಾನು.
Which has been blown out of proportion.
Correct, but public view is there. Rest of the things we'll see.
List of the ingredients, including the presence of the victim, because the usage of the word is humiliation and insult using a casting.
Correct, to the victim, to the.
Humiliated.
No,
to
if
the
your
person.
lordship would read the contents of the abuse, please, my lord.
Sorry, after 3 days.
The abusive
My
words.
nephew would go to the police station and say 3 days back, they abused man. This
We'll
is the
see.
starting point of the whole.
Not once, on 3 occasions on the same day, please.
Then why 3 days? my lord?
List on 17th at 4 PM. I'll dictate on that.
Oblige.
Yes. Next,
They note, my lords, today.
whatever. Yes.
46.
17th ಹಾಕಿ ಮೇಡಮ್. ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
37.
ಟೈಮ್. ಎಸ್ ಧೀರಜ್ ಏನಿದು?
Senior will argue in this case.
Sorry?
Senior counsel will argue.
ಆಯ್ತು 17th? Third, all right. ಅವತ್ತೇ ಇದೆಯಲ್ಲ ಬೇರೆ. Third. ಎಂಟ್ರಿ ಮಾಡಿಲ್ವಾ? ರೆಡಿ ಮಾಡಿ. Third, yes. Next.
38, 39 also. Third.
38, 39, same.
Interim orders maybe.
We'll continue, sir.
One submission, my lord. One submission. Serial number 25. In all cases, my lord, the IPC offence is there at the time of FIR, and during the filing the charge sheet separate, my lord, for the IPC offence and the private complaint MMDR. In all cases, my lord, the two
IPC offense ಇದ್ರೆ will consider it. Yes.
Two.
ಅದು ಹಾಕಿ ಅದೇನ ಕಂಪ್ಯಾರಿಟಿವ್ ಟೇಬಲ್ ಹಾಕಿ.
Please.
Yes. 40.
40 appear for the respondent, my lords.
Allegation.
40 ಇಷ್ಟೊಂದು ಮ್ಯಾಟರ್ ಇದೆ.
My lords, might I just submit, my lords.
40 there are 8 matters.
My lords, I appear for the sole complainant in all the matters.
ಇವರಿಲ್ವಾ?
Either, my lords.
Either,
My lords,
their senior engaged.
they have engaged senior counsel Lakshmi Iyengar in this matter, my lords. I would want
Heard.
some time, my lords.
But it's all covered, I've already written.
My lords,
No,
it's
no, my
covered,
lords,
it's
there are
covered.
different allegations.
Might I just explain in
Allegations are
2 minutes, my lords? My lords could. My lords, with regarding to accused number 51, my lords had already quashed the proceeding. My lords. My lords had gone on only one aspect in that, saying that in the complaint, as well as the magistrate while taking the cognizance, has gone on the same point, saying that it is verbatim. The word, the entire para is verbatim. That's the only technical point.
So these people have uttered something.
Please, my lord, may I read, my lords?
Entry matter ಇದೆಯಲ್ಲ.
They've used the words called as anti-Hindu and all such kind of things. Anti-Hindu, Karnataka Virudh.
ಏನಾಗೋಯ್ತು ಅದಕ್ಕೆ?
My lords, the thing is like, out of like 53 my lords, only one, as I told, it's already quashed, my lords. The other people like who are there right now, everyone directly they have passed any kind of comments in Facebook, Twitter and all those things.
ಆಯ್ತು, we'll see. No problem.
One more, one date.
ಅದು third.
Please.
Yes. Third finally. ಏನ್ ಎಂಟ್ರಿ ಮಾಡಿಲ್ವಾ ನಿಮ್ಗೆ? ಲಿಸ್ಟ್ ಆನ್ 10th or 17th ಬರಲ್ಲ. ಸುಮ್ಮನೆ ಇರ್ಬೇಕು, ಒಂದು ವಾರ ಅಷ್ಟು ಎಂಟ್ರಿ ಮಾಡಿ ಇರ್ಬೇಕಾದ್ರೆ ಏನು ಗಲಾಟೆ ನಿಮ್ಗೆ? ಏನು ಹೇಳಿ ಬಂದಿದ್ದೀರಾ ಡಿಸ್ಪೋಸ್ ಮಾಡಿಸ್ಕೊಂಡ್ ಬರ್ತೀವಿ ಇವತ್ತು ಅಂತ ಮತ್ತೆ? ಎಸ್, ಇದೆಲ್ಲ ಪಾಲಿಟಿಷಿಯನ್ಸ್ ಕೇಸ್ ಅಲ್ವಾ, ನೀವು ಹೇಳಿದ್ರು ತೊಂದರೆ ಇಲ್ಲ, ಯಾಕಂದ್ರೆ ಆಶ್ವಾಸನೆ ಅಷ್ಟೇ. ಥರ್ಡ್. ಓ ಎಲೆಕ್ಷನ್ ಇದು, ಸರಿ ಆಯ್ತು. ಎಲೆಕ್ಷನ್ ಏನ್ ತೊಂದರೆ ಇಲ್ಲ. ಎಸ್, ಕಂಪ್ಲೇಂಟ್ ಯಾರು ಇದಾರೆ? ಯಾಕೆ ಮಂಜುನಾಥ್ HB ಯಾರು? Heard the learned counsel Bipin Hegde appearing for the petitioner. There is no representation on behalf of the second respondent complainant, at whose behest an application comes to be filed before the concerned court under section 319 of the CRPC, which led the petitioner back into the web of proceedings. ಮುಂಚೆ ಚಾರ್ಜ್ ಶೀಟ್ ಡ್ರಾಪ್ ಮಾಡಿದ್ರಾ? Web of proceedings. In as a last chance, list the matter on 10th. In the event the counsel for the second respondent would not be present, appropriate orders would be passed on hearing the counsel appearing for the petitioner Bipin Hegde. Yes. So interim orders would continue to the next. Yes, next.
42, my lord, page 23 is the complaint filed after 40 days, my lord, of the alleged incidents.
Yeah, what is the alleged incident?
Yes, alleged incidents is, my lord, that ಅಲ್ಲಿ ಸರ್ವೆ ಮಾಡಕ್ ಹೋದಾಗ ಇವರು ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಿದ್ರು ಅಂತ ನಮ್ಮವರು. Then, my lord, the FIR is page 19, my lord, and complaint is
atrocities and
yes, Atrocities Act and, my lord, 189, 191, 352, 115, 118.
Own certificate. Where is the investigation? ಆಗೆ ಇಲ್ವಾ?
ಇಲ್ಲ. Your lordships will see, I also belong to the scheduled caste, my lord, and my children also belong to the same caste. Page 23, your lordships will see that.
No, you forget about the Atrocities Act, other offences.
Yes, other offences, my lord.
One minute.
Yes, sorry.
The crime was registered on 23rd January 2025, and the interim order is granted on immediately thereon 6/2/2025. The state shall place on record any investigation conducted by investigation papers of any investigation conducted till the said date before this court on the next date, 10th. In the meantime, interim order continues. Next.
Wait.
43.
Change your name. Defamation. What happened?
The matter was referred, my lords, on the suggestion of the court and bench. No mediation proceedings has taken place until today. However, my lords, during this period, there are certain events, my lords, that have transpired, my lords, that have pushed the respondent to say that there is no scope of mediation insofar as the petitioner in serial number 43 is concerned. Even during that
Take
period,
it on merits, mediation
Very
ಇಲ್ಲ
well.
ಅಂದ್ರೆ 499, 500. You are the complainant.
Yes.
ಎರಡು ಕೇಸ್ ಇದೆ.
Two accused persons rising out of the same private complaint.
An exception 8, defense.
Is what they project, my lords, but there was a press interview that they conducted after.
We'll see. ಅವ್ರಿಗೆ ಡಿಫೆನ್ಸ್ ಅದು ಒಂದೇ ಅದಕ್ಕೆ ಕೇಳಿದ್ದು. Exception 8. 17th. Entry mode would continue. Next.
Oblige.
44.
My submission may be recorded, my lords.
The learned counsel for the respondent submits 43 eligible. Would submit that talks of mediation have not progressed any further. Therefore, this court may record that there is no mediation and hear the matter on its merit. In that light, list the matter on 17th to be heard on merits.
So.
44.
Intermodal ಎರಡರಲ್ಲ.
Can I just ask a synopsis?
Insulting modesty of a woman, Manoj. Ranya.
Synopsis.
Kindly.
ಅದಕ್ಕ
I have few documents, Manoj, to produce.
No, it's
before the
only
court. On the last
stuff.
after senior submits it.
ಕೊಡಿ.
Kindly see this page.
Manoj, on the last occasion, what was submitted before the court were on two grounds. One was on the ground of dialect, saying that because of dialect, the word came in a different way. And second was submitted.
Because of the dialect, it is not direct.
Yes, Manoj. Not a dialect, my lords. If the ground is that because of dialect, I submitted same thing. Not in the dialect language, if the word had a different meaning, it would have been probably a ground, my lords. Whichever dialect it is, the word that is uttered by the petitioner has the same meaning. Be that as it may, my lords. Another ground what was raised by the petitioners is that in the subject matter of investigation by DRI, the search during the course of search and seizure, the gold was found in those places is what was told. I am producing by way of a memo the search and seizure that was conducted without admitting to what is written here, Manoj, of course, for the defense purpose.
Correct.
I am submitting it, and your lordships may see where the gold was.
No, it was not.
It was not, Manoj. That is one aspect. The second aspect, Manoj, the person who alleged to have stated this, Manoj, is a MLA, a sitting MLA and a leader of opposition. Manoj, stating that not once but twice during the course of the so-called statement before the media. What was the purpose of the statement? He says he wanted to reveal the names of two ministers who were involved in the alleged scam. Not till date the names of those two ministers' names were involved. Just because to settle some political vendetta, somebody else is made a scapegoat, and my lords, not one media channel.
We'll see. Kodias will answer it.
And there are three judgments which I am relying upon. Two of which are your lordships, which I would not trouble.
Yeah, C.T. Ravi.
Rajiv Gowda one. And the other,
C.T. Ravi.
yes, Manoj. That is one aspect, Manoj. And the other one is Allah Baksh Patil, where
Wall's mail.
Yes,
written on the wall.
Yes, Manoj.
With the telephone number.
Yes. And the other
that is 2022.
Yes, 2022 judgment, Manoj. Yes. The other judgment is a judgment rendered by the Madras High Court. In this, Manoj, what happens is a former sitting MLA, where he would retweet a certain post on a Facebook. So the Madras High Court answers, you are a former sitting MLA, you have your own kind of set of followers. When you speak something, you should speak with caution and responsibility. You cannot defame.
This
The complaint is filed.
Last time I held.
Complaint is filed by respondent number 2. Well, it is not about comment about general women class. The day on which this statement was made, the victim or his client was in custody. There was no way she could have heard or not seen the statement made by me.
It is all over, sir.
No, my lord, she was in judicial custody.
Maybe it is all over.
No, but she should. My lord, the requirement of law is that she should have seen or heard.
ಅಲ್ಲಿ ನ್ಯೂಸ್ ಪೇಪರ್ ಬರಲ್ವಾ? ನ್ಯೂಸ್
That's not exactly what affidavit I have filed already.
Newspaper ಬರ್ಬೇಕು ಅಂದಿಲ್ಲ. ಲೇಡೀಸ್ಗೆ ಹೇಳಿದ್ರೆ ಸಾಕೆಲ್ಲ.
ಮತ್ತೆ
I have already filed an affidavit.
In the complaint.
It's insulting for all women, my lords, not only her.
No, if they want to argue and ಹೇಳಕ್ ಬಿಡಿ ಸ್ವಲ್ಪ. My lord, in the complaint there is no statement with reference to the knowledge of the real person. My lord, in the complaint there is no whisper about it. The day in which I make a statement, very next day or 2 days later, my lord's complaint is lost. I can understand, my lords, if I make a statement about a woman.
Okay. This.
My lord, the
or court
entire,
ಒಂದು affidavit file ಮಾಡಿದ್ರೆ ಆಯ್ತು. Then it will stop.
ಹೇಳೋಕೆ
ನೀವು ಅಪಾಲಜಿ ಅವರು ಕೇಳಬೇಕಾಗಿತ್ತು.
But it can come up 2 weeks later, my lords will just.
It's not correct at all. Even that will not wipe away what you have
No,
said.
no.
That's exactly what
If
your
I have to
lordships
be
are
tested
very
on the legal.
In fact, CT Revil, it was, an affidavit was filed.
My lords, I am
Affidavit
aware
of
of that.
apology, even then I did not accept.
My lords, I have read the judgment also. My lords, it can come up of 1 week, so I'll just go.
I'll take it on 17th, not a problem. By then, if wisdom dawns, do something. Otherwise, I will pass an order. Yes. List on 17th, ಇದೇನು ಕೊಟ್ಟಿದ್ದಾರೆ ಎಲ್ಲ ಇರಲಿ. Entry order subsisting would continue. ಇದರಲ್ಲಿ entry order ಇದೆಯಾ?
Interim order.
ನಾನೇ ಕೊಟ್ಟಿರೋದಾ?
By
It was based on,
Pradeep Singh area cyber.
ಸರಿ. I would not have granted.
Correct. Correct, sir. I mean, we heard.
Yes.
Deeply obliged.
Perhaps has the all the ingredients of 354.
79. 509 and 79.
509 also. 79 is 354. Yes. 509 also, yes. Yes, next.
45.
ಇದೇನೋ
ಇದು my lords, in a election, in a Ramnavami function.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
Outrage of religious feelings.
ಆಯ್ತು ಪರವಾಗಿಲ್ಲ. ಇದು ಮಾಮೂಲಿ. Yes. ಇದು 24th.
Ticketing statement.
ಪರವಾಗಿಲ್ಲ. 24th IO. Next.
46.
The loan offense is section 188 of the IPC.
Covered. What do you want?
Kindly seek adjournment. We do not have instruction on this.
17th, yes. Covered. ಆಯ್ತು. ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ?
47.
17th, yes. ಈಗ ಮಿನಿಸ್ಟರ್ ಆಗ್ಬೇಕಾ ನೀವು? ಹೌದಾ? Yes.
47.
We'll take it on 10th. Entry order will continue. Yeah, as a last chance, at the request of the council appearing for the respondent, list on 10th. Next.
47.
Appearing for
Covered.
respondent from Millard. Millard, in serial number 48, Millard, we are yet to receive the petition copy.
Is it 47 or 48?
47.
The 40, in both the cases, Millard, the date may be given, I will argue in.
Right, 17th, both entry order would continue, yes.
Much.
At the request of the council appearing for the respondent as a last, ಏನು offense ಏನು?
That's 190, 153, 353.
Yes. ನಿಮ್ದು ಎಲ್ಲದರಲ್ಲೂ ಅದೇನೆ, but ಇದು ಮಾತ್ರ different.
I understand.
49.
The alleged offenses is 125 of RP Act, my lord. So
Served unrepresented. Judgment
it is covered by my lord's
correct
judgment.
ಕೊಡಿ ನಾನು. Rajesh.
Please.
The petitioner is before the court calling in question so and so. Heard the learned counsel Girish Bharadwaj appearing for the petitioner and the learned counsel Tejesh, HCGP Tejesh. The petitioner gets embroiled in a crime for offences punishable under so and so. Whether this would amount to the ingredients of which are necessary to be present need not, what ingredients are to be present need not detain this for long or delve deep into the matter. This court following the Umesh Reddy, this court following the judgment of the coordinate bench has held as follows. Allowed post next.
Grateful.
50.
The respondent.
ಪಾಸ್ ಓವರ್ ಇಲ್ಲ 10ಕ್ಕೆ ತಗೊಳ್ಳುವ 10th
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್
ಅರ್ಜೆಂಟ್ ಉಂಟಾ?
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಸ್ಟೇ ಇದೆ ಬಟ್
ಅರ್ಜೆಂಟ್ ಯಾಕೆ ಅಂತ, ಅರ್ಜೆನ್ಸಿ ಯಾಕೆ ಏನಿಲ್ಲ ಅಲ್ಲ,
ಮುಗ್ದೋಗ್ಲಿ
ಅಷ್ಟೇ ತಾನೆ, ಮುಗ್ದೋಗುತ್ತೆ ಬಿಡಿ 10ನೇ ತಾರೀಕು. ಎಸ್, ವಿಲ್ ಡಿವೈಡ್ ಇಟ್, ಎಲ್ಲ ಒಂದೇ ದಿನ ಬಂದ್ರೆ ಆಗಲ್ಲ. 10th, ಎಸ್,
ಮಚ್ ಆಫ್ ಇಟ್
that will continue. 51 also entry ಮಾಡಿದೆಯಲ್ಲ ನಿಮ್ ಕೇಸ್ ಅದರಲ್ಲೂ ಇರ್ಲಿ ಬಿಡಿ. ಎಸ್, ಲಿಸ್ಟ್ ಆನ್ 17th. In the light of the interim order subsisting in the companion petition, there shall be an interim order in the case at hand as well. List on 17th, 24th. Yes, next.
52.
My lord, I appear for the respondent number 1 in this case, my lord. My mother is hospitalized, my lord. I could not able to appear before this honorable court. Kindly have this matter on any other day, my lord. And
ಯಾರು
CC number 375 of 2026. 30/12/2000.
CC, ನೀವು appear ಆಗ್ತಿದೆ.
375.
53 charge sheet format, yes, next. 54. ಗೊತ್ತಾಯ್ತು, yes. Entry ಮಾಡಿ ಇದೆಯಲ್ಲ ಇಲ್ವಾ? ಅರ್ಜೆನ್ಸಿ ಉಂಟಾ? ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
Proceedings may be staged.
ಅಲ್ಲಿ ಯಾರು ನೋಡಿ ರೆಸ್ಪಾಂಡ್ ಕೇಳ್ಬಿಟ್ಟು ಮಾಡಿ. ಲಿಸ್ಟ್ ಆನ್ ಕಂಪ್ಲೇನೆಂಟ್ ಅದು. ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್. ಏನ್ ಯಾರು ಇದು ಗೊತ್ತು BNS 353 of BNS. Yes, Yogesh sir. 153.
ನಾನಿದ್ದೀನಿ, ಅವರು ಇದ್ದಾರೆ, ಅಂಜನ್ ಇದ್ದಾನೆ.
ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಗೇನ್ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ.
ಹೇಳ್ಬಿಡಿ ಹಾಗಿದ್ರೆ. ನೋಡೋಣ ಪ್ರೈವೇಟ್ ಹಾಕಿ ಅಂತ ಹೇಳ್ತಾರೆ, ಏನ್ ಮಾಡ್ತಾರೆ ನೋಡಿ.
List on third, the preventive protection subsisting would continue to the next date of hearing. Next.
55.
The state is restrained from filing the charge sheet without the leave of the court.
55.
Initially, the matter was, the complaint was filed, matter was referred, my lord, the 156(3), supposed to be referred under 155.
5 matters yet?
But all the accused different accused. Same crime.
24th, interim order continues. Next.
56.
420, my lords, offense under section 420. My lords, based on forged document, forged GPA, my lords, accused number 1, accused number 2 executes a sale deed in favor of the petitioner.
ನೀವು ಯಾರು?
I am the purchaser of the property.
Stay ಇದೆಯಲ್ಲ?
Stay.
Yes. 17th. Yes. IO. Next.
Stay to extent.
57.
Same 17th. IO.
Appear for respondent number 2.
17th will take.
58.
Appear for this matter.
Same.
Case and counters case, my lord. The two matters.
Interim order may be extended, my lord.
Wherever interim order is there, it will get extended. Don't.
Both the parties have settled the matter, my lord. I paid
settlement
appear for the respondent number.
ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ಲಾ?
To be quashed, my lord, on the ground that it's case and counter case.
ಎಲ್ಲಿದೆ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ ಅಂತ ಇದ್ರೆ
Affidavit to that.
ಮಧ್ಯಾಹ್ನ ಹಾಕಿ ಪಾಸ್ವರ್ಡ್.
Parties are not there, my lord.
ಮತ್ತೆ
we'll file as a joint
ಏನ್
affidavit.
ಕ್ಲೋಸ್ ಮಾಡ್ಲಿ?
Please. My lord,
ಆಮೇಲೆ ಯಾರಾದ್ರೂ ಅಲ್ಲಿ ಮೇಲೆ
my lord,
Please, my lord, we'll file an affidavit.
we'll have it on 10th.
please,
List on 10th to report settlement, comma, if any.
please.
Interim order subsisting will continue to the next date of hearing. Next.
Much obliged.
I appear for
Request for some time, my lord.
24th IO.
Definitely.
Interim order ಇದೆಯಲ್ಲ?
376,
ಓ ಯಾರು 376 ಏನು? ಒಂದ್ ನಿಮಿಷ ವೇಟ್.
2N, my lord.
ಯಾರಿಗೆ? Promise to marry.
I'm the special prosecutor. This is MP MLA.
ಆಯ್ತು ಗೊತ್ತಾಯ್ತು. ಅಲ್ಲ 376 2N ಯಾರ ಮೇಲೆ?
A1 ಮೇಲೆ.
ಇವ್ರು ಯಾರು?
ಇವರು A3, A4, A3.
ಅವ್ರ ಮೇಲೆ?
ಇವ್ರ ಮೇಲೆ is an accomplice, my lord. He has helped him out in the entire process.
ಆಯ್ತು, we'll see. List on heard the learned counsel of the petitioner and learned special prosecutor. Hey, Pradeep?
Yes.
Yes. List the matter on 17th. In the same stage. Yes. Interim order ಹೆಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇದರಲ್ಲಿ?
Interim order ಇದೆ.
Interim order subsisting in any of the cases shall continue to the next date of hearing. Yes, next.
Right.
ಏನ್ 60 ಇಷ್ಟೊಂದಿದೆ?
The batch matter.
13 FIRs registered, my lord.
Farmers protest.
13 FIRs registered, my lord.
Last
307 ಇದೆಯಾ?
307
So,
ಇದೆ.
ಒಂದರಲ್ಲಿ ಮಾತ್ರ ಇದೆ.
No, yeah, everything can be clubbed into one and then one common rule
Only
can be.
grievances, my
ಓ
lord.
ಲಾಸ್ಟ್ ಟೈಮ್ ಮ್ಯಾಟರ್.
Yes, ma'am.
Yes. ಆಯ್ತು, ಮಧ್ಯಾಹ್ನ ಆರ್ಡರ್ ಮಾಡುವ?
ಅದ್ರಲ್ಲಿ
ಎಲ್ಲ ಒಂದೇ ಟ್ರಯಲ್ ನಡೀಲಿ.
Segregate ಮಾಡಿ ಮಾಡಬೇಕಾಗುತ್ತೆ.
Not that ಸುಮ್ನೆ ಎಲ್ಲ
ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದೆ ನಿಮ್ಗೆ.
ಆರ್ ಒಂದು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬೇಕು.
ಇಲ್ಲ 220 ಅಲ್ಲಿ ಎಲ್ಲ ಒಟ್ಟಿಗೆ ನಡೀಲಿ.
That will
Then
be
seek for
separate
discharge
case.
before trial court once then that.
That also I told you last time, seek discharge ಅಂತ.
One incident, my lord, multiple complaints are registered. That is the reason why, my lord.
I had given a table.
We will
disclosing
show
the
how,
incident.
my lord, the same transaction.
Same grounds you urge before the concerned court in discharge. If you don't get discharged, last time will they come back ಅಂತ.
Allegations also vague, my lord.
I will see, yes. List on 10th will pass that order.
Yes. Interim orders.
Will continue. Discharge ಕಳಿಸ್ತೀನಿ ಕೊನೆಗೆ. Yes.
Interim order.
That will continue.
61.
417 breach of marriage.
MPML breach of promise to marry.
This is a complaint of 2014 though.
61 na?
Initially B report came to be filed, my lord. Subsequently warrant case ಆಗಿದೆ.
17th interim order ಇದೆಯಲ್ಲ.
ಹೌದು.
17th IO next.
62.
Same.
63.
17th IO.
54.
17th sir. Interim order will continue.
54.
IO. 24th IO. Yes.
55.
Yes Diksha. Interim order ಇದೆಯಾ?
Interim order.
Yes. 24th IO.
66.
Serious fraud. 24th.
My lords,
No,
I
no.
appear for the respondent in this case, my lord. Kindly
24th,
pass over the, kindly pass over
24th,
the.
yes, next.
67.
Correspondent.
Sir, petitioner, lord.
24th, yes. ನೀವು respondent ga?
Petitioner.
ನೀವು?
For a change.
Yes.
68.
Appearing for the petitioner, your lordship.
68 is 31st July. Yes, next.
69.
For the petition, the respondent, my lords. 138 and petition 69.1.
60?
I approve the petition 69.1 and respondent
138?
138 NA.
138?
NA Act. Conviction section 138 NA.
69. Okay, revision petition. Madam, revision petitions ಎರಡೂನು post them on 17th.
Interim order 69.1.
17th ಅಲ್ಲ 24th ಹಾಕಿರಿ.
There's an interim order 69.1. Wait.
ಆಯ್ತು ಸರ್.
Serial number 72, my lords.
72.
72.
2017 matter. No way. Last time itself I've told you I'm not going to grant adjournment. Nothing doing. If seniors are there, argue. Otherwise I'll hear the respondent and close the case. Last time I warned you that I am not going to grant adjournment in the 2017 matter. No. No. You are also there?
72 I appear for respondent.
74.
72 my lord I appear for
I'm not going to grant time. Period. If you are coming, you are there for the respondent. Who's for the respondent? Then I'll hear and pass outs. Yes.
List 2. List 2. Serial number 12 my lord.
78 I am appearing for the appellant, my lord.
Court officer. Court officer.
What up, sir?
ಎಲ್ಲಿ ಏನು ಅವಶ್ಯ ಏನು
Francis ಕೂಡ ಬೇರೆ
ಕೊಂಡು ಬರ್ಲಿಲ್ಲ.
It's a submission, Millets. Serial number 53, Millets, in list 1. Millets, I'll file a memo for withdrawal, Millets. Charge sheet is filed in that matter, Millets. Charge sheet has been withdrawn.
ಆಗ್ಲೇ ಮಾಡಾಯ್ತು ಕೊಡಿ ಏನೋ ಮೆಮೊ ಕೊಟ್ಬಿಡಿ ಒಳ್ಳೇದು.
Pass on.
ಜಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬಿಡಿ, ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬಿಟ್ಟು ಅದು ಎಸ್ ಅದು ಕರೆದ್ಬಿಡಿ ಫಸ್ಟ್.
Matters pertaining to Dharwad bench being spoken to seal number 1.
All the details we have produced in the registry, my lord, about the existing criminal cases and all those things.
All right, fine. The order ಮಾಡ್ತೀನಿ ಆಮೇಲೆ. Yes. Yes, Gangadhar.
Please, ma'am.
List 1 continued. Preliminary hearing 71.
It's a matter where, my lord, the offence alleged is 189 clause 2, my lord. Then, my lord, 329, 323 and 190. Or since 223 is there, my lord, they should have filed private complaint is one of the grievance, my lord. The other thing is, my lord, they have invoked 144 in the midnight. They did not communicate that 144, my lord, and in the morning that opening ceremony was there of the function.
No, I have, this is that they wanted to do organize an event. DC has passed a promulgation order, communicated to them.
Under 140, it's communicated?
No, not at all.
No, I'll in fact,
Let the records placement.
No, the issue, my lord, now the petition became infectious.
Why?
FIR was registered. Subsequent to investigation, we filed a complaint before the magistrate. Now, magistrate can take a cognizance by issuing notice to them. He may not even take cognizance by
But I have challenged, my lord, the order of 144, which was never communicated to me. That gave rise to, my lord,
want me to answer? I'll answer. There's an interim order, is it?
There's no interim order.
There's only interim protection, my lord, some.
Not to take any coercive.
By the coordinate bench.
But now, so far as 144, my lord, my petition will survive, my lord. Your lordship may kindly hear and dispose it of.
Will, ಅದೇ. Yes. ಮುಂದಿನ ವಾರ? Third.
But my submission is that, my lord, it was not communicated, nor
communicate ಆಗಿರೋದಕ್ಕೆ.
There are communication, what messages between the petitioners and the DC, everything was there. In fact, and the place also, they were told not to do it. Everything is there. Everything is there on.
The record ಇದ್ರೆ ಆಯ್ತು. We'll answer it. If everything is communicated, then there's nothing left. We'll see.
Our instructions, my lord, not communicated.
Kodli. Yes.
Midnight they promulgated and not communicated.
ಆಯ್ತು kodli. Yes. Heard the learned senior counsel Arun Sham appearing for the petitioner. The issue revolves around the promulgation of the order under section 144 of the IPC for the learned additional learned SPP would submit that the records are available of communication of such an order to the petitioner, which the learned senior counsel would dispute. In that light, the records of such communication being made to the petitioner to avoid gathering as obtaining under law shall be placed before the court.
163 BNSS.
BNS side, BNS 160. BNS is 163. Yes, not 144. Yes, next.
72 B group matters.
Yes, sir.
State the facts.
2017 ಇಂದ ಪೆಂಡಿಂಗ್ ಇಟ್ಕೊಂಡು ಯಾಕೆ ಇದು 10 ವರ್ಷ?
ಫಸ್ಟ್ ACB ನಲ್ಲಿ ಇತ್ತು, ಅಲ್ಲಿ FIR ಹಾಕಿದ್ರು. ಅದಾದ್ಮೇಲೆ
ಅಲ್ಲ ACB ಆಸ್ ಅನ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಹೋಗಿದ್ದು 2023 ಅಲ್ಲಿ. 6 ವರ್ಷ ಯಾಕೆ ಪೆಂಡಿಂಗ್ ಇತ್ತು? Yes, start ಮಾಡಿ.
Yes, please, Milad.
Yes, whoever
start. First petition in the first petition.
Senior start ಮಾಡ್ತಾರೆ, ನೀವು ಮಾಡ್ತೀರಾ?
ನೀವು ಮಾಡಿ.
ಆಯ್ತು, ಅವ್ರು ಮುಗಿಸ್ಲಿ ಬಿಡಿ. Yes.
Milad, I shall state the facts in a nutshell.
Yes, sir.
Milad, the lands bearing survey number 12 and 13 of Karnataka.
Is there? Oh, yes, all right.
Milad, the lands bearing survey number 12 and 13 of Kannampalli village, measuring 1 acre 21 guntas and 1 acre 20 guntas. Milad, belong to one Chowda Reddy. That is, Milad, the petitioner in the connected writ petition.
All right.
And my lord, abutting these two survey numbers, there is government land bearing survey number 11, measuring 1 acre 11 guntas.
Government land.
1 acre 19 guntas.
Yes.
Then my lord, in the year 1992-93, the petitioners in the connected petition, Chowda Reddy and his sons, got the land converted for non-agricultural purpose. While converting my land, this government land was also included. And
So you got the government land also converted as if it is your land.
Yeah, yes, because it was, yes, it was abutting. My lord, the petition.
ಅಂದ್ರೆ ಅಬಟ್ ಈಗ ಒಂದು ಪ್ರೈವೇಟ್ ಲ್ಯಾಂಡ್ ಗೆ ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಅಬಟ್ ಆಗಿದ್ರೆ ಅದು ನಿಮ್ದೇ ಅಂತನಾ?
ಅಲ್ಲ, ನಾನು
ನೀವು ಹೇಳ್ತಿರೋದು ನೋಡಿದ್ರೆ ಹಂಗಿದೆ. ನನ್ನ ಲ್ಯಾಂಡ್ ಪಕ್ಕದಲ್ಲಿ ಇತ್ತು, ಅದಕ್ಕೆ ಅದನ್ನು ಕನ್ವರ್ಟ್ ಮಾಡಿಸ್ಬಿಟ್ಟೆ.
I am for the petitioner, commissioner in this. He has been victimized for no fault of him. That's why, my lord, I just
You are the commissioner?
Yes.
Who executed that order?
No, my lord, I never. My lord, I worked in this panchayat, my lord. CMC, my lord, from.
So the perpetrator is in the companion petition.
Yes.
All right. Heli.
My lord, I worked as, my lord, commissioner. My lord, of Chintamani on 22/6/98 to 22/7/2000. Whereas the land was converted, my lord, in the year 1992-93.
Oh, when you were not yet the commissioner?
No, my lord, I was not there.
All right.
And then, my lord, after conversion, my lord, they formed the layout. And that panchayat, my lord, assigned the site numbers.
Government land guno?
Yeah, government land gu ella sersi they assigned. Panchayat, my lord, because at the time of conversion, it was under the jurisdiction of the panchayat, village panchayat. Thereafter, my lord, it was included in the town panchayat. That is, my lord, corporation, Chintamani corporation. Then, my lord, in Chintamani corporation, where, my lord, I was working, my lord, I never, my lord, converted this land, or, my lord, I never changed the kata of these sites. Whatever the kata site number were given, my lord, after the inclusion of this area into the city municipality, my lord, kata was transferred. I am not at all responsible. My lord, after 17 years, my lord, a complaint is submitted by the 5th respondent. My lord, may I draw your lordship's kind attention to the annexure A, my lord. Complaint. Annexure A. And I may incidentally mention, my lord, I retired from service on 31/5/2020.
Oh, you are not in service now?
Not in service.
Right.
And my
complaint yavaga?
Complaint, my lord, 24/4/2016.
Page?
My lord, ink page 13, my lord, annexure A.
Complaint to the police?
Yes,
ACB?
it is complaint to the
ACB?
ACB, yes, my lord. State ACB. My lord, in the entire complaint, there is not a single allegation against the petitioner that, my lord, the petitioner is responsible for, my lord, he has received, my lord, the illegal gratification, and, my lord, he got the kata transferred in the name of the petitioners in the connected writ petition. My lord, kindly see the ink page. This is the complaint, my lord. It is just in the form of, it appears that he should have filed a writ petition and thereafter complaint seemed to be drafted. My lord, entire. Swami,
content important.
Yes. Now, my lord, in the complaint, my lord, entire complaint, my lord, there is not even a whisper against, my lord, the petitioner.
So that is your case. There are no allegations against
absolutely you. No allegations. My lord, the operative portion, your lordship will get it at ink page 19, my lord. May I read, my lord?
Yes, sir.
Yes. Hence, Mr. Chowda Reddy, that is the petitioners in the connected petition. Balaji is son and Sudhakar is another son. An official of town municipal council. Official of town municipal council. Nannessri illa Swami. And sub-registrar and other public servants have committed the overt act of misconduct so as to attract the ingredients of offence punishable under section 13(1)(d) of the Prevention of Corruption Act, section 34 and 120(b) of the Indian Penal Code by adopting illegal methods and connived with each other in pecuniary advantage of abusing their official position while holding the office as a public servant. There is not even, my lord, a whisper regarding my any allegation there. Then, my lord, on the basis of this complaint, my lord, an inquiry was held. That is at Annexure B. This is, my lord.
Departmental inquiry?
Oh, yes, please, my lord. No, I'm sorry, not departmental.
But what inquiry?
Police. When this complaint was referred to ACB, my lord.
Correct. Referred to ACB. ACB held a preliminary inquiry.
A preliminary inquiry.
All right.
Preliminary inquiry, no opportunity of hearing was given to me.
All
But
right.
I was not heard, no notice was given.
All right.
On the basis of this preliminary report, my lord, I have been along with the respondents, my lord, charged under section 13B and C of the Act.
All right. That's all your cases.
That's my case.
Yes, sir.
Your Lordship, may I say?
Companion petition, is madam? Yes. Yes, sir.
Survey number 11, survey number 12, and survey number 13. They are all in possession of the Chaudhary, the petitioner herein.
All right.
In respect of that, your Lordship, you can see annexure E1, that at page 41. What is the extract which I have produced before this court? That is the 11, survey number 11 is Fulubani Karab. Adjacent to the land of survey number 12 and 13. He is cultivating the land from 66, 67. His name is entered, Chaudhary name is entered in the cultivator's column. Then thereafter, your Lordship, you can see in the year 1993, all the three survey numbers converted into agriculture to non-agricultural purpose, and thereafter a layout as forum, and sold the several sites to several persons. And persons who are purchased the properties are all in possession of the property. During the 1903, my lord, the offence is, according to them, the offence was committed. Then, your Lordship, the complaint was lodged on 2016 for after lapse of several years. Then, your Lordship, you can see the offence is 13(1)D, E, and 13(1)C and D of Prevention of Corruption Act. He is not a public servant. He was not an MLA at that time. He was an ordinary person. He was only MLA at the time of. No, that's not one. MLA only 2016. Chaudhary was holding the post of 1990 to 2004. As on the date of offence, he is not MLA. These provisions will not attract. He is not a public servant.
All right, we'll consider it.
ಯಾಕೋ ಒಂಥರ ನೀವೇನೋ ನೋಡ್ತಾ ಇದ್ರಿ ಅದಕ್ಕೋಸ್ಕರ
ಪೇಪರ್ ನೋಡ್ತಾ ಇದ್ದೀನಿ, ಅದು ನೋಡ್ಬಾರ್ದಾ?
ಪೇಪರ್ ನೋಡಿದ್ದಲ್ಲ ನೀವು.
ಅಲ್ಲ, ನೀವೇನೋ ಹೇಳಿದೀನಿ, ಯೋಚನೆ ಮಾಡಬಾರ್ದಾ?
ಯೋಚನೆ ಮಾಡಿದ್ದು ದಯವಿಟ್ಟು
ಹೇಳಿ ಸರ್. ಯು ಡೋಂಟ್ ಗೆಟ್ ಪರ್ಟರ್ಡ್ ಬೈ ವಾಟ್ ಐ ಡು. ನಿಮ್ ಕೇಸ್ ನೀವು ಹೇಳಿ.
Then your Lordship again to say, when the land was sold several years back, then laterly your Lordship, they filed a complaint on the instigation of a sitting MLA. Even if your Lordship will see MLA has issued a letter dated 3/8/2016, white annexure F, page 51. A rival, political rivalry. He has made allegation that he converted the land and sold the property. Because of that reason, my lord, he was a sitting MLA, hence this the police was investigated. Yes, your Lordship will say annexure F, my lord. That is the sitting MLA that is on.
All right. Yes, that's the complaint, is it?
Yes, that is the letter given to the.
Letter given, not the complaint.
Not the complaint.
Yes.
Letter given to the Chief Secretary, Revenue Department.
All right.
Then in turn, he referred the matter to the investigation. Preliminary investigation is conducted, and this affair is filed.
So it's political rivalry.
Political rivalry only. Lord, that your Lordship can see that the Chaudhary man, I think your Lordship is not heard. He is one of the honest MLA and minister in our area. Because of that reason, your Lordship can see he never committed any offences. Because this is a Karab land, converted the land by the Deputy Commissioner, then thereafter your Lordship can form the layout. It is not a government land. It is adjacent to the property of survey number 12 and 11.
All right. Yes, respondent. ನೀವು ಮಾಡ್ತೀರಾ, ನೀವು ಮಾಡ್ತೀರಾ?
This complaint we have received. It discloses cognizable offense, but still not preliminary.
ಈಗ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಸ್ಟೇ ಆಗಿದೆಯಾ?
ಹೌದು, everything.
10 years ಇಂದ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಸ್ಟೇ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ 5 ಸಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ, ಯಾರು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ಲಿಲ್ಲ.
ನಾನ್
That is
ಮಾಡ್ತೀನಿ.
not our fault.
The buck
Even
stops.
before your lordship also we argued
ಯಾವಾಗ
earlier.
ಹೌದಾ? ನನ್
ಹೌದು.
ಮುಂದೆ ಬಂದಿದ್ಯಾ?
ಹೌದು.
ಇಲ್ಲ
ಒಂದ್ಸಲ ಅಲ್ಲ,
Anyway,
3-4 ಸಲ ಬಂದಿದೆ.
no worries. The buck stops now. Yes.
After receiving complaint, my lord, we have
Oh,
conducted
I thought charge sheet ಆಗಿದೆ. FIR stage ಅಲ್ಲಿ ಇದೆಯಾ ಇನ್ನು?
ಹೌದು.
preliminary inquiry is conducted. Preliminary inquiry reveals, my lord, disclosure of cognizable offence and so also, my lord, involvement of the petitioner also. My learned senior colleague said that in the complaint his name is not there. Complaint refers to, my lord, officials of the Davangere Municipal Corporation, my lord, being hand in glove with, my lord, the other petitioners. And in the preliminary inquiry, my lord, it reveals the names of these persons. So, my lord, FIR is registered again.
Yes.
My lord, I appear for respond number 5 in this matter, the
Complainant.
Please.
Yes.
My lord, filing a convenient synopsis.
Synopsis.
They're not fresh documents, my lord. These are all documents that are amalgamated for the convenience of. They already
Convenience
have these
compilation.
Yes, my lord.
All right. Yes.
My lord, now my endeavor before your lordships today would
Oh,
be.
one is citations.
One is citation, one is compilation.
All right.
My lord, my endeavor before your lordships today would be to show as to why under 482 your lordship shouldn't interfere and why the investigation must go on. Now, my lord, I will go date-wise so that your lordships will see how the entire crime that has taken place from the year 1966.
1966.
Please, my lord, it starts from there. Now, my lord, I'll start now. The genesis of the entire case, my lord, lies in 3 survey numbers: survey number 11, 12, and 13. Now, my entire case is that, my lord, survey number 11 is a government land or grassland, or also called as Hullu Bani Kharab land, which is a B Kharab land, my lord. Now, if your lordships will take, my lord, the last document in the convenience synopsis.
Last document.
Please, my lord. Page 129.
129.
It's a sketch. Your lordships have it, my lord.
One moment, madam. Sketch. All
Yes,
right.
I just want to point out this first, my lord, so that your lordships will keep in mind the positioning of the survey numbers and how on top, my lord, your lordships see, my lord, the first 2 columns, the first 2 rows, that is survey number 11, which is the Kharab land. Below is survey number 12 and 13.
All right.
So this survey number 11 that is there, my lord, is the Kharab land. And in this sites were formed and sold. So I just want your lordships to keep this image in mind, my lord, so that when we go through the documents, your lordships will understand how 12 and 13, my lord, were converted.
Survey number 12 and 13.
12,
So this
while converting,
for clarification, survey number 11 is B Kharab.
please.
11 and 12 and 13 is theirs.
Please.
All right. Yes.
Now, my lord, I just wanted to point this out first, my lord, to show to your lordships how, while converting 12 and 13, they have also very conveniently converted 11, which they could not
also.
have ever converted because
What's
it's a
the
B
extent
Kharab
of land? 11.
1 acre, 19 guntas.
All right. Yes. Carry on.
My lord, now the first document which your lordships will find, my lord, at page number 9, my lord, it's document number 1, which I want to show to your lordships. This is all their document. There are no fresh documents that I've placed on record. I just want to make that clear. Document number 1, my lord, page number 9. My lordships will see, my lord, it's a RTC which points out the year 65-66, my lord. It says Hullu Bani Kharab. Your lordships have it, my lord.
Survey number 11.
Yes.
Yes.
Now, my lord, in thereafter, now on top, my lord, in column number 9 and 10, my lord, it also says Hullu Bani Kharab. This is survey number 11. After 65-66, my lord, from the year 66-67, automatically the name of the one Mr. Chowda Reddy starts appearing, who's one of the petitioners in this. But there is no MR, there is no transfer, there is no grant, there is no convenience. Nothing has been done in their favor. Automatically, the name starts reflecting from the year 66-67. That is there in the same RTC document number, page number 9, my lord, document number 1. After Hullu Bani Kharab from 65-66, 66-67 onwards, Mr. Chowda Reddy's name starts appearing. Subsequent documents, my lord, page 10, 11 are also the RTCs. Now, I would want to take your lordships to page number 15, which is document number 2, to point out, my lord, this is the present RTC as on today. Lordships, you'll see, my lord, it's from the date 2021 till date. In column number 9, it again says government land, Hullu Bani Kharab.
Correct.
Yes. The name of the petitioner is not appearing, it's not reflecting.
Yes.
So, my lord, it's admitted that it's a government land.
That they also admit convert ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
Convert ಆಗಿದೆ.
Placing the facts, my lord. It's not converted.
Oh,
They
alright.
could not have converted it, right?
Correct. That's
It's survey,
yes.
it's a Kharab land, it could not have been done.
Convert ಆಗಿದೆ.
These are the, my lord, facts your lordships will have to remember that as on today also it's a government land. And therefore the actions that are going to be explained to your lordships further could not have ever been committed prima facie. Now document number, my lord, your lordships will see at page number 16. I just want to point out at page number 16, my lord, document number 3. This is to show, my lord, that the current act of crime that was committed was when the petitioner was holding office. The argument that he was never holding office is false. Page number 16, my lord, is a timeline of events. Now, in column number 11, if your lordships will see, my lord, it's Chintamani Taluk. Mr. Chowdreddy's name is up here, Chowdreddy. Ombatne Vidhan Sabha, that is 9th Assembly. From the date of 18/12/1989 till 17/12/1994. Why I'm pointing out this, my lord? Because the argument was that he was never holding office. I will show as to how during that relevant time he was. Now, my lord, the next document which is important as to why he was holding office becomes relevant here, my lord, because page number 19, document number 4. It's the conversion order. 29/5/1993. So this is well within the time when he was holding office. He was holding office from 18/12/1989 to 17/12/1994. So, my lord, this conversion order is from 29/5/1993. And my lord, the intention or the act that the idea behind this was 1993 document. They say survey number 12, this conversion order. They suppress the fact that survey number 11 is also being converted. Everywhere they say survey number 12, 13, which is precisely my case. Just because the land survey number 11, which is a Kharab land, was adjacent to their lands, they have conveniently converted that also. And in every document they said 12, 13, 12, 13.
So 11 is never projected.
Never projected, but it's converted.
Yes.
And I'll come to that later, my lord.
Yes.
19 and 20 are relevant documents with respect to survey number 12 and 13. 19 is with respect to 12. 20 is with respect to survey number 13, my lord. Both of the same year and same dates, 29/5/1993. Please, my lord. Now, my lord, after this, they enter in the petitioner and his sons, one Mr. Balaji and one Mr. MC Sudhakar, my lord, they enter into a partition deed. They, my lord, in these particular survey numbers, divide the sites among themselves. Now, in survey number, the other two people, my lord, one Mr. Balaji and one Mr. MC Sudhakar, are sons of Mr.
Chowdreddy.
Yes.
All right.
Who's also now the present MLA, my lord. One of the sons. Please. Now, my lord, in survey number 11, there are total of 27 sites. But I just want to. Yes.
On the Kharab land,
Yes.
27 sites are built and sold.
Sorry.
27 sites are formed,
Yes.
houses are built and sold, is it?
5 houses are built, constructed as on today, my lord.
Yes. All right.
Out of 33 sites, 27 sites are allotted to these people, the present petitioners and their sons.
All right.
Now, my lord, I will point out the relevant sale deeds as to also show again how every sale deed that they have. Now, my lord, first, after the partition deed was done, the petitioner and one of the son, MC Balaji, have entered into a GPA. They enter into a GPA, my lord, with one government employees housing cooperative society, Chintamani, to give the power to the GPA has entered, and then they give the power to this housing society to sell the sites on their behalf to the. Now, my lord, once it's a government housing society, only the members of that society can be allotted these sites. So what they do very conveniently, enter into a GPA, give the power to the president and one of the secretaries to sell the sites on their behalf. Thereafter, so I'll show, my lords, in this how in survey number 11 these particular sites are there, and these are those relevant sale deeds, my lord. At page number 38 is the GPA. 6/12/2003, my lord.
6/12, yes.
Names of Chowda Reddy and MC Balaji is reflecting, my lord, in the first para itself. Now, page number 39 is also relevant, my lord, where it's highlight the portion to show that it's given in the favor, the GP is given in the favor of the housing society.
Sarkari Naukara Graha Nirmana. Yes. Yes.
What is relevant here is, my lord, the names of Chowda Reddy and Balaji is there. MC Sudhakar's name is not there, even though he has sold the sites. But his name is
That's in the
missing
power
from
of
this.
attorney.
Yes.
Yes.
So, my lord, from page 38 onwards.
That's the power of attorney with respect to all
53?
sides.
Yes, 53 till page 53, my lord. That's the GPA.
53.
Now, my lord, page 54, my lord, is I've produced 3 sale deeds just to show how each one of the persons, Chowda Reddy, MC Balaji, and MC Sudhakar, have sold these sites. And these sites, although in the sale deed it says survey number 12 and 13, these sites are actually of survey number 11. Again, the fact that it is survey number 11 is not represented here.
Yes.
It's suppressed here. Now, my lord, I'll just point out the first one, my lord, page 54, document number 7. The schedule is not there. Page 56, my lord, your lordships will see. 11.1 to the unnumbered para, last para, my lord, Sankhya 56. So now, if your lordships will go to the last document that I showed, my lord, the survey sketch.
Yes.
Here. Now, 56, my lord, your lordships will see. On top, it's under survey number 11.
Correct.
That's MC Balaji who has sold.
That's sold.
Yes. Now, but however, in the sale deed, it says survey number 12. So each one of these sale deeds, my lord, survey number 56. Sorry, site number 56. Then the next sale deed, my lord, is site number 54, which is also part of, which is at page 63. MC Sudhakar site. That is site number 54. That is also misrepresented and suppressed that it is not part of survey number 11. But however, if your lordships will see the sketch, my lord, it is also part of survey number 11.
Yes.
And the next one, the last one is, my lord, is the site of Mr. Chowda Reddy. Site number 43, that is also part of survey number 11 and not 12 and 13, which is again suppressed.
Yes.
Yes. Now, my lord, thereafter, the Tahsildar, my lord, next document which is relevant, my lord, is document number 11, which your lordships will find at page number 79. Now, just a brief background, my lord, as to how the complainant gets involved into this entire, how I filed a complaint. The complainant, my lord, contests in the municipal councillor elections and gets into office in the year 2014. That's just a backdrop, my lord. I'll show the certificate later. Now, page 79, my lord, is an endorsement that is issued by the Tahsildar. He issues this endorsement, my lord, to show that how this survey number 11 was never granted to any government organization, let alone a private party. Second paragraph, unnumbered paragraph, your lordships will see.
Kacheriya Dakalegalalli.
Great.
Yes.
Tahsildar endorsement to show that how it was never granted to any government organization or any.
Yes.
Now, my lord, this is relevant. The next document, my lord, is important at page number 80, document number 12. This is a response of Mr. Chowda Reddy to this endorsement in the newspaper article in Vijayawani News, which he comes forward and he says to the when allegations were raised that it's an encroached land, he comes forward and he says, my lord, the relevant portion your lordships will find at page 81. The last 2 paragraphs, my lord, where he says that if at all there is some error committed by me and my family members and we have encroached the land, we are ready and willing to give an alternate land. It's shocking how, my lord, they can come and make such statements when the land was never theirs. They're ready to return the land and to give alternate land now that they've already developed sites on it. So this is relevant, my lord, because there's an admission by them saying that they have encroached these lands. Now, my lord, the next document would also be relevant, my lord, where the Commissioner of the Municipal Town Corporation, 10/2/2015, also passes an order
That there is encroachment.
Yes, there is an illegal layout formed in survey number 11, which is 1 acre 19 guntas, and also illegal khatas are affected to that extent.
Yes.
Thereafter, my lord, at page 86, document number 15. This is the most important document, my lord, in my considered view, my respectful submission. It's a DDLR report, which is, my lord, which states after the spot was Mazar was conducted and inspection was done, after the endorsement issued by the Tahsildar and these admissions that were made that there are illegal encroachments on that particular site. At page 86 is the DDLR report where it states categorically that survey number 11 is encroached. Sites are formed, 5 houses are constructed, and they're sold. Now, this is signed by, my lord, the Tahsildar, the Assistant Commissioner, and the DDLR. The signatures, your lordships will find at the bottom of the page. Now, page 87, my lord, there's another, the same sketch, my lord, but it's also very clear that what is, which is what survey number, my lord. So,
yes,
which is prepared by the DDLR, of course.
Yes.
Now, page 87, my lord, your lordships will see survey number 11, 12, and 13 are highlighted
Yes.
at page 87. Thereafter, my lord, there are a couple of communications that were made by the Tahsildar and the DC to the district in charge minister, who, my lord, also looks into the matter, and they come to a conclusion that survey number 11 is encroached, which is a government kharab land.
Yes.
Now, at page 92, my lord, this was also raised in the assembly in the year 2015, wherein, my lord, the revenue minister replies. Uttara, my lord, your lordships will see in this column on the right hand side at page 92, my lord.
Yes.
Yes. Where the minister itself says, the revenue minister, my lord, that the land is encroached.
Yes.
Now, the next document I've produced to show at 95, my lord, that how many total number of sites are there in survey number 11 and what sites are built, their exact measurements. This is only to show, my lord, that nothing could have been done on survey number 11.
Yes.
Thereafter, my lord, at page 96, document number 18, a show cause notice is issued by the Tahsildar, my lord, to the petitioners.
Yes.
To show cause as to why such an encroachment that is made and why it should not be removed. They challenged that before this honorable court.
That is 98, is it? Yes. This is Rammohan
96
Reddy's.
is the show cause notice. 98 is the order of this court, where they say that hear them first and then fast. It was nothing on merit. Now, 111, my lord, 111, 101, sorry, document number 20. Again, a notice is issued to them.
Yes.
To which there is a reply at 102, document number 21, which is again important, my lord, 6/11/2015. From, your lordships have it, my lord, page 100.
Yes.
From Shri Chowda Reddy, MC Balaji to the Tahsildar Chintamani.
Yes.
Next page is relevant, my lord. Now, your lordships will recall as to how in that Vijayawani newspaper, there was an admission made by the petitioner that if there is any encroachment, they're ready and willing to give the lands back. Now, on page 103,
Yes.
now D, my lord, D para D. Shri MC Anjaney Reddy occupied the land in question on Shankranti Day in 1950 with a view to acquire title over the said land by adverse possession. Here they say now that
Adverse possession.
on that day he openly asserted his hostile intention, and this is their reply, my lord.
Yes.
On that day he openly asserted his hostile intention to dispossess the government of the said land and occupy the said land to the knowledge of the government as well as the entire world openly. What is relevant, my lord, that they were very... Now, my lord, my complaint is at page 106. I have also produced it, my lord, which is also part of their petition, document number 22. Now, based on this complaint, my lord, a preliminary inquiry was conducted.
By the ACB.
Yes.
And ACB finds that there is...
Yes. And the FIR
offenses.
lordships will find, my lord, at 126.
So the FIR is challenged here.
Yes. So they have just placed, and my lord, the citations also I've placed, my lord, to show.
Yes,
Lordships have it, my lord.
I have it.
Inspector of Police Anti-Corruption Bureau has lawful authority because they say that it's not a lawful authority of produced citations. I don't want to trouble your lordships going through this, my lord. The next one, my lord, is procedure of conducting a preliminary inquiry before the registration of FIR. And the last one, my lord, B Kharab land, as your lordships are already aware, I don't want to trouble your lordships, could not have been converted.
Yes.
Could not have been converted, much less, my lord, form sites and sell them, my lord. I just want to, my lord, in my convenience synopsis, just one relevant section, my lord, to your lordships. Page number 6.
B Kharab cannot be converted.
I just want to read this. I just
21,
want to
read. Yes.
Grounds.
21, Allah?
Yes, my lord. 21 2B, my lord, of the Land Revenue Act. Defines B Kharab as under that which is not assessed because 1. It is reserved or assigned for public purpose. 2. It is occupied by a road or recognized footpath or by a tank or stream used by persons other than the holders of irrigation, drinking, or domestic purpose. 3. Used as a burial ground or cremation. 4. Assigned for village potteries. So, my lord, my respectful submission is the fact that survey number 11 could not have been converted, they go ahead and convert it. Second, they form sites. There are 5 constructed houses. And then they sell these sites also. And the DDLR report is very clear on this, my lord. And there is no conversion on this.
Yes, sir.
Your lordship, you can see their document that at page 80, my lord.
80.
80,
Yes,
document
sir.
number 12. Wherein the children has written a letter to the Deputy Commissioner Chikbadapo, District
Yes.
Chikbadapo. At page 81, last 3 paragraphs, your lordship can see. ಸದರಿ ಆಸ್ತಿಗಳು ಸೇರಿದಂತೆ ನನ್ನ ಒಟ್ಟು ಆಸ್ತಿಯ ಮೇಲೆ ಈ ಹಿಂದೆ ಮಾನ್ಯ ಲೋಕಾಯುಕ್ತರು 1996ರಲ್ಲಿ ಲೋಕಾಯುಕ್ತ ದೂರಿನಂತೆ ವಿವರವಾದ ತನಿಖೆಯನ್ನು ಕೈಗೊಂಡು ಸುದೀರ್ಘವಾದ ವರದಿಗಳನ್ನು ಮತ್ತು ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಸರ್ವೆ ಮಾಡಿಸಿ ದೂರುದಾರರು ಕೊಟ್ಟಿರುವ ದೂರಿನಲ್ಲಿ ಸತ್ಯಾಂಶವಿಲ್ಲವೆಂದು ದಾವೆಯನ್ನು ವಜಾ ಮಾಡಿರುತ್ತಾರೆ. ದೆನ್ ನಮ್ಮ ಗಮನಕ್ಕೆ ಬಾರದೆ ಹಾಗೂ ಅಚಾತುರ್ಯದಿಂದ ಅಂತಹ ಯಾವುದೇ ಒತ್ತುವರಿ ಆಗಿದ್ದಲ್ಲಿ ಅದನ್ನು ಕೂಡಲೇ ಸರ್ಕಾರಕ್ಕೆ ಬಿಟ್ಟುಕೊಡಲು ನಾನು ಮತ್ತು ನನ್ನ ಮಗ ಸಿದ್ಧರಿದ್ದೇವೆ. ಈಗ ಆಗಿರಬಹುದಂತಹ ಅಚಾತುರ್ಯಗಳಿಗೆ ಬಹುಶಃ 100 ವರ್ಷಗಳಿಗಿಂತ ಹೆಚ್ಚು ಸದರಿ ಆಸ್ತಿಗಳು ನಮ್ಮ ಸ್ವಂತ ಸ್ವಾಧೀನದಲ್ಲಿರುವುದು ಕಾರಣವಾಗಿರಬಹುದೆಂದು ಭಾವಿಸುತ್ತೇನೆ. ನನ್ನ ಇದುವರೆಗಿನ ಸಾರ್ವಜನಿಕ ಬದುಕಿನಲ್ಲಿ ಯಾವುದೇ ರೀತಿಯ ಕಳಂಕ ಬರುವ ರೀತಿ ನಡೆದುಕೊಂಡಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ನಾನು ತಮ್ಮಲ್ಲಿ ಕೋರುವುದೇನೆಂದರೆ ತಾವುಗಳಿಗೆ ಕೂಡಲೇ ಈ ವಿವಾದಿತ ಕನ್ನಂಪಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 11, 12, 13 ಜೊತೆಗೆ ಕನ್ನಂಪಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 6, 9 ಸೋನ್ಸೋ ಮತ್ತು ಮಾಲಪಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸೋ ಇವರೆಲ್ಲದರ ಸರ್ವೆ ಮಾಡಿಸಿ ಅಳತೆ ಮಾಡಿ ಹದ್ದುಬಸ್ತು ನಿಗದಿ ಮಾಡಿಕೊಡ್ಬೇಕಾಗಿ ತಮ್ಮಲ್ಲಿ ಕೇಳ್ಕೊಳ್ತೇನೆ. ಅಳತೆಯಾದ ನಂತರ ನಾವೇನಾದರೂ ಸರ್ವೆ ನಂಬರ್ 11ರಲ್ಲಿ ಒತ್ತುವರಿ ಮಾಡಿದ್ದ ಪಕ್ಷದಲ್ಲಿ ಕೂಡಲೇ ಅದನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಒಪ್ಪಿಸಲು ನನ್ನ ಯಾವುದೇ ಅಭ್ಯಂತರವಿಲ್ಲ ಹಾಗೂ ಈ ಪ್ರಕ್ರಿಯೆಯಿಂದ ನಿವೇಶನ ಕಳೆದುಕೊಳ್ಳುವವರೆಗೆ ಕನ್ನಂಪಲ್ಲಿ ಸಮೀಪದ ಇರುವ ಬದಲಿ ಜಮೀನು ನೀಡಲು ಬದ್ಧನಾಗಿರುತ್ತೇನೆ. Without his knowledge, if it is formed a layout, then your lordship is ready to give back that land.
ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಲ್ಯಾಂಡ್ ವಾಪಸ್ ಕೊಟ್ರಾ?
ಅಲ್ಲ, ಅವ್ರು ಯಾರು ಕೇಳಿಲ್ಲ, ಸರ್ವೆ ಮಾಡಿಲ್ಲಲ್ಲ. All these survey number as per this request.
ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ಲೆಟರ್ಲಿ ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್ ನಲ್ಲಿ ಇದೀನಿ ಪೊಸಿಷನ್ ಅಂತ ಯಾಕೆ ಹೇಳಿದ್ರಿ?
ಅಲ್ಲ, even Panish discloses that.
ಆಯ್ತು, ಇದು ಇಲ್ಲಿ ನನಗೆ ಗೊತ್ತಿಲ್ಲದೆ ಆಗಿದ್ರೆ ವಾಪಸ್ ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್ ನಾನೇ 30 ವರ್ಷದಿಂದ ಇದೀನಿ, ಸೊ ನಂದೇ ಲ್ಯಾಂಡ್ ಅಂತ ಹೇಳಿದ್ರೆ ಯಾವುದು ನಿಜ?
RTC extracts discloses from 1965 to
11 ಇಲ್ವೇ ಇಲ್ಲ ಅದರಲ್ಲಿ.
11 ಸರ್ವೆ ನಂಬರ್
11 ಅಲ್ಲಿ ಇರೋದು ಬಿ ಖರಾಬ್ ಅಂತ.
ಬನ್ನಿ ಹುಲ್ಲು ಖರಾಬ್ ಅಂತ.
ಅದು ಕರೆಕ್ಟ್, ಅದು ಬಿ ಖರಾಬ್. ಆಯ್ತು, ವಿಲ್ ಸಿ. ಎಸ್ 10 years ಇಂದ FIR ಸ್ಟೇ ಆಗಿದೆಯಾ?
17 stay order passed on 24/4/2017.
Then the offences will not attract.
ಆಯ್ತು, that will answer, but 10 years keeping this pending. Yes, heard the learned senior counsel.
That the important point is Lord 13(1) CHD will not attract to
that. Will see. ಅವ್ರದ್ದು ನೋಡೋಣ.
ಅವ್ರದ್ದು
ಅವ್ರು ಮಾಡಿದ್ದಾರೆ ಬಿಡಿ.
ಅವ್ರದ್ದು ಅಫಿಷಿಯಲ್.
ಅವ್ರದ್ದು ಅಫಿಷಿಯಲ್, ನಿಮ್ದು ಅನ್ಅಫಿಷಿಯಲ್.
ಅಲ್ಲ, I am not a public servant. That provision will not attract.
ಆಯ್ತು. Yes. We'll see what is your.
Yates, my learned friend, has pointed out, while he was public servant, my lord, it took place.
Yaudu?
The Kata transfer and all.
That will see, will answer.
And also, my lord, with respect to the sites that were formed, no plan sanction was ever taken.
Even to the layout.
Yes. No conversion was effected, nothing.
Conversion ಆಗಿದೆಯಲ್ಲ?
11 ಆಗಿಲ್ಲ.
11 ಎಲ್ಲ ಆಗಕ್ಕೆ ಸಾಧ್ಯವೇ ಇಲ್ಲಲ್ಲ. Yes, 12 and 13 convert ಆಗಿದೆ. Heard the learned senior counsel Sadashiv Reddy appearing for the petitioner. Counsel B.K. Manjunath representing the petitioner in the companion petition. Sri Venkatesh Arbatti representing the Lokayukta and Srimati Kirti Reddy representing the de facto complainant. Respondent number 5. Reserved.
Yes, sir.
CBI.
My lords, there is some inconvenience today, so kindly have it next week.
Is it 25? All right. Why what inconvenience? ಅದೇ 30 ಜನದ್ದು SPPಗಳು ಟೆಂಡರ್ ಆಗ್ತಾನೆ. Tenth, 71, 10th. Nagadhan sir. What's the matter?
Covered by judgment. ಇದರಲ್ಲಿ ಕಂಪನಿ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಇಬ್ಬರಿಗೆ ಆಲ್ರೆಡಿ ಕ್ವಾಶ್ ಆಗಿದೆ.
ಕೊಡಿ ಯಾವ್ದದು? No inconvenience in all this. Yes, ಕೊಡಿ.
Petition ಅಲ್ಲಿ annexure E.
Co-accused Co-accused.
Already.
ಅಲ್ಲ, both are co-accused?
Yes, my lord, co-accused. The ಕ್ವಾಶ್ ಆಗಿರೋದು 15 and 20 ಗೆ. I am 19.
The petitioner is before the court calling in question, seeking the following prayer. Heard the learned counsel R. Nagendra Nayak appearing for the petitioner and counsel so and so representing the respondent. The learned counsel for the petitioner, Nagendra Nayak, would submit that the accused numbers
15 and 20 is already questioned.
15 and 20. The coordinate benches of this court have quashed the proceedings on the score that the company is not made a party in the proceedings. The orders of the coordinate benches read as follows. Madam, page 65 and page 72. Since the petitioner is accused number 19. The petitioner accused number 19 is undoubtedly entitled to the same benefit that is granted by the coordinate benches. In that light, the proceedings where the petitioner on the same reason so rendered as quoted supra stands obliterated. Next.
74.
My lord, there is a stay in respect of accused number 192, my lord, who was the beneficiaries of the.
Permitted to file my objections also.
Akelven. Learned counsel Unni Krishnan M. Seek. ಏನಿದೆ ED ಎನ್ಫೋರ್ಸ್ಮೆಂಟ್ ಡೈರೆಕ್ಟರೇಟ್.
Enforcement.
ಯು ಆರ್ ಆಲ್ಸೋ ದೇರ್ ಇನ್ ಇಡಿ. ಮತ್ತೆ ಎಲ್ಲರೂ ಅವ್ರಿಗೆ ತೊಂದರೆ ಕೊಡ್ತೀವಿ ನಾವು. ಅವ್ರಿಗೆ ಕೊಡ್ತೀವಿ, ಇಲ್ಲ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿಸ್ತೀವಿ.
ತೊಂದರೆನ ಶೇರ್ ಮಾಡ್ಕೋಬಹುದು. ತೊಂದರೆನ ಶೇರ್ ಮಾಡ್ಕೋಬಹುದು.
ಅದಕ್ಕೆ ಅವರು ಸುಸ್ತಾಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ಆಗ್ಲೇ. ಎಸ್, ದ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ M. Unni Krishnan seeks 2 weeks time to file statement of objections. List the matter on 17th, objections if any by then.
My lord, interim order in respect of already 192, it's already there, my lord.
ನೀವ್ ಯಾರು?
I am accused number 11, my lord. I am only the arrange the iron ore, my lordship.
Ultimate ಯಾರು?
Ultimate beneficiary who has the export.
ಅವ್ರಿಗೆ ಸ್ಟೇ ಇದೆಯಾ? Unni Krishnan ಸರ್. Yes. ಎಲ್ಲಿದೆ ಪೇಜ್?
I have given, my lordship.
Where have you given?
Your lordship was granted on 18/12/2024, my lord.
Numbers ಕೊಡಿ ಸರ್ ಹೋಗ್ಲಿ.
Writ petition 33619 of 24, my lord.
ಆಮೇಲೆ
Same one.
Same ಒಂದೇನಾ? Tag this petition along with so and so in the light of the interim order subsisting quay accused number 1 and 2, the beneficiaries of the beneficiary of the alleged illegal acts, and the petitioner being accused number 11, there shall be an interim order of stay as is granted in the said case. Yes, next. Next.
75.
Offense, my lord, this is under 171G. Based on a newspaper report, my lords, complaint is filed by the second respondent.
Judgment kodi sir.
No, my lords, this is a matter where B report was filed.
So complainant ga.
No, my lords.
Accused ga alva.
Please, my lords. B report was filed. Subsequently, protest petition was filed by the complainant. Again, a B report was filed, but the learned magistrate, my lords, takes cognizance. And the newspaper, the authors of the newspaper reports, my lord, state that I have not made a statement against. There's an interim order.
Alla respond complainant yaru? Served and unrepresented?
Served and unrepresented.
Illa. Additional SPP for R2 anta. Neeve complainant?
Flying squad.
Flying squad.
Flying squad. Learned HCGP accepts notice for the second respondent as well. Registry to print the name of the HCGP as appearing for the respondent. Idu former chief minister. Yes. Yavat 17th hakla? List on 17th. We'll close it on 17th. Interim order subsisting will continue to the next date of hearing. Yes.
76.
Matter 76, I need some time, my lord, I have to file my objection.
Right.
That's in 76.
Yen Sunil Kumar idu?
Lord, this is the, where, my lords, in the connected matter, your lordship has quashed the entire proceedings, my lords.
Ardadu.
Yes, my lords, in this matter, my lords. Then subsequently, the CBI approached the Supreme Court. And Supreme Court is
Wapas
one of the,
banta?
wapas, my lords, it is restored to the trial court, my lords.
This is a separate crime, my lord.
Yav nan quash madiddu?
In one petition, my lords, I'll place it the order, my lords. I'll place the order. So 195, my lords, the non-following of the adjourn's judgment, my lords. Your lordship followed the adjourn's guidelines followed in the adjourn's. Then quashed it, my lords. This is, my lords, another case.
This is the case where, my lord,
Complaint filed by the brother of the deceased.
This is the case, my lord. The dishonorable court has directed, my lord, to register the FIR.
Vinay Kulkarni connected.
Along with the two police officers.
You are accused, ade crime you are accused,
He is the brother of the deceased, my lords. I am accused.
I am the
brother of the deceased.
complainant
Of the deceased.
seeking the investigations to the transfer to the CBI, my lord. What happened in this case, my lord? Original, my lord, dishonorable court directed to file
CBI ಮಾಡಿರೋದು ಇನ್ಯಾರು ಮಾಡಿದ್ದಾರೆ?
ಅಲ್ಲಲ್ಲ ಅದೇ ಸ್ಟೇಟ್ ಪೊಲೀಸ್ ಮಾಡಿರೋದು ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ the complaint was registered.
For witness threaten, my lords, already one charge sheet is filed.
Complaint
Trial is
dishonorable court had directed to file FIR. Their FIR was filed. Then B report was filed. We filed the protest application. Then again B report was filed.
This on 195 I had passed an order that Apex Court clubbed it with 3-4 Kerala. Ella seri it is lost.
Sunil versus Kerala. Here, my lords, on 4/12/2025, my lords, dishonorable court has dispensed the notice to the present respondent, my lords. So now they are seeking the transfer of the investigation to CBI, my lords. Seeking.
Yes. Nothing. ಇದನ್ನು CBI ಗೆ ಕಳಿಸಬೇಕು.
Trial is already going on, my lords. CBI has filed two.
Threatening the witnesses go CBI ಗೆ ಏನ್ ಸರ್ ಸಂಬಂಧ? What is this? Just because the main matter is going
CBI
on.
has already filed the charge sheet on
My lord,
the score of the threatening witnesses, my lord.
in this case, my lord, in this case, this honorable court has directed to register FIR, my lord. After registering, my lord, B report was filed. Again, we filed the protest application. Again, B report was filed. Then we filed again the protest application, my lord. Again, the magistrate has
your investigation correct ಆಗಿ ಮಾಡಲ್ಲ.
Again registered the directed to do the further investigations to the state police. Then we filed this petition because, my lord, two of the accused are one is the accused.
Clearly, deceased wife wanted to support the accused.
No, my lords, that is not case.
Case.
One of the accused is, my lord, additional SP, and another accused is a DYSP, my lord. So when high rank police officers are involved in this case, my lord.
So CBI is better.
Because police are again and again filing the B report in spite of the video and audio recordings, my lord.
ಇದು ಕಳಿಸ್ಬಿಡೋಣ CBI ಗೆ.
That is not even given the video and audio records. It is already produced. After verifying this, my lord, this honorable court has directed to register FIR against
10th SPP ಅವರೇ. Yes. ಎಲ್ಲದಕ್ಕೂ CBI ಉತ್ತರ.
ಎಲ್ಲದಕ್ಕೂ ಅಂತಲ್ಲ ಸ್ವಾಮಿ, ನಾವು 2 ಟೈಮ್ ಕಾದ್ವಿ, 2 ಟೈಮು ಸ್ಟೇಟ್ ಪೊಲೀಸ್ ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರು. ಅಲ್ಲಿ ಸಫಿಶಿಯಂಟ್ ಮೆಟೀರಿಯಲ್ಸ್ ಇದಾವೆ. ಮೇನ್ ಮರ್ಡರ್ ಕೇಸ್ ನಲ್ಲಿ MO ಮಾರ್ಕ್ ಆಗಿದೆ. ಸೇಮ್ ವಾಸ್ ದ ಎವಿಡೆನ್ಸ್ ಹಿಯರ್.
ಅದು ಕನ್ವಿಕ್ಷನ್ ಆಯ್ತಲ್ವಾ?
Appeal suspension of sentence is going on, hearing on
sentence is not suspended even.
Not yet suspended.
Yes.
On the trial, my lords, with respect to the very same fact, another trial is going on. And the petitioner himself is a
ಎರಡೆರಡು ಕೇಸ್
witness.
ಬೇಡ ಒಂದೇ
Petitioner
ಒಬ್ಬರೇ
himself is a witness in that both the cases.
ಅಲ್ಲ another tempering of
All
witness
right, all right. Yes, 10th. Final ಏನ್ ತಗೋಬೇಕಾ? ತೋರಿಸಿಲ್ವಾ? ಇದು so registry to print the name of Sunil Kumar appearing for
R3, my lords.
R3 to R5,
Three, but only three, my lords.
R3.
4 and 5 dispensed, my lord.
4 and 5 dispensation.
Accused has no say in the investigation.
The learned
my lord.
counsel
They
to the
cannot choose the investigation.
petitioner submits that service of notice to response 3. ಯಾಕೆ ಪಾರ್ಟಿ ಮಾಡಿದ್ರಿ ಮತ್ತೆ?
ಅಲ್ಲ ಫಾರ್ಮಲ್ ಪಾರ್ಟಿ ಮಾಡಿದ್ವಿ ಬಟ್ ನಾವು ಸಬ್ಮಿಷನ್ಸ್
ಬರ್ಲಿ ಬಿಡಿ.
ಲಾಸ್ಟ್ ಟೈಮ್.
Yes, R3 ಗೆ ಮಾತ್ರ ಇರಲಿ. 4 and 5 dispense with ಮಾಡಿ. ಆಗಿದೆ already. Yes, learned SPP. To hear the learned SPP and the respondents list the matter on 10th. Yes.
Final hearing.
Then appeals ಎಲ್ಲ. All these are appeals.
77, 2012 matter, my lord, 2008.
2012 ಯಾವ್ದು?
Matter, my lord, it's a conviction appeal. 5 lakh rupees bribe amount.
Yes, sir. ಯಾವಾಗ?
Last occasion also, they fixed the date today. They want to engage the senior counsel, they submitted last occasion.
3ನೇ ತಾರೀಕು ಹಾಕ್ತೀನಿ. ಅವತ್ತು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ I will pass orders. I will hear Prasad and pass the orders.
Request on 10th, my lord.
No, ಎಲ್ಲಾನು ಆಗಲ್ಲ. ಇದು 77, 78, 79, 80, 81, 82. 82 ಏನೋ ತುಂಬಾ ಕನೆಕ್ಟೆಡ್ ಇದೆ.
82 also connected.
82 ವರೆಗೆ ಲಿಸ್ಟ್ ಆನ್ 3rd. ಆಮೇಲೆ 83, 84, all these are appeals. List appeals and revision petitions on 10th.
Lord 84. Lord, your lordship may call for the records, my lord, paper book file ಮಾಡಕ್ಕೆ ಇನ್ನು ಆರ್ಡರ್ ಆಗಿಲ್ಲ.
ಆಯ್ತು. 84 ಅಲ್ಲಿ ರಿಜಿಸ್ಟ್ರಿ ಯಾವ್ದ್ರಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಬೇಕು? In all these cases, madam, appeals and revision ಇದೆಯಲ್ಲ, the registry is directed to secure the trial court records by way of telephonic instructions by the next date of hearing. Up to 84. 85 to 92, revision petition, 85 to 92, list on 17th. Same order.
77 may request on 10th, my lord.
No, sir.
My lord.
3rd ಬಂದಾಗ ನೋಡೋಣ. 2012 matter. What?
They themselves have filed application for early hearing. That was came to be allowed very long back, 10 years back.
No, sir, this is puts all of us to shame, sir.
No, my lord.
No, nothing.
10, my lord, it may be taken.
Nothing.
Detailed order has been passed.
Nothing. 3rd ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ, ಇಲ್ಲದ್ರೆ ಇಲ್ಲ. These ಏನ್ 2017 ಇಂದ FIR ಸ್ಟೇ ಹಾಕೋದಿದೆ, 2012 ಇಂದ ಇದು ಪೆಂಡಿಂಗ್ ಇದೆ. 15 ವರ್ಷ. What? No, nothing. Nothing, sir. 3rd, I'm going to take these matters, and 10th, I'm going to take the other matters, period. Yes. Mahesh ಅವ್ರೆ ಅದರಲ್ಲಿ? That is on 10th. 17th, sorry. ಅದೆಲ್ಲ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. But no adjournment on those days, because these are all 25 matter, okay. ಇವ್ರು ಕೇಳ್ತೀರಾ 12 matter ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
90 heard,
90 ಯಾವುದು?
heard and posted for
ಇದು ಹಿಯರ್ ಮಾಡಿದ್ನಲ್ಲ, ಹೌದು.
result.
ಆಯ್ತು, ನೋಡೋಣ ಬರ್ಲಿ. ಎಸ್, ಎಲ್ಲ ರಿವಿಷನ್ ಪೆಟಿಷನ್ಸ್ ಇದು.
Kalburgi bench matter is also a special court matter. Interim order may be continued now.
ಯಾವುದು? ಅಮಿತ್ ಕುಮಾರ್ ದೇಶಪಾಂಡೆ ಅಪೇರ್ ಆಗಿದ್ದು?
Yes.
All right, it will continue, don't worry. Yes.
Great.
Now go to the second list.
List number 2. Fresh matter, still number 1.
This is yesterday's matter, my lords. The one incident, 2 FIRs. Ram Sundar sir appeared and.
ಒಂದು ನಿಮಿಷ. ಎಲ್ಲಿ SPP ಅವರು ಇದ್ದಾರಾ? ಲಿಸ್ಟ್ ನಂಬರ್ ಇದೆಯಾ? ನಂಬರ್ 2 ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಇದೆಯಾ ನೋಡಿ. ಒಂದ್ ನಡೀಲಿ ಅಂತಾನೆ ಹೇಳಿದ್ದು.
No, my lords, even the other side, the complainant also appeared. They have also given.
ಏನಿಲ್ಲ ಕೇಸ್ ಅಂತ ಹೇಳಿದ್ರು.
Nothing, my lords, is a former registrar of that university. We are not claiming, my lords, ಅವರು ಅದನ್ನ claim ಮಾಡಿದ್ರೆ ಗಲಾಟೆ ಮಾಡ್ತೀನಿ ಅಂತ ಶ್ಯಾಮ್ ಸುಂದರ್ ಸರ್ ಹೇಳಿದ್ರು, my lords. It's only instigation. My name is not there. in
ಒಂದ್
the-
ಕೇಸ ಎರಡ್ ಕೇಸ ಸುನಿಲ್?
Two cases, my lords, two petitions.
Same petitioner?
Same petition.
The petitioner, common in both these petitions, is before the court, calling in question, before the court seeking the following prayer. Heard Sunil Kumar appearing for the petitioner. K. Sunil Kumar.
Yes.
Yes, Sunil Kumar. Yes, Sunil Kumar appearing for the petitioner, and the learned senior counsel M.S. Shyam Sundar representing the respondent. Synopsis kotra?
Yes, my lords, yesterday.
ಎಲ್ಲಿದೆಯಪ್ಪ? Yes. The petitioner at the relevant point in time was working as the principal of ಯಾವ ಕಾಲೇಜ್ ಇದು? Of the Alliance University College. On 13/11/2017, a complaint comes to be registered before the jurisdictional police, which becomes a crime in crime number 190 of 2017 for offences punishable under section 143, 147, 148, 186, 189, 353 and 149, 353 against unknown persons. The contents of the complaint was that the second respondent who was on duty receives an information from his staff that CW11 and CW12 were hatching a conspiracy with regard to agitation to be conducted before the gate of the Alliance University College. The other accused who have some role to play in the episode of crime were drawn as accused at a later point in time. The petitioner is also along with them drawn as accused number 13 only on the score that he was the principal of the college at the relevant point in time. And the charge sheet hakidara?
Yes, my lords.
On the same incident, the other crime has sprung, which is challenged, other crime has sprung, which has resulted in the filing of the charge sheet in the said case as well, and which is challenged in the companion petition. The learned counsel appearing for the petitioner submits that the petitioner, accused number 13, has no role to play in the dispute between the parties. He was only a principal and has not committed any overt act for him to be drawn into the web of proceedings. The learned counsel submits that apart from being the principal, he has no other claim or no other obligation in the university, Alliance University College, nor would claim anything in future. The learned senior counsel appearing for the respondent, complainant M.S. Shyam Sundar, would submit that the offences, the ingredients of the offences are made out as there are sprinkling few offences against the petitioner. Therefore, the trial must be conducted for the petitioner to come out clean, or would also leave the decision to the hands of the court. I have given my source. Therefore, narrated facts lie in a narrow compass with regard to the role of the accused number 3, the present petitioner. The police, a complaint comes to be registered by the second respondent police, a suo motu complaint, on the score that the several persons are agitating in front of the gate of the Alliance University College. The petitioner is caught in the web of crime as accused number 13. The police conduct investigation and file a charge sheet. The summary of the charge sheet as obtaining in column number 17 reads as follows, page 1920. A perusal at the summary of the charge sheet would not indicate any offense against the petitioner, much less the offense of being a part of the unlawful assembly or assaulting the criminal usage of criminal force to stop the police officer from performing his duties as obtaining under section 353. In the light of no offense being made out against these petitioners, against the petitioner in both these cases, as the incident is common, if further proceedings are permitted to continue, would become an abuse of the process of the law. Therefore, allowed quashed que accused number 13 only.
Let's correction. He was a registrar, my lords, not
No,
principal.
registrar, principal, registrar. ಮತ್ತೆ ಇವೇ ಪ್ರಿನ್ಸಿಪಲ್ ಅಂತ ನೆನ್ನೆಯಿಂದ ಇವತ್ತಿಗೆ ರಿಜಿಸ್ಟರ್ ಆಗೋದ್ರ? ಎಸ್, ನೆಕ್ಸ್ಟ್.
Both matters.
Both. Next.
Seal number 2.
Respondent number 2, my lords.
My lord, in serial number 2, I appear for the petitioner, my lord. The
Have it
offence is, my
next
lord,
week.
at 498A, 504, 506.
Laws may have it next week, my lords. I get prepared.
My lord, this is the matter that I moved, my lord, saying a disciplinary inquiry was initiated against the petitioner under
Brahmakumari.
490. Please, my lord, I'm covered by
yes,
your lordship's
sir.
order. And now, my lord, thereafter the disciplinary inquiry is now suspended 2 days ago.
Because of this crime. Yes, sir, come on.
It's Monday, my lords.
Nothing. Complaint ಕೊಡ್ಬೇಕಾದ್ರೆ ಚೆನ್ನಾಗಿರುತ್ತೆ ಕೊಡಿ. ಬ್ರಹ್ಮಕುಮಾರಿ problem.
I'm not on record, my lords.
Then who is it?
It's Bharat Kumar. I'm a proxy counsel. I appear for Bharat.
Well, look at the impact. Departmental inquiry is initiated because of the complaint registered by the wife.
Monday, my
Kodi
lords.
adu.
Monday, my lords. Have it.
List on Tuesday in the fresh matters list as a last chance. In the event the respondent would not be present or not, and being present would not make any submissions, orders would be passed on hearing the counsel appearing for the petition. Mail heard so and so on that.
Great for this. Interim orders.
Interim order idea. Interim order subsisting will continue to the interim order idru. How did they proceed there?
No, my lord, initially we had filed and we took the liberty to challenge the charge sheet and thereafter it was.
In the interregnum they have done it.
Yes.
Yes. Tuesday fresh matters list. Yes.
Grateful.
Seal number 3.
This is my day before yesterday's matter, my lord. Now, one of the matter, my lord, and Supreme Court, in respect of the my lord 306. No, it was, my lord, the 2025 judgment.
Complainant on you?
No, my lord, I am accused. My lord, husband and my lord, parents of the husband, my lord.
Who died?
No, the wife, my lord. And my lord, the complainant, my lord, is the brother of the, my lord, the wife.
498A 306.
Yes. The last portion, lordship, may kindly. No ingredients, my lord.
No, husband I'm not going to say. Other mother-in-law and father-in-law, yes.
The allegation, my lord, it's just, my lord, that there is no any, my lord, cruelty on the, my lord, the wife. My lord, is even, my lord, the brother of the, my lord, the wife, my lord, he also, my lord, stated, my lord, that, my lord, there is no anything, but ದಪ್ಪಗಿದ್ದೀನಿ ಮಕ್ಕಳಾಗ್ತಿಲ್ಲ, that is the only, my lord, reason.
Continuous taunt from all the accused.
Mother-in-law, father-in-law, it's all right. It's not 304B, madam. 306. 306 operates on a different platform. 306 you need to have 107 present.
In this also, my lord, there is nothing, my lord. 107 is also not present. 107 is not present, my lord.
Husband.
No, husband, my lord, against the husband also, my lord.
Husband.
Yes, my lord.
Yes, sir. Husband. Yes, we'll quash against the two new discharge ಹಾಕೊಳ್ಳಿ. I am not going to quash. ಅವರೊಂದು ಮಾಡಲಿ proceeding, ಆಮೇಲೆ we'll see. The petitioner is before the petitioners accused 1, 2, complainant ಇಲ್ವಾ?
Complaint, my lord.
Javed, yes. Last time you.
Last date, my lord, he appeared.
Interim order ಇದೆಯಾ?
Interim order ಇದೆ.
ಇದು ಮುಗಿಸೇ ಬಿಡ್ಬೋದು. Heard the learned counsel appearing for the petitioner, there is no representation. We have the complainant as a last chance. List this matter on 14th in the event. 14th in the fresh matters list. In the event the respondent would not be present, appropriate orders would be passed on hearing the counsel for the petition. IO extended.
Please.
Next.
Number 4.
Petitioner, the DV case has not been connected.
DV case?
Yes, domestic violence case.
Domestic violence ಅಂತ ಗೊತ್ತು DV ಅಂದ್ರೆ. ಏನಿದೆ ಇದೇನು ಹೇಳಿ?
My lord, I had married in a Feb 2017.
You had married?
In a Feb, I am a sister-in-law, still. 498A, 323 and 313. 313 has been dropped after filing a final report.
ಒಂದು ನಿಮಿಷ. ಆನಂದ್, you are sister-in-law.
Yes, my lord.
ರಾಕೇಶ್ ಏನಂತಿದೆ?
Rakesh is, that is at 4.1 I'm submitting, my lord.
Oh, yeah. ಅದು ಹೇಳ್ಬೇಕಲ್ಲ ಯಾವ್ದ್ರಲ್ಲಿ ಸಬ್ಮಿಟ್ ಮಾಡಿ. This is Vidyashri, that is sister-in-law, na?
I had married in Feb 2017. After 15 days, I relocated to the Europe. I am a permanent resident of a Luxembourg. And the complainant,
Luxembourg. Yes.
complainant date of marriage on June 2022. Now, she has been accused of me saying on a phone that I used to demand dowry from Luxembourg to India. That is their version.
ಆಮೇಲೆ
So on that, the similar facts and circumstances, the DV, both the
So,
proceedings have been
ಆಯ್ತು
stayed.
ಲಕ್ಸಂಬರ್ಗ್ ಓವರ್. ನೆಕ್ಸ್ಟ್ ಈಗ ಬನ್ನಿ.
The DV case is yet
ಇಂಡಿಯಾಲ್
to
ಯಾರಿದ್ದಾರೆ?
connect. This 1200 calling for CDR, my lord.
1200 husband.
Yes, my lord. Husband and subsequent mill and fill. Mother-in-law and father-in-law.
Husband, mill and fill.
Yes, my
ಅದು
lord.
ಸಿಲ್.
Yes, my lord.
ಆಯ್ತು.
So
ಆಮೇಲೆ
DV case has to yet to connect and respondent number 2 is yet to file a wakalat for a 4.1, my lord.
Don't worry about that.
Okay. So,
Yes, Venkatram.
I am for impleading applicant. Not
The
de facto
impleading,
impleading applicant, de facto complainant. Complainant has not made a party to the
ಆಯ್ತು, will hear you, tell me.
No, my lord. So far as serial number 4 is concerned, I have no objection to allow the petition.
4 allow ಮಾಡಕ್
Allow ಮಾಡಿ.
ಹಸ್ಬೆಂಡ್ ಸೇರಿ.
No, that is the petition, my lord, rejection of 91 CRPC application. They
Stand,
challenge before this
my
honorable
lord, it has
court.
already been,
If you
IO has
interim
been
order,
filed a
they
report.
complied it, then they CDR and call it.
4.1 ಏನು?
4.1 is the same.
ಅಲ್ಲಿ ಚಾರ್ಜ್
Connect-
ಫ್ರೇಮ್ ಆಗಿಲ್ವಾ?
No, my lord,
No, my lord.
during the pendency of the FIR, during investigation, they approached this court and obtained the interim order. And
No, my lord was pleased to give.
ಇಬ್ರು ಹೇಳಿದ್ರಾಗಲ್ಲ ಹೇಳ್ತಾರೆ.
My lord, the charge sheet has been filed against the accused number 1 to 3. This petition number 4, accused number 4 is in petition number 4.1. And they, against them, my lord, the charge sheet is
ಕೇಳಿದ್ದೆ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ? ಚಾರ್ಜ್
ಆಗಿಲ್ಲ. Against them, charge sheet has not been
ಈಗ
filed.
4.1 ಅಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್
Charge sheet
ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ, sir.
4 ಅಲ್ಲಿ ಆಗಿದೆಯಾ?
4 ಅಲ್ಲಿ ಆಗಿದೆ, sir.
4 ಅಲ್ಲಿ ಟ್ರಯಲ್ ನಡೀತಾ
Charge ಇದೆ, ಹೌದು. Charge frame, charge, it is posted for framing the charges.
No, my lord.
not
it
yet
was-
charge is not yet framed.
Not at trial. They filed the application under 91 CRPC, sought for the call details and tower location of the petitioner and the.
ಅದು ಅಲೋ ಮಾಡ್ಬೋದಾ?
Allow ಮಾಡಬಹುದು, sir. I
My
have no
lord, one
objection.
submission.
ಅಲೋ ಆಯ್ತಲ್ಲ ಅದು.
In meanwhile, an interim order was been, my lords were been able to secure through the IO. And the IO has put up a report indicating on the said date, nobody was there in that.
ಅದು ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
Already been produced, my lord.
ತೊಂದ್ರೆ ಇಲ್ಲ, ಅಲ್ಲಿ ಮುಗಿಸ್ಕೊಳ್ಳಿ.
Yes, my lord. Now, my humble submission is, still the same complainant is in a domestic violence case, 4.1. This is a FIR, my lord, connected. FIR stage. Another DV case which in the, my lords, in the last previous hearing had instructed to connect it by.
You had instructed, I did
No,
not
my lords
instruct.
were instructed to connect, but
sorry, yeah.
by oversight it has been missed out, my lord.
Hmm.
The DV case might be connected so that it can be heard because the same respondent is before.
ಪರವಾಗಿಲ್ಲ, we'll close this, we'll close that later. DV ಕೇಸಲ್ಲಿ ಹಸ್ಬೆಂಡ್ ಏನ್ ಬಿಡಲ್ಲ ನಾನು.
Husband is not been before this.
Then we'll,
court, my lord.
it is deemed cost, don't worry, we'll ಅದ್ ಬರೋದಷ್ಟೇ. ಈಗ ಇದನ್ನ ಮುಗಿಸ್ಬೋಣ.
Yes, my lord.
ಇದು 4
And DV may be, date may be.
criminal petition, wait, criminal petition 1200 of 2026. The petitioners accused 1, 2 and 3 are before the court calling in question an order of the concerned court which rejects an application filed by the petitioners accused under section 91 of the CRPC seeking certain documents - call record details to prove their case before the concerned court. The concerned court rejects the application and therefore the petitioners are before the court. This court grants an interim order of stay of further proceedings before the concerned court on the score that the application should have merited positive consideration, favorable consideration in favor of the accused. The learned counsel Venkatram Nayak, appearing for the respondent complainant therein, would submit that the application be allowed and the concerned court be directed, the concerned court application be allowed and the documents that are sought for can be placed on record. In the light of the submission.
It is already placed on record.
ಮತ್ತೆ ಏನ್ ಬೇಕು sir?
He could, in meanwhile, the IO has produced it, my lord.
No problem. The counsel for the respondent submits that it can be, the application can be allowed. The learned counsel for the petitioner at this juncture would submit that the investigating officer has already placed it on record. In that light, as a matter of form, the order which rejects the application stands quashed. The document that is already placed on record by the investigating officer shall be put into use as is sought for by the petitioner or the respondent as the case would be before the concerned court, ordered accordingly. Next matter, 10716. The petitioner in the case at hand is the cell of the complainant. Complainant, the wife of the accused number 1. The learned counsel for the petitioner, who taking this court through the documents appended to the petition, would seek to demonstrate that 1 week after the marriage between accused number 1 and the complainant, the petitioner flies to.
No, my lord. Sister-in-law got married in 2017.
Oh, sorry. The sister-in-law of the the petitioner is the cell of the complainant, the wife of accused number 1, the husband. The petitioner gets married in the year 2017 and flies to Luxembourg, where she stays even today. The learned counsel for the petitioner, taking this court through the documents appended to the petition, would seek to demonstrate that not an iota of allegation is against the accused number 4.
Yes, my lord.
Accused number 4, the sister-in-law, the present petitioner, and the court should not permit further proceedings against the said petitioner. This court in the year 2024 itself had granted an interim order of stay, and therefore no charges framed against the present petitioner while the trial is continuing against the other accused. In the light of the said circumstance, permitting further proceedings against this petitioner would undoubtedly become an abuse of the process of the law and run foul of the judgment of the apex court in the case of Kashkan Kaushar versus State of Bihar, 2022 SEC online, SC page 162.
Sorry, my lord. There is that time, that, my lord, in respect of the allegation is concerned. She was there, she called and threatened, she has made use of that then.
There is
allegation.
Wait, sir. The learned counsel appearing for the respondent complainant would, however, clarify that there are serious allegations. How are the allegations? Is that she calls from Luxembourg to India and threatens the complainant with dire consequences. If this is accepted, every person calling the daughter-in-law, the sister-in-law, every person calling the daughter-in-law would end in the web of crime. This is noted only to be rejected, as it cannot form the ingredient of section 498A or even otherwise. Yes.
My lord, one correction.
My lord, there is a serious termination of pregnancy, my lord.
In phone terminate madadra.
My lord, in a final report, pregnancy termination was been dropped.
Lord, she instigated the my lord.
Phone terminate madbidi anta.
There is a lot of conversation.
Only instigation, nobody has written that it will become a crime. Ashte. ಈಗಿರದೆ 498 ಮಿಸ್ಯೂಸ್ ತಡ್ಕೊಳಕ್ ಆಗ್ತಾ ಇಲ್ಲ, ಇದು ಬೇರೆ. ಎಸ್. ಆಮೇಲೆ ಪಕ್ಕದ ಮನೆಯವ್ರು ಇನ್ಸ್ಟಿಗೇಟ್ ಮಾಡಿದ್ರು, ಅದ್ರ ಪಕ್ಕದ ಮನೆಯವ್ರು ಫೋನಲ್ಲಿ ಮಾತಾಡಿಸಿ ಕೇಳಿಸ್ತಾ ಇತ್ತು ನಂಗೆ, ಎಲ್ಲ ಬಂದ್ಬಿಡತ್ತ. ಕಂಟ್ರೋಲ್ ಇರ್ರಿ ಸರ್, ಪರವಾಗಿಲ್ಲ. You may have axe to grind, you may have so many differences of opinion that cannot become 498A. Yes.
In this last para, one correction. As per the complaint, respondent number 2, petitioner had directly called her father and mother. On a father and mother phone, she used to talk. That is allegation. She never called directly the respondent. That is allegation as per the complaint below.
ಇದಕ್ಕೆ ಕ್ರೈಮ್ ಮುಂದೋಗಿಲ್ಲ ಬಿಡಿ. ನಿಟ್ಟಿಗ್ರಿಟಿಗೆ ಹೋಗ್ಬೇಕಾ ನಾವು? ಯಾವ ನಂಬರ್ ಇಂದ ಮಾಡಿದ್ರು, ಯಾವಾಗ ಮಾಡಿದ್ರು, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಮತ್ತೆ
ಸಾರಿ,
CDR ಯಾಕೆ ಬೇಕು ನಿಮ್ಗೆ? ಎಲ್ಲ ನೀವೇ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. ಆಲ್ ರೆಕಾರ್ಡ್ ಡೀಟೇಲ್ಸ್ ಬೇಕಾಗಿಲ್ಲ.
On that day, 15 members had beaten respondent number 2 and father and mother on the set date and time. So they were residing in a Bangalore itself. They never visited a Tumkur. That is their difference.
Tumkur ಎಲ್ಲಿಂದ ಬಂತು ಮಧ್ಯದಲ್ಲಿ?
Tumkur is a fill and mill places of incident is in Tumkur. So they are residing in a Bangalore.
ಅವರು ತೀರ್ಮಾನ ಮಾಡ್ಲಿಲ್ಲ ತಾನೇ ನನಗ?
No, I'm
just saying ಯಾಕೆ ಸರ್, ತುಂಬಾ ಕೆಲಸ ಇದೆ, ಆಮೇಲೆ ನೋಡಿ.
Sorry.
Yes. Next matter, please.
My lord, DV matter date.
DV matter ಬಂದಿದೆಯಾ?
My lord, previous hearing itself the connect agbe.
ಅದು ನೋಡಿ ಮೇಡಮ್.
Same petitioner, my lord. Date maybe.
ಯಾವತ್ತು ಬೇಕು ವೆಂಕಟರಾಮ್?
Next week, my lord.
Any date.
Next week same stage.
Date.
Next week same stage, same day.
Grateful.
Number 5.
Here for respondent number 2. This case, my lords, where a pre-FIR anticipatory blanket order has been passed, my lords. A pre-FIR anticipatory bail, my lords, which is in the form of a blanket order that was passed, my lords.
Vachanananda.
Please, my lord.
Oh.
My lords, my request, my lords, lordship, may kindly peruse, my lord, only one para, my lords, in the impugned order.
I will permit you to approach the
Charge
bail
sheet filed.
court.
My lords,
ಅಷ್ಟೇ,
now the
ಇನ್ನೇನಿದೆ?
charge sheet, my lords, now the charge sheet is filed. My lords,
ಅದನ್ನ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು bail court ಹೋಗಿ ಎಲ್ಲ.
my lords, the backdrop, my lords, in which the application
Are you
was filed.
challenging the charge sheet, sir?
I'm not
It is
challenging.
his petition.
Please, my lord.
You are wanting to get relief in his petition. This relief is more than enough that
Please,
I'll grant you
lordship,
some time.
please.
Go before the bail court.
Lordship, may then, my lords, may I request, my lord, lordship, may grant me 4 weeks time, my lord. Protection, my lords, for 4 weeks.
Supreme Court galla sir, bail
My
court.
lords, it is, my lords, I'm only requesting, my lords, that the protection be extended by 4 weeks, my lord. By that time, I'll file an application, my lord, seeking regular bail, my lords, before the. In the
Four
meanwhile, my-
weeks Supreme Court. ಮತ್ತೆ?
then lordship may direct, my lord,
We will direct the court to decide the bail application in terms of the Supreme Court's order.
the intrignum, my lords, they have already intimated the complainant, and an FIR also comes to be filed, my lords.
ಯಾವುದಕ್ಕೆ ಸರ್? ಇಂಟಿಮಿಡೇಟೆಡ್
ಅಲ್ಲ, ಥ್ರೆಟನ್ ಮಾಡಿದಕ್ಕೆ
ನಿಮ್ಮನ್ನ ಮಾಡಿದಾರ?
ಪ್ಲೀಸ್ ಸ್ವಾಮಿ, and the FIR ಕೂಡ ಆಗಿದೆ. My lords, it is by some other person, my lord, who is not at all connected, my lords, to the respondent.
Connected to the very same case, my lords, because only for the reason
Themselves,
that.
my lord, call the, my lords, the victim, and they make statement before the court, my lords, that.
ಒಂದ್ ನಿಮಿಷ. ಕೋರ್ಟ್ ಅಲ್ಲಿಗೆ ಹೋಗಿ ಬೇಲ್ ತಗೊಳ್ಳೋವರ್ಗುನು ಯಾವ ವಚನಾನು ಹೇಳ್ಬೇಡಿ.
ಪ್ಲೀಸ್.
ಹೆಸರು ವಚನಾನಂದ ಅಷ್ಟೇ. ಸುಮ್ನೆ ಇದ್ಬಿಡಿ. Yes. Yeah, why do you threaten witnesses?
My lords, it is not the complaint, is not the respondent.
So why have you got the witnesses threatened?
My lords, we have not done it, my lord. They themselves, my lord, make a call, my lord, to the victim, and they submit, my lord, the same before the honorable court, my lord, to show cause as though, my lord.
The petitioner is before the court. ಇದು you are not on that ground ತಾನೆ? Non application of mind ಅಲ್ವಲ್ಲ? ಹಾ ಸರಿ.
Blanket order ಮೇಲೆ
reason ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ interfere ಆಗಲ್ಲ. Yes.
My lords,
but this order on the face of it could not have been.
A blanket in the form of blanket order.
The petitioner
in fact,
is
now, my lords, I'm sorry, my lords, now an application is filed, my lords, by the state for cancellation of bail. That is pending consideration.
ಅದೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿ ಸರ್. ಈಗ ನಾನೇ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ತೇನೆ.
That was pending consideration.
That becomes useless. Sorry, infructuous. The petitioner is before the court. The petitioner, the victim, in crime number 83 of 2026 is before the court calling in question an anticipatory bail, pre-arrest anticipatory bail granted to the second respondent. The order of the concerned court is as follows, page 19 to 28. A perusal at the order led this court to pass an order on 16/6/2026. The 16/6/2026, the learned counsel for the second respondent now submits that police after investigation have filed a charge sheet even. Though in law, once an anticipatory bail is granted, it would run even after filing of the charge sheet. This court is not examining whether the grant of the filing of the charge sheet would obliterate the anticipatory bail granted. No, it is not. The manner in which the pre-arrest bail is granted is what troubles this court. As 1 week prior to the registration of the complaint itself, a bail is granted in offences punishable under section 4, 6, 8, 10, 12 of the POCSO Act. Therefore, owing to the offence and the manner in which it is granted is what leads to obliteration of the subject order and not mere fact of filing of the charge sheet. In that light, I deem it appropriate to obliterate this order and reserve liberty to the petitioner to knock at the doors of the appropriate court to seek regular bail. Seek regular bail in the light of in the light of the anticipatory bail being in subsistence today and the petitioner not being taken into custody on any ground in the teeth of the anticipatory bail. I deem it appropriate to extend the same for a period of 2 weeks. To sakala. Because ಹಾಕದ್ಮೇಲೆ ಒಂದು ವಾರದಲ್ಲಿ ತೀರ್ಮಾನ extend by a period of 3 weeks from today, with a direction to the concerned court that as and when the petitioner would file the application for seeking bail, it shall be decided in the light of the directions issued by the apex court for expeditious disposal of bail applications.
My lords, the respondent number 2 may put to strict terms. My lords, already an FIR has been registered, my lords, for threatening the complainant.
More or extend ಮಾಡಿದೀನಿ ಏನ್ term, same ಮತ್ತೆ.
That's one request. It shall consider, my lord, independently uninfluenced, my lord, by this.
ನಾನೇನ್ ಬರ್ದಿದ್ದೀನಿ ಇಲ್ಲಿ? The concerned court shall consider the bail application on its merits and not being influenced by the observations made in the course of this order.
That victim should have been heard.
ಅದು ಅಲ್ಲೊಂದು ಬರೀರಿ. So and so, apart from the aforesaid, the very fact that the victim has not been heard in a case concerning POCSO would also be a ground for obliteration of the order granting bail. I think that should be fine. Yes. More ವಾರ.
Still number 6.
Appearing for the petitioner, my lord. Custody matter, my lord.
Yes, sir.
Husband, wife, matrimonial dispute.
Custody. ಅದೇ.
Baglur police station.
Baglur
police station.
Baglur police station. We'll release him today. ಎಲ್ಲಿ ಬಂದಿದ್ದಾರೆ ಇವರು? Come this side, sir. Why did you take him into custody? ಯಾವ ಕೇಸಲ್ಲಿ ಜೈಲ್ಗೆ ಹಾಕ್ಬೇಕು ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕ್ಬಾರ್ದು ಗೊತ್ತಿಲ್ವಾ ನಿಮ್ಗೆ? ನೋಟಿಸ್ ಕೊಟ್ರಾ? ಏನ್ ಮಾಡಿದ್ರು ಬರ್ಲಿಲ್ವಾ? ಬರ್ಲಿಲ್ವಾ? ಎಷ್ಟು ಸರ್ತಿ ಕೊಟ್ರೆ? 2 times ಕೊಟ್ರಾ? ಎಲ್ಲಿದೆ ನೋಟಿಸ್? ನೋಟಿಸ್ ಕೊಟ್ಟಿದಾರಾ? ಅಥವಾ ನಾಮಕೆ ವಾಸ್ತೆ ಇಲ್ವಾ? ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಏನ್ ವೈಫ್ ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ ತಕ್ಷಣ ಹಸ್ಬೆಂಡ್ ಜೈಲ್ಗೆ ಹಾಕ್ಬೇಕು ಅಂತಿದ್ಯಾ? 498A ಅಲ್ಲಿ ಫೋರ್ಜರಿ ಅದ್ರಲ್ಲಿ ಹಾಕ್ಬೇಕು ಅಂತಿದ್ಯಾ? ಯಾಕೆ ಹಾಕ?
ಪದೇ ಪದೇ ಹೋಗಿ ಅವ್ರಿಗೆ ತೊಂದರೆನೂ ಕೊಡ್ತಾ ಇದ್ರು.
ಪದೇ
ಮನೆ ಹತ್ರ ಹೋಗಿ ಕಂಪೌಂಡ್
ಅದಕ್ಕೆ ಜೈಲ್ಗೆ ಹಾಕ್ಬೇಕಾ?
ಡಾಕ್ಯುಮೆಂಟ್ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಡೀಡ್ ಒಂದು ಫೋರ್ಜರಿ ಮಾಡಿ
ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಡೀಡ್ ಫೋರ್ಜರಿಗೆ ಜೈಲ್ಗೆ ಹಾಕ್ಬೇಕು ಅಂತ ಎಲ್ಲಿದೆ? ಹಸ್ಬೆಂಡ್ ಅಂಡ್ ವೈಫ್ ಮಧ್ಯೆ ಇರೋ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಡೀಡ್ ಫೋರ್ಜರಿ ಆಗಿದೆ ಅಂತ ವೈಫ್ ಕಂಪ್ಲೇನ್ಸ್ ಅಂಡ್ ಹಸ್ಬೆಂಡ್ ಇಸ್ ಇನ್ ಲಾಕಪ್. ಏನ್ ಜೈಲ್ಗೆ ಹಾಕೋದು ಆಟ ಆಗ್ಬಿಟ್ಟಿದ್ಯಾ? ಯು ಥಿಂಕ್ ಇಟ್ ಈಸ್ ಎ ಪ್ಲೇ ದಟ್ ಸೆಂಡಿಂಗ್ ಸಮ್ ಒನ್ ಟು ಪ್ರಿಸನ್? ಮಾಡಿದ್ರೆ ಕಳಿಸಿ. There are crimes conducted, crimes committed, definitely send in a manner known to law. Wives today, day in and day out, are registering crimes. And you straight away take the husband into custody? For what? Partnership deed between the husband and the wife is alleged to be forged. ಅದೇ ನಿಜ ಇರುತ್ತಾ? ಅದು ಆಮೇಲೆ ನೋಡಿ.
3 months, only 2 CDs.
Will direct departmental inquiry against him. I will impose costs of putting him into custody. 1 lakh you will pay from your pocket. What do you think of yourself? And police ಅಂದ್ರೆ ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ಬೋದು ಅಂತ. How did you put him into custody? And what is the offense? ಏನು offense ಇಲ್ಲ. ರಿಜಿಸ್ಟರ್ ಆಗಿರೋದು ಕ್ರೂಯಲ್ಟಿ ಇಲ್ಲ, ಟಾರ್ಚರ್ ಇಲ್ಲ, ಎಲ್ಲ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಡೀಡ್ ಬಿಟ್ವೀನ್ ಹಸ್ಬೆಂಡ್ ಅಂಡ್ ವೈಫ್. ಅದಕ್ಕೆ ವೈಫ್ ಇಸ್ ಇನ್ಫ್ಲೂಯೆನ್ಷಿಯಲ್, ಹಸ್ಬೆಂಡ್ ಇಸ್ ಇನ್ ದಿ ಪ್ರಿಸನ್. ಅಂಡ್ ಯು ಕ್ರಿಯೇಟೆಡ್ ರೆಕಾರ್ಡ್ಸ್ ಆಫ್ ನೋಟಿಸ್ ಬೀಯಿಂಗ್ ಇಶ್ಯೂಡ್. ನೋಟಿಸೇ ಇಶ್ಯೂ ಮಾಡಿರಲ್ಲ, ಜೈಲಿಗೆ ಕರ್ಕೊಂಡು ಹೋಗ್ಬೇಕಾದ್ರೆ ಸೈನ್ ತಗೊಂಡಿರ್ತೀರಾ. ಹೌದಾ? ಹೌದಾ ಇಲ್ವಾ? ಅರೆಸ್ಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿರೋದು ಇದು. ಅಷ್ಟು ಗೊತ್ತಾಗಲ್ವ ನಮ್ಗೆ? ಅರೆಸ್ಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ನೋಟಿಸ್ ಕೊಟ್ಬಿಟ್ಟು ಅರೆಸ್ಟ್ ಮಾಡಿ, ಯು ಆರ್ ಪ್ಲೇಯಿಂಗ್ ವಿತ್ ದ ಲೈಫ್ಸ್ ಆಫ್ ಸಿಟಿಸನ್ಸ್. If there are crimes committed, do it. Do it in accordance with law. Not because the wife registers a crime or frivolous crimes. 69 ಅಲ್ಲೂ ಅಷ್ಟೇ ಎಲ್ಲರೂ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ. Something has to be done in 69. Everybody is behind bars. Consensual acts for 8 years. The moment crime is registered under 69, he is inside. Total misuse of law by police. ಯಾವತ್ತು ಅರೆಸ್ಟ್ ಮಾಡಿದ್ದು?
April 21st, my lord. More than 2 months have passed, my lord.
ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ವ ನಿಮ್ಗೆ?
Instructions I've heard is notice ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ.
ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಬಿಟ್ಟಿದ್ದಾರೆ. ಆಲ್ ರೈಟ್. ಯಾವ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ಗೆ ಅಂತ ಬಂದ್ರಿ ಕೋಆಪರೇಟ್ ಮಾಡಕ್ಕೆ? It's a case of 318(4), cheating and forgery. And complainant is the wife. It's a pure...
No, I think your lordship may direct for departmental inquiry. The two investigations.
Pure husband and wife dispute in a partnership firm.
The two investigations.
Wife appears, two investigations.
First investigation officer for 3 months does nothing except writing 2 CDs. He has taken over the investigation.
What is the date of registration of the crime?
1912.
19/12/2025 registration of crime ge 5 months ಆದ್ಮೇಲೆ ಅರೆಸ್ಟ್ ಮಾಡಿದಾರಾ? This is the new IO, is it?
Charge sheet has not been filed yet, my lord.
Yes, sir. ನಿಮ್ಗೇನು ಹೊಸದು ಕಾಣಿಸ್ತು? ಹಳೆ IO 3 ತಿಂಗಳು ಕಾಣಿಸ್ತೇ ಇಲ್ಲ ಇರೋದು. ಏನ್ ಕಾಣಿಸ್ತು?
ಅವರು ಮುಂಚೆ ಒಂದು ಕೇಸಲ್ಲಿ ಜೈಲಲ್ಲಿ ಇರ್ತಾರೆ.
ಯಾರು? ಅದಕ್ಕೆ ಒಂದ್ಸರಿ ಇದೇ ತರ ಜೈಲ್ಗೆ ಹಾಕಿರ್ತೀರಾ? ಅದಕ್ಕೆ ಜೈಲ್ಗೆ ಹೋದವರೆಲ್ಲ ಅಲ್ಲೇ ಇರ್ಬೇಕು ಅಂತ ನಾವ ಯಾವಾಗ್ಲೂ?
It is 498.
ಅದೇ 498 ಅಲ್ಲಿ ಅದರಲ್ಲೂ ಹಾಕ್ಸಿದ್ದಾರೆ. The petitioner, the husband of the complainant, the second respondent, is before the court seeking his release, seeking quashment of the FIR in crime number 308 of 2025. Crime number 308 of 2025 is registered by the wife on 19/12/2025, alleging that the husband has forged the signature of the wife and has signature of the wife and created a partnership deed and opened a current account without the knowledge of the wife. This is the fulcrum of the complaint registered on 18/12/2025. The crime is registered before the jurisdictional police, i.e. Bagalur police station. The investigating officer who began his investigation on the 19th of December 2025 did nothing for 3 months. No investigation virtually takes place in terms of the records for 3 months. The station house officer is changed. The present investigating officer, what's your name?
Ramesh.
You know?
Ramesh Bandra.
So and so takes charge as officer in charge of the police station of Bagalur police station. It is then the investigating officer appears to have shown undue interest in the case, which resulted in the petitioner husband of the complainant against whom no investigation virtually was conducted for 3 months, to immediately issue a notice under 35(3), seeking to appear before the investigating officer for conduct of investigation in the 4th month, and alleging that the petitioner has not cooperated, takes him into custody. The magistrate The magistrate, by the remand order with blatant non-application of mind, has permitted the custody of the petitioner. It is by now too well settled a principle of law that arrest should be the last resort in terms of the judgment of the apex court, right from D.K. Basu till the judgment of the apex court in Arnish Kumar. In what offences, even Allabalu, in what offences that the offences arrest should come about is is elucidated by the apex court in those judgments. Notwithstanding the same, the petitioner is taken into custody just only because of the registration of the complaint by the wife, for which the offence punishable is up to 7 years or less. Therefore, the act of the investigating officer of showing undue haste in taking the petitioner to custody without any rhyme or reason, nor there are any reasons indicated for the arrest of the petitioner except a bald statement that he has not cooperated with the investigation, would necessarily lead to the release of the petitioner from prison. The order cannot stop with this, but the investigating officer cannot be left off the hook for for acting blatantly contrary to law. A departmental inquiry shall ensue against this investigating officer of station house officer of the Bagalur police station stroke the investigating officer at the hands of the competent authority in accordance with law, and the action taken against him shall be reported back to this court within 12 weeks from today. The proceedings against the petitioner husband shall remain stayed till the next date of hearing. In the light of the interim order granted now, the petitioner shall be released from prison without broking any delay. The registry is directed to communicate this order through electronic mail to the jail authorities to enable release of the petitioner forthwith.
No, even against the person who did not conduct investigation. For 3 months, nothing has been done.
So
even against that person also.
The competent authority is also directed to inquire into the conduct of the investigating officer who, after registration of crime from 18/12/2025 till the present incumbent takes over for conducting no investigation worth the name. Yes. I'll bari ella hakbek helತೀನಿ ಅದನ್ನ. Next. ಇನ್ನೊಂದಿತ್ತಲ್ಲ ಇಲ್ಲಿ ಬ್ರದರ್ನ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ರಲ್ಲ
65 serial.
ಅದು ಕರೆದ್ಬಿಡಿ ಹೇಳ್ತೀವಿ, ಒಂದೇ ನಿಮಿಷ. ಅದು SHO ಬಂದಿದ್ದಾರೆ.
But affidavit is ready, my lord. Affidavit is also ready.
What affidavit, sir?
But I told him we will not file an affidavit. Let him. I think there is a mistake. One reason, my lord, is justification is that the wife, the complainant, consumes sleeping tablets and then get admitted to hospital and then created.
ಅಲ್ಲ ಬ್ರದರ್ನೇ ಕರ್ಕೊಂಡು ಹೋಗ್ಬೇಕು.
So that is where things have bit more.
ಅಲ್ಲ, whatever may have happened,
mistake, my lord.
For the accused number 1 who is not to be seen, how accused number 2 is not even connected be taken into prison? Then police ಆಟ ಆಡ್ತಾರೆ ಒಳಗ್ ಬಾ ಸ್ವಲ್ಪ ಅಂತ.
Because she consumed sleeping tablet.
Whatever may be the reason, sir, where grounds of arrest ಅಲ್ಲಿ?
All those things are given, but they could not. I say, my lord, could not have been arrested. Allegation against him is only harboring an offender. So harboring an offender is a bailable offence, could not have been arrested.
How did whatever may have happened, sir, arresting someone like this is not correct. Just because crimes are registered, where is that man? ಬನ್ರಿ ಸ್ವಲ್ಪ ಇಲ್ಲಿ. ಇವ್ರನ್ನೇ ಕರ್ಕೊಂಡು ಹೋದ್ರಿ. Why did you arrest him? Accused number 1 absconding ಇದಾರೆ ಅಂತ accused number 2 ಹೆಂಗ್ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರಿ ನೀವು? ಅವ್ರ ಮೇಲೆ ಏನ್ ಅಲಿಗೇಷನ್ ಇದೆ? ಏನ್ ಆಟ ಆಡ್ತಿದ್ದೀರಾ ನೀವೆಲ್ಲ? Are you policemen or what? Accused number 1 ಕಾಣ್ತಾ ಇಲ್ಲ ಅಂದ್ಬಿಟ್ಟು accused number 2 ಕರ್ಕೊಂಡು ಹೋಗೋದು. And offense ಏನು? 69. Promise to marry. ಇವ್ರು ಪ್ರಾಮಿಸ್ ಮಾಡಿದ್ರಾ? ಇವ್ರೇನ ಮಾಡಿದ್ರಾ? ಮತ್ತೆ ಯಾಕೆ ಜೈಲ್ಗೆ ಹಾಕಿದ್ರಿ ಇವ್ರನ್ನ? Why? This is misuse of law. ಇದಕ್ಕೆ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡಲೇಬೇಕು to be pulled out from the pocket of this man. How did you arrest him? Arrest has become a playful thing for all you policemen here. ಏನು ಉತ್ತರ ಅದಕ್ಕೆ? Yes, sir. Promise to marry, accused number 1 promises the girl, whatever it is, that we will take care. Our not to be seen ಅಂತ accused number 2 arrest ಮಾಡಕ್ಕಾಗತ್ತಾ? His brother. What is his mistake? And you know the consequences of arrest? It's a tag all over his life. This will impose illegal arrest and will impose costs. 1 lakhs to be paid from his pocket to the petitioner. He will not be spared. Departmental inquiry ಮಾಡಲೇಬೇಕು. What is this? ತೊಗೊಳ್ಳಿ ಬರ್ಕೊಳ್ಳಿ. You are still in custody?
No, my lord, I was released.
ನಾನೇ ರಿಲೀಸ್ ಮಾಡಿದೆ.
Yes, please.
ಅವತ್ತೇ ರಿಲೀಸ್ ಮಾಡಿದ್ರ?
ಹೌದು, ಅವತ್ತೇ ಮಾಡಿದ್ರು.
We'll ask him to be placed under suspension and a departmental inquiry to be conducted apart from 1 lakh cost.
I think it's because of the conduct of respondent number 2.
What conduct of respondent number 2? You take action against respondent number 1, as accused number 1. Sir, arrest is qua the offense.
Yes, no, there is no justification.
Non-cognizable offense, 2 ವರ್ಷದ punishable offense, ಎಲ್ಲದರಲ್ಲೂ arrest.
No justification.
Law into your hands is, you are playing with the law into your hands. ನಿಮಗ್ ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತದೆಲ್ಲ. When you face the same situation, you will know it. ಸುಮ್ಮನೆ you have the uniform ಅಂತ ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Yes, what do we do with him?
The cost can be imposed and not suspension, my lord, but
Departmental inquiry ಮಾಡ್ಲಿ. Because of the SPP I am sparing you. ಇಲ್ಲಾಂದ್ರೆ ಈಗಲೇ ಸಸ್ಪೆಂಡ್ ಮಾಡಕ್ ಹೇಳ್ತಾ ಇದ್ದೆ. And once again, if I see this conduct of any policeman of taking citizens into custody without any rhyme or reason, I will direct the secretary to place everyone under suspension. Every officer who would violate the law like this to arrest persons without any rhyme or reason, definitely. ಯಾವ್ದ್ರಲ್ಲಿ ಮಾಡ್ಬೇಕು ಅದ್ರಲ್ಲಿ ಮಾಡಲ್ಲ. ಇಲ್ಲಿ ಮ್ಯಾಂಡಮಸ್ GM ಅಲ್ಲಿ ಇದ್ದಾಗ ಅರೆಸ್ಟ್ ಮಾಡೇ ಇಲ್ಲ 307 ಅಲ್ಲಿ, ಅರೆಸ್ಟ್ ಮಾಡಿಲ್ಲ 302 ಅಲ್ಲಿ. ಇಲ್ಲಿ ಬೇಡಕ್ಕೆಲ್ಲ ಅರೆಸ್ಟ್. Power of arrest is misused. ಈಗ ಬಿಟ್ಟಿದಾರಲ್ಲ, I will pass an order. ಅವ್ರ ಹೆಸರು ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್. Yes.
affidavit is ready, my lord. I don't want to file, my lord.
Hey, what is the justification? What justification can he have? Tell me.
The only justification is that the respondent number 2 attempted to commit suicide and that she went on.
Whatever may happen, that doesn't mean that he should be taken into custody. What is the offense? What is the allegation against him? Harboring the offender?
Yes. Bailable.
In a bailable offense, he is into custody. And these magistrates straight away remand order ಕೊಡ್ತಾ ಇರೋದೇ ಕೆಲಸ.
That is another unfortunate.
That's another thing I want to observe, that all on non-application of they have the power to even not to grant. ಹೇಳಿದ್ದಕ್ಕೆ ಕೊಡ್ತಾ ಇರೋದು remand.
Magistrate should have been.
That's the first filter. Why would they come here if the first filter is appropriately acted upon?
In this case, I think magistrate should have been.
No, this will write. ಬರುತ್ತದೆ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೇನೆ.
Please.
ಈಗ ಸ್ಟೇ ಕೇಳಿದ್ದೀರಾ?
ಇದು ಸ್ಟೇ ಆಗಿದೆ ಸರ್.
ಸ್ಟೇ ಆಗಿದೆ ಅಲ್ವಾ?
65 ಸ್ಟೇ ಆಗಿದೆ.
We'll see. About him we will pass an order.
66 is with respect to A1.
66
is with respect to A1 in the same thing.
ಆಯ್ತು. ಎರಡು ಟ್ಯಾಗ್ ಮಾಡಿ ಸ್ಟೇ ಆಗಿದೆಯಲ್ಲ ಈಗ?
Please.
66
And what's the offense? ಇದು ಎಷ್ಟು ವರ್ಷ ರಿಲೇಶನ್ಶಿಪ್?
That's 1 year. And we got to know that she is married to somebody else.
Is that correct?
Today morning I have.
Is that correct?
That is not correct. She is not married. She is unmarried. She is divorced.
No, don't get the clients here who ನಾನು cross examination ಮಾಡಕ್ ಬಂದಿದ್ದೆ ಕರೆದಿದ್ದೇನೆ ಇಲ್ಲ ಮತ್ತೆ?
She is
Yes.
unmarried.
Page 31. Her phone had certain photographs with her husband.
How do you say, every boy's husband, is it?
No, she has that Mangal Sutra and she's hugging him.
ಮಂಗಲ್ಸೂತ್ರ ಹಾಕೊಂಡು ಹಗ್ ಮಾಡಿದ್ರೆ ಅದು ಹಸ್ಬೆಂಡಾ?
Page 32 may be seen, please.
Hmm.
Her phone had intimate photos of with him. That's the reason we stated we don't want to continue this.
Why did you check the phone?
Millards?
Why did you check the phone?
No, Millards. We were in relationship with her,
Hmm.
and at that juncture we saw her phone.
Oh.
That's all.
Hmm.
I think the respondent also should be,
And respondent?
should also be held restraint, my lord, in,
No, if the respondent is going overboard, we'll direct the police to take action against the respondent also. Let her not think setting the criminal law into motion, she has done everything correct. And then SI,
He's a probationary SI, please.
Yaro?
The accused number one, petitioner in 8585.
We'll deal with this 69, yes. ಅದು ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ ಆಮೇಲೆ ಲಿಸ್ಟ್ ಆನ್ ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇಗೆ ಹಾಕಿ.
Today morning I filed Wakala.
All right, register to print the name of so and so is appearing for the respondent. ಅವ್ರು ಹೋಗ್ಲಿ, ಆ ನೇಮ್ ಬರ್ಕೊಂಡಿದ್ದೀರಲ್ಲ, ನೇಮ್ ಪೆನ್ ಮಾಡ್ರಿ ಅದಕ್ಕೆ. ಎಸ್, ಕಂಟಿನ್ಯೂ ದ ಲಿಸ್ಟ್ ಮಾಡಿ.
Continue.
26, my lord, there's one more matter.
That's
24.
interim order, maybe.
Entry model ಕಂಟಿನ್ಯೂ.
Oblique.
24, one more matter.
ಏನದು?
Yet to receive copies, he may.
24 ತಗೊಳ್ಳಿ, ವಿಶ್ರುತ್. ಯಾವುದು ನೆನ್ನೆದಾ?
This is that stolen property, receiver of stolen property.
Hmm.
His contention is that he has not been informed and he's been taken into illegal custody.
Hmm.
I secured the record, my lord. Grounds of arrest have been given.
Hmm.
This accused number 1 has stolen multiple Mangal Sutras from the temple.
Hmm.
That has been pledged with the petitioner.
But you have given all the idalla?
Yes, we have given.
Grounds of arrest ಇದೆಯಾ?
Everything has been given.
Reasons of arrest ಇದೆಯಾ?
Everything that
Communicated?
Communicated.
Yes. List on Wednesday
IO is present, my lord.
in the fresh matters.
He recovered about 15 Mangal
Sutras.
Mangal Sutras.
All right. ಇಂಥದಕ್ಕೆ ಮಾಡಿ. ಇದು ಬೇಡ ಅಂತ. ಅಲ್ಲ, ಅದು ಸಿಕ್ಕಿದ್ದಕ್ಕೆ ಮಾಡಿದ್ರೆ? Yes, list on Wednesday in the fresh matters list. Yes. The investigating officer and the direction of this court, so and so is present. His presence in the future proceedings is dispensed with. Yes, next.
Continued 7.
That yesterday's matter to defreeze the account.
This can be allowed.
The petitioner is before the court calling in question an order of the concerned court which rejects the application filed under section 497 and 503 of the BNSS seeking defreezement of the account. Defreezement
Defreeze and lien.
ಅಲ್ಲ, defreeze and demark the lien. ನಿಮ್ದೇ ದುಡ್ತಾನೆ ಎಲ್ಲ ಅದು.
ಹೌದು ಸರ್.
Defreeze and demark the lien that is operating on him. The petitioner is not is the complainant.
Yes.
Petitioner is the complainant who is said to have lost several amounts of money in a cyber fraud. He registers a complaint before the cyber police station, which becomes a crime in crime number 146 of 2025 for several offences. The issue in the list is not with regard to the said offences. By the time the petitioner could register the crime, and the freezement of the account could happen, about 3 crores.
68 lakhs.
3 crores 68 lakhs was transferred by the accused to several accounts which was in 16 banks. The petitioner then files an application before the concerned court seeking defreezement, demarking of the lien in the account of the accused and transfer of the said amount to the account of the petitioner. There were no rival claimants to the account, as the petitioner was admittedly a victim of the cyber fraud at the hands of the accused. The investigation was still underway. The petitioner the petitioner on the said the rejection of the application by the concerned court is before this court in the subject petition. The learned counsel for the petitioner would demonstrate that all the amounts that he has lost to the tune of 3 crores by a cyber fraud belongs to him, and those amounts are frozen at the hands of those amounts are frozen, and the lien is marked in few of the banks. Therefore, therefore seeks a direction for demarking of the lien, defreezement of the account, and the amount to be transferred to his account.
Only two PF, your lordship.
Whatever prayer is, so and so. The learned SPP on instructions would submit that the amount does belong to the victim, the petitioner, and there are no rival claimants. In that light, the prayer that was sought for by the petitioner before the concerned court in the application under 497 and 503 deserves to be allowed. It is thus allowed. A direction be issued by the investigating officer to the banks sought for in the prayer before the concerned court to defreeze, demark, and do the needful action. Yes.
And dispose the matter within 6 months because
Which one? Which matter?
The entire CC, my lord. 75 years NRI, my lord. Habitually, this person is doing, my lord. He's the second victim.
That we can't. ಇದ್ರಲ್ಲಾಗಲ್ಲ ಇನ್ನೊಂದು ಪೆಟಿಷನ್ ಹಾಕಿ ಒಂದ್ 2 ತಿಂಗಳಾದ್ಮೇಲೆ. Yes.
Only one submission, ದಯವಿಟ್ಟು. Page number 407 of document, my lord. Repeated FIRs, the same accused has been doing. My lord, and charge of fame ಆಗಿಲ್ಲ.
We'll direct it to be speeded up. We'll see. Yes. All right.
Kindly, my lord. Because 3 months ಒಂದೊಂದು ಸತಿನೂ ಹಾಕ್ತಾರೆ.
ನೀವು 2 months ಬಿಟ್ಟು ಹಾಕಿ. Yes, next.
Two petitions, 8 and 8.1. There ought to have been a case and counter case registered.
Different investigating officers, sir.
One though, in fact, my FIR did not even come to be registered. PCR I had to file, and thereafter some report has been called for. And in the case against me, there is a charge sheet filed.
Really, SPP or how many times different investigating officers irbardu?
Both 307 minutes.
Wait, we'll take it on Tuesday. Tuesday, fresh matters. Yes, next.
9.
I don't have an interim order in this yet. I don't have an interim order.
Tuesday. Let's see. Yen allivarge ena. Yes, affidavit hakadra?
Yes,
kodi.
Copy ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅವ್ರಿಗೆ ಸರ್ಗೆ
ಹರ್ಷವರ್ಧನ್ ರಾವ್ ಕೇಸ್ ನೋಡ್ದ.
ಅಯ್ಯೋ ಆಮೇಲೆ ಹಂಗ್ ಬೇಕು ಅಂದ್ರೆ ದೀಕ್ಷಿತ್ ಸಾಹೇಬ್ರ ಆರ್ಡರ್ ಕೊಡ್ಲಾ?
ಅಲ್ಲ, I thought that holds the field. ಹರ್ಷವರ್ಧನ್ ರಾವ್.
ಆಮೇಲೆ ಬೇಕಾದಷ್ಟು ಬರದಾಗಿದೆ. That's 2022 judgment, sir. Namdu.
And also, my lord, the parties, not there is an affidavit filed, joint affidavit, given a memo, my lord.
We will direct if he doesn't return and cooperate with the things, then.
Yes, ma'am. That observation.
That will always be there. Liberty is reserved to impound the passport.
Yes.
That is there. We'll close it. Application matra.
Please.
Yes.
Only in so far as.
Application affidavit na court ಮಾಡ್ಬಿಟ್ಟು last ಅಲ್ಲಿ in the event the petitioner would not appear and cooperate with the trial, it is the respondent passport authority, Ministry of External Affairs through the regional passport office is at liberty to take steps to impound the passport of the petitioner.
Request, my lord.
ಆಯ್ತು ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಅಲ್ಲಿ?
And delivery ಗೆ ನೋಡ. Please.
And delivery ಆಗಲ್ಲ. ನಾಳೆ ರಜಾ, Saturday ಬೆಳಿಗ್ಗೆ.
Please.
Yes, because already 4:30.
Please.
Yes, heard, madam, ASG. Yes,
Great.
3 yaru, madam. You want your appearance to be shown, officer?
Sir. Ji sir.
You want your appearance to be shown?
Ji sir. Kindly mark my
present.
presence also, please.
All right. Yes. Okay. Yes, sir.
Thank you.
Yes.
I can't, it's not audible, man.
Yes. Dispose. ಅದಿರೋದು IA dispose. Petition ಹಾಕಿರೋದೇ ಅದಕ್ಕ ಗೌರವ್. Petition is for that or IA? Caution ಇಲ್ಲ. It's only on IA. Interim order ಇದೆಯಾ?
Interim prayers ಕೇಳಿದ್ವಿ.
ಇರ್ಲಿ, ಈಗ ಸದ್ಯಕ್ಕೆ ನೀವು ಹೋಗಿ ಬನ್ನಿ. No interim prayer, yes. Yes.
Yes, Your Lordship. Lordship, at the time of cross-examination, the complainant company gives an admission, several admission, Your Lordship. Later, at the belated state, they come up with the authorization letter and file section 91 application along with the 311, which is allowed. Subsequently, my 311 application
has
is
to be allowed,
rejected,
sir.
Your
The
Lordship.
reason why I'm just
I'll
going to
tell you.
point out your lordship.
No.
Is to say that it's not first
No,
time
no,
they've approached
no,
this court
that's,
also.
that's not the thing. See, I'll tell you, what is sauce for the goose is sauce for the gander. Now, you file an application, that is allowed. Because of your application, an application is filed, that is rejected.
It is not just because of my application. They
What-
had three opportunities.
Maybe inter alia,
They
maybe
had
inter
three
alia, but
opportunities.
what necessitated filing of the application is your application,
Maybe the
which comes
conduct
to
may
be
be
allowed.
noted.
What, sir?
Maybe the conduct may be noted, my lord.
Ah,
Lordships
no,
also will come to the opinion that this may not be warranted, my lords.
That's not, no.
Even if you're a bare perusal of the application, my lords.
That's okay. Now, the reason for filing an application is the allowing of your application. As simple as that.
The application was filed first, my lords.
In one
But
case, it is
it should
filed,
be
Your
allowed, right?
Lordship.
What did you want to cross-examine? The authorization?
My lords,
Your Lordship.
if I may. The prayer is not even clear as to whether they want for defendant evidence or to cross me. They had an opportunity
They
to
want.
cross-examine
For
me.
cross-examination, Your Lordship.
Where is the prayer? 138, huh?
138, my lords. 2022 matter, my lords. It's in judgment stage right now.
116 page number, Your Lordship.
One hundred and?
116 is the application. Your Lordship. 113. Your Lordship.
What do you want to, whom do you want to cross-examine now?
PW1, Your Lordship.
At the stage where complaint required substantial authority, such procedure lapse the complaint had not been diligent in attempting.
It is only on ground of delay it is rejected, Your Lordship.
Yes, the petitioner is before the court seeking the following prayer. The petitioner is the accused, the respondent, the complainant, the two have a transaction, the transaction goes wrong and the complainant is before the concerned court invoking section 200 of the CRPC for offense punishable under section 138 of the Negotiable Instruments Act. The petitioner, the issue in the list is not with regard to the merit of the matter. Before the concerned court, the petitioner, the complainant initially files an application. Complainant files an application under section 311 of the CRPC, which comes to be allowed. The application was with regard to the authority to file these, to institute the said proceedings against the accused, the petitioner. On the application being allowed, even before the application could be allowed, the petitioner had filed an application under section 311 and 91 of the CRPC for the same reason. The application filed by the petitioner reads as follows. Page 116, Allah?
No, Swami, I do 124, my lord. 116 is the objection. they filed.
124, correct. Page 124.
It's for defendant evidence they sought for.
ಅದೇ ಅಲ್ವಾ ರಿಜೆಕ್ಟ್ ಆಗಿರೋದು ಈಗ?
124 is what's rejected, but they have not asked for cross. They've asked for defendant evidence, my lord.
Whatever. So and so. The petitioner, the concerned court rejects the application on the following ground, page 122 to 124. The learned counsel for the petitioner submits that in view of the authorization letter being produced by the complainant through an application filed under section 311, which comes to be allowed, an opportunity ought to have been granted to the petitioner to lead evidence on the said marking of the authorization letter by if necessary to recall PW1 on the issue. That is what is said here.
They had the opportunity to recross.
That's okay, yes.
This is for a totally different reason.
So and so. in the light of the said application being allowed by the concerned court qua the complainant, it ought to have been allowed qua the petitioner as well. However, the learned counsel for the respondent submits that the matter is the stage of judgment, and therefore the application is being used as a ruse to drag the proceedings. In the light of the aforesaid circumstance, while granting one opportunity to the petitioner, I direct the concerned court to oversee that it should not drag the proceedings any further. For the aforesaid reasons, the following order allowed, quashed, application allowed. The concerned court shall permit the defense evidence or cross-examination as the case would be, as sought for in the application on a particular day, and no adjournment would be granted to the petitioner on the said date. In the event the petitioner would not avail of the said opportunity on the said date, the concerned court shall close the examination or cross-examination as the case would be. For the
There are two prayers that they've made, my lord. Prayer A may not be considered, my lord.
What is that prayer A?
That was my grant of my application. They're trying to set that as well.
That's okay. Prayer B. Yes.
My lord, if the trial court may be directed to dispose of
Yeah,
the
ಯಾವ ವರ್ಷದಿದು?
2022.
In the light of the issue being of the year 2022, I deem it appropriate to direct the concerned court to conclude the proceedings with an outer limit of 4 months from the judgment already. Outer limit of 3 months from the date of receipt of the copy of the order, if not earlier. Yes, ordered accordingly. Next.
The connected matter as well.
Same both.
Grateful, Your Lordship.
Same order. Is next.
11.
Lord, the section 60 and 50 of the Forest Act, Lord, it's a classified 104B of the Forest Act, the cognizable offense and non-cognizable offenses. Only chapter 10 offenses are classified as cognizable offenses.
Your Lordship, please see this order. Your Lordship's order in earlier occasion for the same sawmill.
Sawmill tane?
Yes, yes.
Kodi.
Last page.
Undertaking of duty.
ಇವ್ರದೇನಾ ಇದು?
ಇವ್ರದೇ.
ಮತ್ತೆ ಯಾಕೆ ಬಂದಿದ್ದೀರಾ ಮತ್ತೆ?
Lord, I'll pass on the one letter. Lord, the temple authorities, Lord, was undergoing the renovation. They requested one wooden log to be cut into pieces by sawing. And into the crime of web lords by
already shall undertake not to indulge in any activities that would become ingredients of the Forest Act.
Yes. I'll pass on the letter.
ಅದು ಒಂದೇನ? ಯಾಕೆ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದೆ?
Pro bono service I made temple. ಅವರೇ ಒಂದು ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದನ್ನ ನಾನು
ಅದನ್ನ ಒಳಗಡೆ ತಗೊಂಡು ಹೋಗಿ
ಅದನ್ನ ತಿಳ್ಕೊಂಡು ಅದನ್ನೇ ನೋಡ್ಕೊಂಡು ಕಂಪ್ಲೇಂಟ್.
ಯಾರದು?
ಅಲ್ಲ, but
if it is a log inside temple, leave it. Yes. ಅದಕ್ಕೊಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಈಗ.
let him not take the shelter of the same letter and then.
ಅದೇನಿಲ್ಲ. ಮತ್ತೆ ಇದು ಲಾಗ್ ಅಷ್ಟೇ, ಲಾಗ್ಸ್ಗೆ ಅಂತ ಮಲ್ಟಿಪ್ಲೈ ಮಾಡಿ.
There are no cases against only the
ಥೆಫ್ಟ್.
ಕಟ್ ಮಾಡಿ
ದೇವಸ್ಥಾನದೊಳಗೆ ತಗೊಂಡು ಹೋಗಕ್ಕೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Page 25.
They requested, we made into piece.
Page 25.
Only 2.7 square meters.
ಏನ್ ಇಷ್ಟೊಂದು ಲಾಗ್ಸ್ ಮಾಡಿದ್ರ?
ಅದು ಕಟ್ ಇಂಟು ಒಂದು ಲಾಗ್ ಅನ್ನು ಪೀಸ್ ಮಾಡಿ ಕೊಟ್ಟಿರೋದು 2.7 meters ಅಷ್ಟೇ.
For the use of the temple. ಅದು ಬೇರೆ ಏನಕ್ಕಾರ ಯೂಸ್ ಮಾಡಿದ್ರೆ let them take action. The petitioner is before this court seeking the following prayer. The learned counsel, learned SPP would place on record an interim order granted by this court in the case of these very petitioners who run the sawmill. The interim order reads as follows. The learned counsel for the petitioner now submits that he is wanting to cut the logs and transport it and put it inside a temple for the refurbishment of the same. and has produced a letter from the hands of the temple where they sought that the logs be cut and then placed inside the temple for its usage. The petitioner, the submission of the petitioner, the communication and the annexure appended to the petition all would corroborate. Therefore, I deem it appropriate to ಇದನ್ನು stay ಯಾಕೆ ಮಾಡೋದು, dispose ಮಾಡ್ತೇನೆ. Dispose ಮಾಡಿ. In the light of the said circumstance, the FOC so registered on the aforesaid ground that the petitioner has cut the log would stand obliterated on the condition that the petitioner would use the logs cut. The petitioner would put the logs cut inside the temple as he is indicated. If there is any other logs being cut by the petitioner unauthorizedly, it is open to the respondent forest department to take action in accordance with law. The aforesaid observation, the petition stands disposed.
They closed my entire sawmill.
In the light of the quashment of the subject proceedings, the sawmill that has stood closed on account of the aforesaid alleged offence shall be forthwith reopened. 50 employees are there ಅಂತ ಹೇಳಿದ್ದೇನೆ already. Next.
230 moved matters. Fresh matter. Seal number 1, Murali B.
Yes, forward, charge sheet. Gottilla. Trial has begun. The petition is moved for withdrawal on the score that the trial has already commenced. Meenakshi Bala goes next.
Seal number 2, Sri Rajas.
2 ne kottidda. Yes. Who are you?
This is a connected. Respondent 2, my lord. Guru Raj. The matter.
Notice ಮಾಡಿದೀವಾ?
Yes, sir.
Notice ಮಾಡಿದೀನಾ?
This is in a different matter. He's appearing in a different matter.
Oh, sorry, sir. Mine is serial number 15.
Yes. Very.
Lords, may kindly take my lord page 18. The FIR, my lords. Rape 64. My lords, why is 64(2)(m) is invoked, my lords? I will just demonstrate, my lords. 64(2)(m), my lords. My lords may take column 3.
That is repeated rape.
Repeated rape. Date, my lords, 1/10/25 to 25/5/26.
ಬಲವಂತವಾಗಿ ಆಗ ನನ್ನ ಮೇಲೆ.
My lords may take, my lords, page 23. ನಮ್ಮಿಬ್ಬರ ಮಧ್ಯೆ ಪ್ರೀತಿ ಬೆಳೆದು ನಾವಿಬ್ಬರು ನಮ್ಮ so and so ಅನ್ನು ತೆಗೆದುಕೊಂಡು ಕಾಲ್ ಮೆಸೇಜ್ ಮಾಡುತ್ತಿದ್ದೆವು. ಆಗ ಶಿವ್ so and so.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
My lords, page 23 para 3, my lords. May be permitted to read this may be little relevant, my lords. Para 3. ನನ್ನ ತಂದೆಯು so and so ಇಟ್ಟುಕೊಂಡಿದ್ದು, ನಮ್ಮ ತಂದೆ ತಾಯಿ ಎಲ್ಲಿಗಾದರೂ ಹೋಗಿದ್ದಾಗ ನಾನು ಅಂಗಡಿಯಲ್ಲಿದ್ದು ಅಂಗಡಿಯ ವ್ಯಾಪಾರ ನೋಡಿಕೊಳ್ಳುತ್ತಿದ್ದೇನು. ನಾನು ಅಂಗಡಿಯಲ್ಲಿ ಇಲ್ಲದಿದ್ದಾಗ ಸುಮಾರು 8 ತಿಂಗಳ ಹಿಂದೆ ಫ್ಲಿಪ್ಕಾರ್ಟ್ ನಲ್ಲಿ so and so ವ್ಯಕ್ತಿ ಎಂಬಾತನು ಆಗಾಗ ನಮ್ಮ ಅಂಗಡಿಗೆ ಬಂದು ತೆಗೆದುಕೊಳ್ಳುತ್ತಿದ್ದಾನೆ. ಹೌದು.
You are an employee of Flipkart.
I am an executive. Please, my lords. ಆ ಸಮಯದಲ್ಲಿ ಆತನು ನನಗೆ ಪರಿಚಯವಾಗಿದ್ದು ನಮ್ಮಿಬ್ಬರ ಮಧ್ಯೆ ಪ್ರೀತಿ ಬೆಳೆದು ನಾವಿಬ್ಬರು ನಮ್ಮ ವಾಟ್ಸ್ಆಪ್ ನಂಬರ್ ತೆಗೆದುಕೊಂಡು ಕಾಲ್ ಮೆಸೇಜ್ ಮಾಡುತ್ತಿದ್ದೆವು. ಆಗ ಶಿವಕುಮಾರ್ ಎಂಬಾತನು ನಿನ್ನನ್ನು ಚೆನ್ನಾಗಿ ನೋಡಿಕೊಳ್ಳುತ್ತೇನೆ, ಮದುವೆ ಮಾಡಿಕೊಳ್ಳುತ್ತೇನೆ ಎಂದು ನಂಬಿಸಿ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಯಾರು ಇಲ್ಲದಾಗ ನಮ್ಮ ಮನೆ ಬಳಿ ಬಂದು so and so, my lords. Next paragraph, next page. ಈ ದಿನ 25/5/2026 ರಂದು ನಾನು ಮತ್ತು ನನ್ನ ತಾಯಿ so and so ರವರೊಂದಿಗೆ ಯಲಹಂಕ ಸರ್ಕಾರಿ ಡಿಗ್ರಿ ಕಾಲೇಜ್ಗೆ ಅಡ್ಮಿಷನ್ ಮಾಡಿಸಲು ಹೋಗಿದ್ದಾಗ ಡಿಗ್ರಿ ಕಾಲೇಜ್ ಹತ್ತಿರ ನನಗೆ so and so ಬಂದ ಹಾಗೆ ಆಯಿತು. ಸೊ ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಯಲಹಂಕ ಸರಸ್ವತಿ ಕ್ಲಿನಿಕ್ಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ತೋರಿಸಿದಾಗ ಅಲ್ಲಿನ ವೈದ್ಯರು ಸ್ಕ್ಯಾನಿಂಗ್ ಮಾಡಿ ರಕ್ತ ಪರೀಕ್ಷೆ ಮಾಡಿ ನಾನು so and so ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. Inherently, my lords, impossible.
ಯಾಕೆ?
For 7 months, my lords.
7 months pregnant ಅಂತ ಹೇಳಿರೋದು.
Please.
Where is it inherent in probability in this?
For them to not realize, my lords, that they were pregnant for 7 months is inherently impossible.
That's a different thing. That we will see.
And this, my lords, I've been taken into custody when I went to attend to her in the hospital. From my lords, the hospital, I was taken directly into custody. And in the
grounds of arrest kotilva.
In the arrest memo, my lords, I am demonstrated to be taken from some temple, my lords, nearby some temple. ಬಾತ್ಮೀದಾರರಿಂದ ಬಂದ ಮಾಹಿತಿಯ ಮೇರೆಗೆ
ಇದರಲ್ಲಿ ಏನ್ ಗಲಾಟೆ ಮಾಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ, ಅವರೇ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಗಲಾಟೆ.
And the parents of my lords, the complainant.
Parents also into custody?
No, parents of the complainant, my lords, they, because I belong to, my lords, the minority caste, my lords, they were not happy with this relationship. Immediately, my lords, they call 112. They take me, victim, and themselves to the police station. There, my lords, an FIR is registered. Immediately, my lords, I am taken into custody.
No, your parents are not troubled.
My parents are not troubled.
All right. But ಇದರಲ್ಲಿ ರಿಲೀಸ್ ಮಾಡೋದು ಡೈರೆಕ್ಷನ್ ಕೊಡಕ್ಕಾಗಲ್ಲ. You
Please,
have to secure bail.
but my lords,
You have to secure bail. This is not an instance of consensual acts and promise to marry ಅವೆಲ್ಲ ಇಲ್ಲ.
it is not marriage, my lords, because if it was marriage, my lords, it could be, my lords, any consent, my lords, given prior to, my lords, the activity being undertaken, my lords, is immaterial.
All this is a matter of evidence.
My lords, she
No,
herself admits, my
not
lords,
a-
in her
not a-
complaint that we
That's
both
all
were in a
right.
love relationship.
There are no many, there's not many instances are noticed, only one, and she becomes pregnant there. It's exactly 7 months prior to that.
Please, my lords,
Then
I am constantly in a,
7 months ವರೆಗೂ ಗೊತ್ತಾಗಿಲ್ಲ ಅಂತಂದ್ರೆ that's a different thing, we'll
no,
see.
my lords, I am constantly in a relationship.
With whom?
The victim.
all
And that is why, my lords, I was with her in the hospital at the time of, my lords, her being treated. And now, my lords,
This is not a case where I can interfere.
my lords, assuming, my lords, the child is delivered, my lords, I am the father of the child. There would be no dispute about that.
Seriously?
Please, my lords, I am, on instructions I am saying,
Then fine.
but it may not amount to, just because,
That
my lords,
we'll
I come from, my lords, a minority background and the
That
girl
will-
belongs to, my lords.
Now who, the parents of the complainant are against it, is it?
Please, my lords. And 164 statement till date is not recorded.
We'll see, we'll get the records.
As on, my lords, the date of the bail, as is
Bail
recorded. in
ಕೊಟ್ಟಿದ್ದಾರಾ?
the- ಇಲ್ಲ. As is recorded in the bail order, my lords, the 164 statement is not recorded. Supreme Court says, my lords, even under BNS, my lords, under BNSS.
Is pregnant for 7 months at the time of filing complaint, not recorded for
That's
various
all right,
reasons.
No, my lords.
We'll get all that recorded, not a problem, yes.
What, my lords, 183 would contemplate. My lords, 183(6) would say,
No, you urge all this in the bail petition.
my lords, it is urged and it is rejected. my
I'll
lords.
direct the bail petition to be answered. Not a case for stay or your release. No.
Afresh, my lords, it may be ordered for,
No
because, my
problem.
lords,
Bail ಕೇಳ್ಕೊಳ್ಳಿ.
the bail petition, my
Here
lords, is
Sessions Court
all
has rejected a bail. Let him approach this court, my lord.
Oh, reject ಆಗಿದೆಯಾ bail?
rejected. It is rejected. my
And
lords.
then approach the coordinate bench.
My lords, my ground is, my lords, that 164
The
statement.
grounds of arrest is given. Reasons for arrest is
It
given.
is given. It is given.
So there is no legal snag here. So if you want to seek bail before the appropriate court.
I did, my lords, when it was urged, my lords, it is recorded that till date, my lords, the statement of the victim is not recorded. What would be, my lords, the sanctity of the statement so recorded? Because 183, my lords, 6 would specifically say.
Record ಮಾಡಿಲ್ಲ.
I'll verify. my
The
lord. I
records don't-
doubt that it's,
But I'll direct the bail court to consider it, or coordinate bench approach ಮಾಡಿ.
My lords, the 183(6), my lords, may just see, my lords, it is as soon as the commission of offense is brought to the notice of the police.
Correct, sir, I know.
Please.
161 ತಾನೇ ಅದು.
163.
164.
164, now, my lords, because of 64.
Correct. ಯಾವ ಸ್ಟೇಟ್ಮೆಂಟ್ ನೋಡಿ ಆಗಿದೆಯಾ ಆಗಿಲ್ವಾ? Just check.
It is recorded, my lords, in the bail order that it is not.
We'll take it on Tuesday. Tuesday in the fresh matters list.
Please.
Learned SVP to verify the records with regard to the statement of the victim being recorded under section 164 immediately after registration of the crime as is mandated in law.
She is not a delinquent, my lord. She is aware about her.
Not delivered.
A delinquent, my lord. She knows the consequences of her actions. That's all I'm saying.
Complaint ಕೊಡೋರೆಲ್ಲ definitely ಗೊತ್ತಿರುತ್ತೆ ಅವ್ರಿಗೆ. Yes.
Number 3, Latif B.
Proclamation.
Due to appear before this.
The petitioner is before the court calling in, seeking the following prayer. The petitioner, the concerned court, on owing to the absence of the petitioner, issues an order of proclamation and a non-bailable warrant. The learned counsel is before the court on the score that the proclamation is issued without following procedure as stipulated under section 82 and 80, ಈಗೇನು BNSS? ಏನು? 82 and 83 of the BNSS, and seeks to refer to plethora of judgments rendered by the coordinate benches with regard to the procedure to be followed qua the proclamation to be issued against the accused. The learned counsel would submit the next date of listing before the concerned
27.
court. ಯಾವತ್ತದು?
27/6.
ಶನಿವಾರ
Please, my lord, Saturday.
is Saturday. Date ಹಾಕ್ಬಿಡಿ. In that light, the petitioner shall appear before the concerned court on the next date. In the event he would not appear, the proclamation would, the concerned court is at liberty to pass coercive order, concerned court is liable to pass necessary orders as it would deem fit. In the event the petition deem fit, subject to the appearance of the petition, the proclamation shall stand suspended till the next date, till the date on which the matter is listed before the concerned court. Adonದು hand delivery. Yes. Dispose. ಅಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಬೇಡ, ಇದು ಆರ್ಡರ್ ಶೀಟ್ ಮಾಡ್ಬಿಡಿ, ಮಾಡ್ಬಿಟ್ಟು ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ, ಅವತ್ತು ಡಿಸ್ಪೋಸ್ ಮಾಡಿ. ಟ್ಯೂಸ್ಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್, ಸೊ ದಟ್ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಕೊಡಕ್ಕೆ ಈಸಿ ಆಗುತ್ತೆ. Yes. Next.
Number 4, withdrawal.
In terms of
Move for
mood for withdrawal.
withdrawal. 5, 6, 7, 8 all.
Yes.
Number 9, Gaurav Subramanian.
Lords, this is a matter wherein pertaining to illegal detention. Lords, I'll
What is left in my chamber?
ಪಾಸ್ ಓವರ್ ಒಂದು ನಿಮಿಷ ಈಗಲೇ ತಗೊಂತೀರಿ, ಅದು ಬಂದ ತಕ್ಷಣ ಹೇಳಿ ತಗೊಂತೀರಿ. ಇದೇ ತಾನು ಇಲ್ಲಿಗಲ್ ಕಸ್ಟಡಿ.
NDPS case.
NDPS ಏನು ಗಾಂಜಾ?
Iva is also here, but
ಗಾಂಜಾ ಆರ್ ಕೊಕೇನ್?
The Ganja, my lords.
ಗಾಂಜಾ.
Ganja.
ಹಾ.
Petitioner was arrested.
ಕೇಳ್ತಾ ಇರ್ತೀನಿ, ಬರುತ್ತೆ ಬಿಡಿ ಪೇಪರ್ಸ್.
Petitioner was arrested on 7/6/2026, my lord.
For what offense?
Without any affair, without
carrying
any
ganja.
offense. No, my lords.
What?
Yeah, the police personnel has visited, respondent number 2 has visited his home.
Visited is your house?
Yes, my home.
Where?
Mysore, my lords.
Mysore ಅಲ್ಲಿ?
Mysore.
ಹಾ.
They have visited my home and they have taken me along to their custody.
Hmm.
And the whole night I will be there in their custody. And the very next day on 8/6/2026, the affair has been registered against me and other persons stating that I was carrying ganja from Malvalli to Mysore.
Malvalli to Mysore.
Malvalli to Mysore.
ಏನು ಹಳ್ಳಿಗೂ ಸಪ್ಲೈ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
They state that, my lords.
Yes.
And the arrest procedures, my
How
lords.
much ganja?
240 kilos.
240 kilos.
In Aisha truck.
Yes, sir.
My lords, truck they are saying, my lords.
240 kg ಗಾಂಜಾ.
They are saying that is on the truck.
ಮಳವಳ್ಳಿ ಪೂರ್ತಿ ಹಾಳು ಮಾಡ್ಬಿಡ್ತೀರಾ?
Lords.
My learned friend contention that he was arrested. Your lordship may see page 12. He produced the order sheet.
ಓ, ಏನ್ ನಿಮ್ಗೆ ಗ್ರೌಂಡ್ಸ್ ಆಫ್ ಅರೆಸ್ಟ್ ಕೊಟ್ಟಿಲ್ವಾ?
No, my lords.
ಇಲ್ಲಿಗಲ್ ಅರೆಸ್ಟ್ ಮಾಡಿದಾರಾ?
It was in their custody, my lords, at the time of registration.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಸರ್? 240 ಕಿಲೋ ಯಾವ್ದ್ರಲ್ಲಿ ಹೆಂಗ್ ತಂದಿದ್ರು?
ತೆಂಗಿನ ಗಿಡ ತರ್ತಾ ಇದೀವಿ ಅಂತ ಹೇಳಿ ಟ್ರಕ್ ಅಲ್ಲಿ ಐಶ್ವರ್ ಟ್ರಕ್
ಲಾರಿಲಿ ಗಾಂಜಾ.
ಹೌದು, ಫ್ರಮ್ ಒರಿಸ್ಸಾ.
ಒರಿಸ್ಸಾ?
Yes.
ಏನ್ ಕಾರ್ಟೆಲ್ ಇದು?
It's we have in fact, my lord, we have unearthed many other things, and this is one of the case which has some ramification different. That
ಎಲ್ಲಿಗೆ ತಗೊಂಡ್ ಹೋಗ್ತಾ ಇದ್ರಿ ಗಾಂಜಾನ?
Lords, according to the record, my lord.
ಯಾಕೆ ಆಫ್ ಮಾಡಿದ್ರಿ? ಆನ್ ಮಾಡಿ, ಪರವಾಗಿಲ್ಲ. ಓ,
Case has been made to save some big hands, my lord. Petition has not been involved. The CCTV shows, my lords, even the host.
What CCTV shows?
They are taking him into custody from the home.
All right.
And he is in his custody of respondent number 2. They say that the next day, very early morning, 3:15, he was carrying the ganja in the truck.
Oh, ಅಲ್ಲ ಸರ್, 250 kg ಗಾಂಜಾ ಪಾಕೆಟ್ ಅಲ್ಲಿ ತಗೊಂಡು ಹೋಗಕ್ಕಾಗಲ್ಲ.
I mean custody of respondent number 2, my lord.
ಸರಿ.
Well, registration of crime also I was in the custody.
No, we have in fact, my lord, on 7th we have summoned.
ಎಲ್ಲಿಂದ ಗಾಂಜಾ comes from Orissa by lorry?
By truck. A truck, accused number 1.
Truck carrying ganja.
Accused number 1.
It is intercepted where?
In the Mysore.
ಇದಕ್ಕೆ ಮೈಸೂರಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದು ಅಷ್ಟೊಂದು.
My lords, I was in custody of respondent number 2, my lords.
Oh, seriously?
My lords,
ನೀವು ಒಬ್ರೇ ಅಲ್ವಲ್ಲ ಸರ್? This must be a cartel operating here.
that's why I have felt
This must be what are you doing with this cartels?
We have in fact, my lord, many other things have been came to light.
ಅಲ್ಲಿ 240 kg ಗಾಂಜಾ ತಂದಿರ.
We have in fact he is right, my lord. His CCTV is also right. We have taken him on 7th because he is earlier also the case against him. We have warned him and left him. By next day morning at 5 a.m. we received a message. We intercepted a vehicle and he was in the vehicle.
In that lorry?
In that truck.
They are not producing, my lords.
Don't worry, sir.
I
Yes,
have.
sir. ನಿಮ್ಗೆ ಏನಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ? ಇಲ್ಲಿಗಲ್ ಅರೆಸ್ಟ್ ಆಗಿದೆಯಾ?
Petitioner has filed even, my lords, RT application for securing the CCTV cameras of both R2 and
Absolutely.
R1.
ಆಮೇಲೆ
They are not giving even the CCTV footages, my lords.
No problem.
In fact, there are CDRs and other things. Phones have been intercepted. We have taken the telephone.
ಸೊಸೈಟಿನೇ ಹಾಳು ಮಾಡ್ಬಿಡ್ತೀರಾ?
My lords, the thing is that, my lords.
What is this? ನಿಮ್ಗೆ ಎಲ್ಲ ಪ್ರೊಸೀಜರ್ ಫಾಲೋ ಮಾಡಬೇಕು. There are cases where definitely these people frivolously initiate proceedings under the NDPS even. Not ಅದು 100 ಗ್ರಾಮು 5 ಗ್ರಾಮು 3 ಗ್ರಾಮು ಅದೆಲ್ಲ ಜೋಬಲ್ಲಿ ಇರುತ್ತೆ. 240 kg ಅಲ್ಲ ಸರ್.
They are saying, my lords.
What is this? 2.5 quintals of ganja.
When I was
More
in
than
their
1 crore rupees is a value.
When I was in their custody, how can I
No,
able to?
you are caught in the lorry ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ with the ganja.
CCTV shows different.
ಓಹ್ ಸರಿ ಸರಿ ತೊಂದರೆ ಇಲ್ಲ. ಎಲ್ಲಿ ಮಳವಳ್ಳಿಲಿ ಸಿಕ್ಕಿದ್ದ?
No, Mysore. It is truck.
ಒರಿಸ್ಸಾ ಇಂದ ಮೈಸೂರಿಗೆ.
From Orissa it comes to Hyderabad. From Hyderabad it comes to Bangalore. From Bangalore it was, in fact, my lord, vehicle was crossed the toll on 7th, Bangalore toll on 7th. We have recorded everything. It is nothing that to hide.
Petition was not there.
Oh, seriously? Yes, sir.
Lords, they have taken him in case 7-6.
No problem.
Even in remand, they have not said.
ಏನ್ ಪರವಾಗಿಲ್ಲ ಸರ್. ಏನೇನು ಪರವಾಗಿಲ್ಲ. Law is not meant for you.
And these transactions in the last 1 year, I've been told, my lord, is few crores in that bank account.
What do you do? ನಿಮ್ಮ ಅವೊಕೇಶನ್ ಏನು ಗಾಂಜಾ ಮಾರದ್ ಬಿಟ್ಟು?
No, my lords. Scrap will.
Scrap. Correct.
Now the cat is out of the bag.
Yes, you are a scrap dealer. ನಿಮ್ಮ ಅಕೌಂಟ್ ತೆಗಿಸ್ಲಾ ಇಲ್ಲ?
No NDPS case against him.
ಅಲ್ಲ ಅಕೌಂಟ್ ತೆಗಿಸ್ಲಾ ಡೀಟೇಲ್ಸ್? ಸ್ಕ್ರಾಪ್ ಡೀಲರ್ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಎಷ್ಟಿದೆ ದುಡ್ಡು ಅಂತ? We'll get out everything and all the cartel that is operating in Mysore. Mysore has become the hub. You are spoiling the city. Seriously, I'm telling you, it's the report. It's in public domain. I'm not saying something else. It is in public domain.
Also implicated, my lords.
What is implication?
Now we will place the
You place everything.
There are many things, my lord. I think which
a scrap dealer taking 240 kgs of ganja ಒಬ್ಬರಿಗೆ ಆಗಲ್ಲ. This is a cartel.
Yes.
Yes, sir.
And there are
ಇರಿ ಪೆಟಿಷನ್ ಇರ್ಲಿ. ಪೆಟಿಷನ್ ಇಲ್ಲಿರ್ಲಿ, ನೀವು ಜೈಲಲ್ಲಿ ಇರಿ. Yes.
In fact, many things I spoke to DCP of that area, my lord. She speaks much more than what is there.
About this.
Yes.
No, obviously, because 240 kilograms of ganja, one person cannot take. It must be a cartel operating. I think you should unearth it.
Yes.
Yes, sir.
Date may be.
Date will be fixed. Don't worry. Yes. Yavat fix.
Need a next week.
Maybe end of next month, my lord. Further hearing, lordship, have it for further hearing.
Yes, yes. This will.
Next week, please, my lords.
No, sir. Bail ತಗೊಳ್ಳಿ ಬೇಕಾರೆ. ಅದು ಯಾರು bail ಕೊಡ್ತಾರೆ ಕೊಡ್ಲಿ.
Next week, please.
ಅಲ್ಲ next week ಬೇಡ.
Next week ಇಲ್ಲ, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ ಸ್ವಲ್ಪ. Next week ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ? The learned SPP is directed, the petitioner is before the court contending that he has been illegally taken into custody while and he wants to seeks to rely upon a CCTV that records him being taken into custody illegally. The petitioners, the counsel for the petitioner submits that the petitioner is a scrap dealer in Mysore, and is allegedly caught in a truck carrying 240 kilograms of ganja.
No. 2 vehicles has been seen.
ಆಯ್ತು, ಇನ್ನೊಂದಿದೆಯಾ?
That accused number 1 and 3 ಇಂದ ಅಷ್ಟಾಗಿರೋದು. ನಮ್ಮಿಂದ ಇಲ್ಲ. ನಮ್ಮಿಂದ 32 kg.
ನಿಮ್ಮಂದ 32 kg. ಆಯ್ತು, ತೊಂದರೆ ಇಲ್ಲ. He is caught with 32 kilograms of ganja apart from the accused number 1 and 3 carrying totally about 240 kilograms of ganja in 2 vehicles. The learned SPP submits that the lorry which carries the said ganja is first emanates from Orissa, comes to Hyderabad, from there to Bangalore, and Bangalore it is being plied to Mysore. At that point in time, the petitioner is intercepted and is found in the lorry carrying ganja. Whether it is 32 kilos or 240 kilos is immaterial. The learned counsel submits that his arrest is illegal. Therefore, he must be forthwith set on liberty so that he could drive the lorry back. Yes. The said submission is noted. Said submission would be considered only after the learned SPP would secure the complete records and place it before the court with regard to the investigation conducted till the next date of hearing. List the matter on 30th July at 2:30 PM for further hearing. The pendency of this petition will not come in the way of the petitioner seeking his bail before the concerned court. Yes.
Seal number 10, withdrawal memo is filed.
Yes. 11.
Number 11,
Tejas.
KK.
This offense is 85, 82 BNS, my lord.
ಯಾಕೆ 2:30 ಮೂವ್ ಮಾಡಿದ್ರಿ?
The apparent of arrest, my lord.
ಯಾರು ನಿಮ್ಗೆ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
Sakleshpura police station.
85 ಅಲ್ಲಿ.
85 ಅಲ್ಲಿ. We are not involved in the offense, my lord. But simply they are.
Husband is not involved in the offense.
Husband
is not here, is it?
No, my lord. I'm the
ನಿಮ್ನ ಯಾಕೆ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರೆ?
ಚಿಕ್ಕಪ್ಪ and ಅತ್ತೆ, my lord.
ಅಲ್ಲಿ ನಿಮ್ನ ಯಾಕೆ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರೆ?
They have a warrant ಇದೆ ಅಂತ ಅರೆಸ್ಟ್ ಮಾಡ್ತಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ.
85 ಅಲ್ಲಿ.
ವಾರಂಟ್ ಕೋರ್ಟ್ ಹೋಗಿಲ್ಲ ಅನ್ನೋ ವಾರಂಟ್.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ? ಅಲ್ಲ ಕೋರ್ಟ್ ಹೋಗಿಲ್ವಾ?
ಹೋಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಯಾಕೆ ಹೋಗಿಲ್ಲ?
ಅದು ಕ್ರೈಮ್ ಸ್ಟೇಜ್ FIR ಆಗಿದೆ ಸ್ವಾಮಿ. ಇನ್ನೂ ಅದು
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
The petitioners accused number 3 and 4 are before the court calling in question the registration of a crime in crime number 221/2025 registered for offences punishable under 85 so and so so and so. The learned counsel for the petitioner submits that the police are now wanting to take the petitioners into custody in the aforesaid offence, therefore has moved the matter to be taken up for urgent hearing. It is ununderstandable about the apprehension of the petitioner for an arrest under offence punishable under section 85 of the BNS. However, to protect the liberty of the petitioner, however, there shall be an interim order of stay of further investigation qua these petitioners till the next date of hearing. ಸುಮ್ಮನೆ ಅರೆಸ್ಟ್ ಅಂತ ಹೇಳಿ ಮೂವ್ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅರೆಸ್ಟ್ ಅಂತಾರೆ.
Yes.
Reporting settlement. Number 2, number 44. Yes, Pramod Chandra.
For the petition.
Offense.
Delivery of flat was the
offense.
420-406, please. Delivery of the flat was the delay in delivery of the residential flat. Now we have delivered, please.
Don't worry. Yes.
Order sheet.
ಕೊಟ್ಟಿದ್ದೀರಾ ಫ್ಲಾಟ್ ಈಗ?
Key ಕೊಡ್ತಾ ಇದ್ದೀವಿ.
All right. Yes.
Before the court is given.
45. Srinivas Rao SS.
My lord, I'm the petitioner in this matter. We're seeking for an adjournment.
Why?
My
No
lord,
settlement?
my lord, the party has not come yet.
We'll take it next week.
Can it be please taken up on Monday, my lord?
Tuesday.
Tuesday.
Yes, Tuesday
Great,
4
my
PM to report settlement.
I may be extended, my lord.
Thank you, madam. Yes.
Great.
Next.
46. Ankit Atrocity.
For the petition. Because the MFA was for the court settle a matter. However, the respondent number 2 is not appearing before the court. We've made a multiple
MFL order settlement ಅಂದಿದ್ಯಾ?
settlement ಆಗಿದೆ sir.
ಎಲ್ಲಿದೆ ಕೊಡಿ?
46 and 47.
ಈ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಆಗಿದೆಯಾ?
Before the Honorable High Court.
ಕೊಡಿ. ಇದೆಯಾ? ಅದು ನೋಡಿ ಮೇಡಮ್ ಯಾವುದು ಅಂತ.
Multiple attempts have been made to go. Each of 4 months, my lord, she's not come. We paid 32 lakhs and then we've respondent number 2.
ಮತ್ತೆ ಬರ್ತಾ ಇಲ್ಲ ಅಂದ್ರು? ನಿಮ್ದಲ್ಲ ಸರ್.
I appeared in that MFA matter, my lord.
I
tried to contact the client, but I could
Anyway,
not.
there is closure ಇದೆ, we'll close it.
I leave it to the court.
The petitioners are before this court calling in question so and so. The parties to the list settle the dispute by drawing up terms of settlement before the division bench of this court. In the said order, the said joint affidavit filed before the division bench records the closure of the present proceedings. The allegation is the wife is now not cooperating with the closure of the present proceedings. In the light of the settlement before the division bench, the subject petition stands disposed, quashed.
Please, my lords, one submission in 9100, which is seal number 46. Petitioner number 1 is passed on. So I have filed a death
Passed on?
passed away, please.
Passed away.
I have passed on death certificate, please.
ಆಯ್ತು. ನೀವು passed on sir.
Passed away, passed on, sir.
Passed on ಅಂತಾರ passed away ಗೆ?
Passed on death certificate ಅಂತ ಹೇಳಿ.
ಆಯ್ತು ಸರ್. You pass on the passed away certificate ಕೊಡಿ. Yes. signature. Again, our passed away. Signature. ಬೇರೆಯವ್ರು. ಬೇಡ ಏನ್ ಬೇಡ ಯಾರ್ದು ಬೇಡ. Yes.
46 and 47, both man.
Pass over. Yes.
48.
Arun ji.
Settlement process.
Process alidya?
2 weeks.
17th to report settlement.
49.
The joint memo as well as the report before the.
498. ಪಾರ್ಟೀಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ಇಲ್ದಾರು ಪರವಾಗಿಲ್ಲ. ಅಲ್ಲಾಗಿ ಪರವಾಗಿಲ್ಲ ಅಲ್ಲಾಗಿದೆಯಲ್ಲ ಮೇಡಮ್. ಕೌನ್ಸಿಲ್ ಇದ್ದಾರಾ? ಕೋರ್ಟಲ್ಲಿ ಎಲ್ಲಿದ್ರು ಪರವಾಗಿಲ್ಲ ಹೇಳಿ. ಓಕೆ ಎಸ್. ಆಯ್ತು ಅವ್ರು ಅಲ್ಲೇ ಇರಲಿ.
My lord, 2 is time will be granted. Respondent number 2, the complaint.
17th 4 p.m. to report settlement.
The stay may be continued.
That will be extended.
51.
I appear for the respondent. Matter has been already settled.
Yes, sir. Offense in.
427, 447.
Joint affidavit ಇದೆಯಾ ಅಲ್ಲಿ? Parties are there?
Parties are present.
All right, yes. ಕಾಪಿ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಾ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ಗೂ?
Lodging 52, I appear for. Lodging 52.
ಮೇಡಮ್ ಕಾಪೀಸ್ ಎಲ್ಲ ಇಸ್ಕೊಂಡಿದ್ದೀರಾ ಸೆಟಲ್ಮೆಂಟ್ ಇದೆಯಾ? ಎಸ್.
Lodging 52, I appear for respondent number 2, my lords. 498A, parties present ಇದ್ದಾರೆ. Mutual divorce ಆಗಿದೆ, my lords.
ಆಯ್ತು.
Please, much obliged.
ಎಲ್ಲ ಆಮೇಲಿಂದ ಆರ್ಡರ್ ಶೀಟ್ ಸೈನ್ ಮಾಡಿ.
Much obliged.
53.
For petitioner.
53, I'm for the petitioner in this matter, my lords.
Offense.
In the last occasion, the victim age was 17 years, 3 months. For that
It is
reason,
your
my lords,
lordship, as per the school documents, it is 17 years, 2 months.
Then no settlement.
my lords, make one request, my lords.
Yes, sir.
The present is emanates from a MLC report. When the victim is admitted for hospital for delivery, not MLC was referred. Now, not she have a baby of 6 months. Not the petition may be pending, and petitioner may be released. Not she will.
Sir, even today your age is 17 years and 3 months.
Please,
How can you say that I'm getting married to the victim?
No, not actually they were married.
They are married, sir. ಈಗ registration ಆಗ್ಬೇಕು ಇಲ್ಲ continue ಅಂತಂದ್ರೆ it should be 18 years.
Please, not till completion of her age of 18 years. At least petitioner may be released on the bail because nobody is there.
After the age of 18 years, sir.
Matter may be pending. Months I will file the undertaking affidavit before this court.
So you will adjourn it by 9 months. Elli undertaking?
Because I will file it in the next date of hearing. Last occasion, the respondent also present before this court. Because of this age, my lords, they are left.
Well, Jagdish sir, we'll adjourn it ಅಷ್ಟೇ. ಮಗು ಇದೆ ಹೆಂಗು. And he is not in custody anyway. We'll adjourn it.
Or let him come back.
Not he is in custody, my lords.
He is in custody now.
Please, my lords.
Then very difficult to leave him. On the ground of marriage I can do, but marriage cannot happen now.
The lordship can direct the trial court to dispose of that matter.
3 months ಅಲ್ಲಿ dispose ಮಾಡಕ್ಕೆ ಹೇಳ್ಬಿಡ್ತು. Anyway, she is going to turn hostile. 2 months ಅಲ್ಲಿ dispose ಮಾಡಕ್ಕೆ ಹೇಳಿ. That's the best order you can get now. Anyway, ಅದಾಗಿಲ್ಲ ಅಂದ್ರೆ you have to come back here only, you can come back.
Sure. Please,
the petitioner is before the court seeking the following prayer. Seeking the following prayer. The petitioner, accused number 1, is has a relationship with the victim and now wants to get married. The victim is 17 years and 3 months today, but has already born a child. Therefore, there can be no question of the stay of the proceedings or letting the petitioner out of prison for marriage between the victim and the petitioner, though the petitioner is wanting to get married to the victim. since the victim is yet to reach the, what's the age, 70?
17.
Yet to reach the age of 18 years, and she is today 17 years and 3 months. Therefore, the only order that can be passed at this juncture is a direction to the concerned court to dispose the subject proceedings within outer limit of 2 months stroke 8 weeks from the date of receipt of the copy of the order in accordance with law. Adu close agutade. That's the best way.
Please, Malad.
Yes.
Hello,
Heard the learned counsel of the petitioner and the learned HCGP, Deepthi Alva, appearing to respond. Yes.
54.
Much
Vinod Kumar M. Vinod
Yep.
Kumar M.
Settlement, huh?
Yes. Settlement, Your Lordship. Offense 316, visa fraud, Your Lordship.
Nobody is here anyway. List 17th. Yes.
55.
I represent the petition.
Offense.
316, 318, 345, 347 and section 349, my lord.
Parties are present.
Please, my lord, parties are present.
My lord,
Still under
permitted to
investigation.
file
Huh?
for
Still under investigation.
Cheating then.
trademark infringement.
Trademark infringement. Accused yaru?
There, yeah.
Complainant? Complainant yaru? All right, yes.
Order sheet signature.
Copies.
56.
Petitioner, my lord. Respondent number 2. Settle the matter, my lord.
Offense.
307.
Settlement.
No injuries, my lord.
No injuries. Where's the wound certificate?
Injuries ಆಗಿಲ್ಲ sir. Fire ಮಾಡಿದಾರೆ ಅಂತ is the allegation. They have amicably settled the
injuries?
issue.
No injuries.
No injuries.
Touch it file.
Huh?
Antecedents ಏನಾದ್ರು ಇದೆಯಾ?
Accident.
Antecedents.
Antecedents. ಏನ್ ಫೈರ್ ಆರ್ಮಾ?
House.
ಆಗಾರ antecedents ನೋಡ್ಬೇಕು.
So that was 10 years prior, my lord. Nothing of recent past.
10 years ಹಿಂದೆ ಆಗಿರೋ ಇನ್ಸಿಡೆಂಟ್.
ಅಲ್ಲಲ್ಲ, the antecedents what the prosecution is claiming. Of late, he has a clean record, my lord. The only.
We're not using the gun now.
Now it has been released, my lord. During investigation, it was seized. In the recent past, he has a clean record, my lord.
We'll get the record.
10th, 3rd, next Friday.
57. Oh. 58.
498A and 307, my lord. There is no injury. Strangulate ಮಾಡಕ್ try ಮಾಡಿದ್ರು belt ಅಲ್ಲಿ ಅಂತ.
Husband and wife.
Husband and wife. Handing over the DD.
You are living together now?
No, I'm handing over the DD. They're separated.
Of?
Permanent alimony.
How much?
10 lakhs.
Is accepted?
Yes, my lord.
All right, yes. Adon last lakh. The petitioner hands over a demand draft of rupees 10 lakhs, which is as permanent alimony. In terms of the settlement, the permanent alimony in Thakpadi. In terms of the settlement anta ಮಾಡಿ, the learned counsel for the complainant is present along with the complainant. The two acknowledge the receipt of the said amount. Yes. ಆಮೇಲೆ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರು ಅದೆಲ್ಲ ಹಾಕ್ಬಿಡಿ. Yes. ಜಾಯಿಂಟ್ ಮೆಮೊ ಹಾಕಿದಾರಾ? ಜಾಯಿಂಟ್ ಮೆಮೊ ಇಲ್ಲಿ?
Page number 46 is the 18 in application.
ಅಲ್ಲೇ ಆಗಿದೆ. mediation lag.
Mediation ಅಲ್ಲಿ ಆಗಿದೆ. Page 46.
Order sheet signature.
Heard. Straight to the, yes.
59.
Appear for petitioner.
Offense.
Parties are present before this honorable.
Offense yes.
Offense 420.
420.
Cheating.
Yes.
Petitioner and respondent number 2 is mother and son.
ಆಯ್ತು ಕೊಡಿ. ಮದರ್ ಅಂಡ್ ಸನ್ ಮಧ್ಯ ಚೀಟಿಂಗ್.
ಹೌದು, ಅವ್ರ ಸಿಗ್ನೇಚರ್ ಫೋರ್ಜರಿ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ದಾರೆ.
ಆಯ್ತು ಕೊಡಿ.
ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊತಾರೆ. ಕಾಂಪ್ರಮೈಸ್ ಅಗ್ರಿಮೆಂಟ್ ಆಗಿದೆ.
ಆಯ್ತು
ಕೊಡ್ತೇನೆ.
Order sheet signatures. Order sheet signatures.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ.
ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ಸ್?
ಇವ್ರದ್ದು
in the light ಅದು ಕ್ವಾಶ್ ಮಾಡಿದ್ಮೇಲೆ in the light of the quashment of the proceedings, the original documents of
accused number 1
of the accused which is now in the custody of the concerned court shall be released to the accused forthwith.
Accused number 1.
Accused number 1 for or without broking any delay forthwith madam. Yes.
Much obliged.
Next.
Serial number 40, my lords.
Settlement.
Settlement. Serial number 40.
ಯಾಕೆ ಪಾಸ್ ಓವರ್ ಆಯ್ತಾ?
ಇಲ್ಲ ಪಾಸ್ ಓವರ್ ಆಗಲ್ಲ. It's not called out, my lord. It is not under reporting settlement.
ಆಟಿಂದ not the mistake of the court officer.
No, of course not. No, there are 7 matters in all. Offense is 420, 406. I could not discharge the loan, which I had availed.
Settle ಆಗಿದೆಯಾ?
Settle ಆಗಿದೆ. Joint memo, I'm filing all the complainants.
Parties are present.
My lord, one petitioner is present before the court. One is in Singapore. She is present online. Online.
Yes. Fine.
Please, ma'am. Grateful, ma'am.
All 7.
My lord,
All 7.
all 7 are closed. I filed 7 joint memos separately, ma'am.
Again. Offense ಏನು?
498.
Serial number?
25.
Second list.
Second list. 25.1 ನಲ್ಲಿ annexed D and E is the memorandum of settlement and decree passed in MC, my lordship.
ಆಯ್ತು. ಮೇಡಮ್ ಪೇಜ್ ಡಿಗ್ರಿನೇ ಇದೆ. ಮೆಡಿಷನ್ ಆಗಿದೆ ಅಲ್ವಾ?
ಆಗಿರುತ್ತೆ. annexed D and E ಪೇಜ್ ನಂಬರ್ 25 ಮತ್ತೆ ಪೇಜ್ ನಂಬರ್ 30.
ಬರ್ಕೊಂಬಿಡಿ ಚೇತನ್. annexed D and D.
25.1 ನಲ್ಲಿ ಸರ್ ಹಾಕಿದ್ದೀನಿ memorandum of settlement.
ಎರಡು ಸೆಟಲ್ ತಾನೆ?
Please, madam. Kindly see the.
Yes. Settlement ಇದೆಯಾ ನಿಮ್ದು?
On submission 29.
Senior counsel, Mr. Prabling now argued that matter came to be reserved. In that matter, my lord, the senior counsel requested me to make a mention that my lord wants to argue the matter.
ಮತ್ತೆ ಇಲ್ಲಿ ರಿಸರ್ವ್ ಅಂತ ಹೂ ಅಂದ್ರೆ ಅವ್ರೆ?
ಇಲ್ಲ ಅದರಲ್ಲಿ ಸ್ವಲ್ಪ ನಮ್ ಸಾರಿ ಅದು ಇವರು ರಿಟ್ ಪಿಟಿಷನ್ ಅದೆಲ್ಲ ಐ ನೀಡ್ ಟು ಎಕ್ಸ್ಪ್ಲೈನ್ ನೋಟ್ಸ್ ಪ್ರಾಪರ್ಲಿ
ಆಯ್ತು. ಥರ್ಡ್ ಹಾಕ್ಲಾ?
ಎಸ್
ಆಯ್ತು, ಥರ್ಡ್ ಹಾಕಿ. ಅದನ್ನ ರಿಸರ್ವ್ ಅಂತ ತೋರಿಸ್ಬೇಡಿ ಮೇಡಮ್, ಥರ್ಡ್ ಹಾಕಿ.
On submission, Your
Yes,
Honor.
sir.
Serial number 29.
70?
29 to report settlement. Both the parties are present.
ತಗೊಳ್ಳಿ. Offense ಏನು?
351 and 352. 118.
Parties are present?
Both parties are present.
ತಗೊಳ್ಳಿ ಮೇಡಮ್. 29.
27.
Serial number 27.
ಒಂದಾದ್ಮೇಲೆ ಒಂದು ತಾನೆ? ಒಂದು ನಿಮಿಷ.
Already filed. 29.
ನೋ ಮೇಡಮ್, 29 ಪೆಟಿಷನರ್ ಎಲ್ಲಿ? ಸರ್ ನೀವು ಯಾವ್ದು ಕಾಯ್ತಾ ಇದ್ದೀರಾ? ಕ್ಯಾಸಬ್ಲಾಂಕಾ.
62.
We'll have to go to Casablanca.
Week after next.
Or
my lord on a Saturday special.
Saturday working ಇದೆ ನಂಗೆ ಗೊತ್ತೇ ಇಲ್ಲ. ಇದ್ರೆ ಯಾವತ್ತು ಹಾಕ್ಬಿಡ್ತೀನಿ ಅವತ್ತು.
Next week after next Saturday. Thursday.
ಎಸ್. ಫ್ರೈಡೆ ಬೇಡವಾ?
Friday.
ಆಯ್ತು, ಥರ್ಸ್ಡೇ. ಯಾ ದಿನ ಇದೇನೆ ಅದೇನು?
I know that. Thursday ಅಂತ ಕೇಳೋದು, ಅವತ್ತು Friday ಅಂತ ಕೇಳಬಹುದು.
ಆಯ್ತು, ಕರೆಕ್ಟ್. ಈಗ ಸ್ಯಾಟರ್ಡೇ ಏನು ಕೇಳಕ್ಕಾಗಲ್ವಾ? No, because tomorrow is a holiday, this rush. Otherwise, I divided both the days, but because of the holiday, it's clumped. Problem, sir. Any other idea?
The same matter which Mr. Srivatsa mentioned, that
Casablanca. The next ಇವತ್ತು ಟೈಮ್ ಆಗಲ್ಲ.
I appear for the petition.
Yes, sir. I'll post it on heard both of them ಅಂತ ಮಾಡ್ಬಿಡಿ. I'll post it on 9th. 9th, sir.
Please.
Now, did your lordship may I mention, Lord?
Yes, Sangat.
Lord, list 261. Your lordship will recall this is an arbitration matter. My learned senior friend Mr. Mahesh is here online. It had to be taken up finally. Lord, there's an application for renewal of the passport and a vacating stay which my learned senior friend has filed. Lord, it's come in the final hearing category. If your lordships have it on
final hearing, no. Final hearing.
Sorry, final hearing al bandide, Lord. It's a 21 petition in which there's a vacating stay application my learned senior friend has filed.
And we'll post it under the caption
fresh matters.
Interlocutory. Under the caption interlocutory applications. Vacating stay.
Not some short date. Not
we'll post 7th.
33 ಒಂದು.
Wait.
17th, my lord.
Madam, chaos ಆಗ್ಬಿಡುತ್ತೆ, ಕರೆದ್ಬಿಡಿ. ಸೆಟಲ್ಮೆಂಟ್ ಮುಗ್ದಿಲ್ಲ, wait. ಅಂಗದ್ wait.
Yes.
29.
ಅಲ್ಲ 33
wait. ನಿಮ್ ಸೆಟಲ್ಮೆಂಟ್ ಇದೆಯಾ? ಇಲ್ಲ ತಾನೆ? ಇರಿ. Yes.
Settlement seal number 29.
Both the parties are present.
Offense ಏನು madam?
351 and 352.
Where is the joint memo?
Is it already filed, Your Lordship?
Oh my God.
Respondent advocate ಯಾರು?
I am for the
Petitioner advocate ಯಾರು?
I am representing the petition.
ಎಲ್ಲಿದೆ ಕೊಡಿ ಅದು ಜಾಯಿಂಟ್ ಮೆಮೊ. ಜಾಯಿಂಟ್ ಅಫಿಡವಿಟ್ ಹಾಕಿರೋದು ಕೊಡಿ.
20.
ಅದ್ ತಗೊಳ್ಳಿ, ಕೊಡಿ ಎಲ್ಲಿದೆ ಅಂತ.
Page number.
ಅವ್ರಿಗೆ ಕೊಡಿ ಮೇಡಮ್, ಕೊಡ್ಲಿ.
Not there, not there. ಇಲ್ಲ ಅಂದ್ರೆ ಡೇಟ್ ತಕೊಳ್ಳಿ ಇನ್ನೊಂದು.
ಇಲ್ವಾ?
ಇಲ್ಲ.
List on
27.
3rd. Yes, next.
Third. ಕೊಟ್ಬಿಡಿ. List continue.
ಈಗ ಪೇಜ್ ವೈಸ್ ಕರ್ಬಿಡಿ.
Hearing on IA. Bill number 12. Third.
Madam, 15th come. Madam, ನಿಮ್ಮ ಹತ್ರನೂ ಒಂದು ಇದೆಯಲ್ಲ ಅಲ್ಲಿ? ನಿಮ್ಮ ಹತ್ರನೂ ಇದೆ ಅಲ್ಲ? ನೋಡಿ 15th 16th ಕಮ್ಮಿ ಆಯ್ತು. Yes.
Bill number 12.
Interim order may be extended. 12.
ಒಂದು ನಿಮಿಷ ಸರ್. List. Yes. 12. 24th ಅಲ್ಲ? 15th.
Interim order may be extended.
That will extend on. List on 15th in the same, in the same stage. Yes.
13.
Vacating stay. Same day, same idea. Angad.
Yes, ma'am.
Not your office. Okay. Yes.
No, I have muted, ma'am. I have muted.
Yes.
It's where the petitioners have been indulging in creation of fake LLB and there are 10.
Really?
There are 10 cases registered in North India. The apex court has cancelled the bail of one of the petitioner's husband. I am the original complainant.
List the matter in the fresh matters list on Wednesday. Serial number 13. Idral stay idea?
Stay. No.
14.
Dispensation. Allowed.
For the respondent.
Dispensation for the reasons indicated. Madam?
So mute ಮಾಡ್ಕೊಳ್ಳಿ sir, please.
14 IP for the respondent, my lord, in this case. Application was filed for release of the cash. Same was rejected before the trial court.
1 minute. Again, 15th. ಎಷ್ಟು ಕ್ಯಾಶ್ ಇದೆ?
13 lakh and.
ಅದು PC Act da?
PC Act.
No. Yes. Next.
15.
Please.
But this is
Yen Rajat?
slight urgency. My friend is my lords the complainant. Atrocities Act. Apartment my lords issues notice. Apartment owner my lords. There is a layout formed. Association president issues a notice my lords. Subsequently an FIR.
Are you appearing? Have you appeared before the committee?
Sir,
have you appeared before the committee and secured Form C?
To secure Form C, they told me to submit Form 10.
Nothing.
Sir.
Go before the committee and secure Form C and come.
So my Form 10 application is here, sir.
But he has filed an application. My lords have the discretion to decide whether he is competent to my lords appear before my lords or not.
ಬೇರೆ ಮತ್ತೆ ನಮ್ಮ ಮೇಲೆ. Wait. ಏನು ಹೇಳಿ?
My lords, development as of my lords 1 week from today earlier. Second complaint, lords before my lords the jurisdictional police. My lords saying I have obtained favorable orders from my lords before this court by producing some fake and fabricated documents. And this has been, my lords, going on consistently. 260, my lords, complaints lodged by the complainant here. I'm sorry, my lords, complaint against 260 people lodged by the complainant, invoking, my lords, the provisions under the Atrocities Act. Habitual complainant, my lords.
Iವರು ಅಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಒಬ್ರಾ?
Adral Obro, he is one of the residents of the my lords, layout where, my lords, the petitioner also.
ಒಂದ್ ನಿಮಿಷ.
Sir, they have violated criminal law, sir.
ಒಂದ್ ನಿಮಿಷ.
Yes, sir.
What is your problem?
Sir, my problem is, he is not a social worker.
Who?
Petitioner.
Social worker.
No, he is
who are you?
projecting that he is a social worker.
Who are you?
I don't claim to be, my lords. I am the president of the Layout Welfare Association.
Association president. All right.
Sir, they have produced a fake manipulated document to seek orders based on IA under 528.
What
question.
fake manipulated document?
Yeah, they have produced.
What? Yeah.
Yes, sir. Sir, sorry, sir.
Yes.
Sir, they have produced fake unregistered letterhead to this honorable court to seek orders based on IA. And I subjected that to this under the authorities, and they gave me reply that this association is not registered under 1960 Societies or Association Act, and it is in violation of 335. It is of BNSS.
Which authority?
Registrar for Societies and Association registrar.
All right.
Under section 1960, it is in violation. They replied me. So on that grounds, I lodged a complaint against them because they have submitted this to this honorable court to seek orders based on that fake and manipulated document.
Oh.
That's the main serious offense is there, sir. If you please kindly give me consent, I will file objection. I will exhibit that document.
File objections.
Yes, sir.
But one more complaint you register on the same ground.
Yes,
I am
sir.
going to take serious.
No, sir.
note
No,
of
sir.
it.
I will not.
My lords, this is the copy of, my lords, 19th June.
Another
17th
complaint?
June. Please, my lords may have a look.
Sir, if there is any violation of law from my side, he can lodge any type of
That's
complaint
a
against
different
me.
thing.
Yes, sir.
If you want this to be correct, this to be a date given and heard, don't precipitate the matter by registering complaints after
No,
complaint.
sir, I will not register complaint against
But
them.
see, my lords, the provision, my lords, under the Atrocities Act is invoked in this subsequent complaint alleging fabrication of documents. How is, my lords,
Now,
Atrocities Act
this
invoked in this?
today is what date?
Well, it's 25th of June.
Till
I have document to prove they have.
forget it.
Yes, sir.
One more complaint comes
I
on
will
this
not,
ground.
I will not lodge, sir.
What is to be done, I will
Okay,
pass.
sir. If
Yes.
if he is having any allegation
You
against me, he can
you
lodge.
don't worry about that.
Okay, sir. Okay.
If you register another complaint on
Okay, my lord.
Atrocities Act,
Okay,
I
my
will definitely take action.
Okay, my lord.
The whole neighborhood, my lord, is afraid. They invoke, my lords, this provision, and he has issued notices to all the residents saying, don't support the petitioner. If you support, next atrocity case would be against
My
you.
lord,
Where-
20,
Please produce those
It's
communications.
already part of his objection.
my lord, 20% they have signed that unregistered letterhead.
We'll see.
It is in violation of Society Act. So that's the reason I lodged a complaint against them. SCP has directed inspector to
It's
enquire
all
that
right.
matter.
You can't live in harmony, is it?
Yes, sir.
You can't live in
No,
harmony.
I am
with
not a
others.
resident of the, see, I am constructing house there. He is in interest of taking extorting money from me. He
Oh, why?
filed in
My lords, the Dalit Sangha for
petitioner,
Karnataka.
petitioner.
How can I, my lords, extort money
Petitioner,
from
sir,
the president of
my
the
lord,
Dalit
see,
Sangha?
till date, my age is 63, no FIR against me, no conviction against me, no defamation against me.
All right.
I have maintained
We'll
law
con-
like that.
We'll consider it next time.
And he is,
List the matter on 17.
my lord, he is
List
habitual
the matter on
extortioner.
17.
Okay, sir, I will
Yes.
prove that.
No problem, but
Okay, my lord.
restrain yourself. Don't go on registering
No,
complaints.
no, I will not
Yes.
register.
My request, my
17.
lords, on
Okay,
such
my
matters, my lords, because this,
ಏನು?
the entire society, my lord, is
ಏನ್
terrorized. by this.
ತೊಂದ್ರೆ ಆಗಲ್ಲ 17th. Yes.
Sir, the
He will
whole-
not create any
No,
problem.
I will not create, sir, after your,
Obliged.
okay, my lord.
17th.
Okay, my lord.
File your objections, get all the documents.
I will get all, I will prove that they have,
To get
indulged
the
in
documents,
fake.
that we'll see later.
Okay, okay, my lord.
You okay ಅನ್ನೋದು ಬಿಡ್ಬೇಕು ನೀವು.
Oh, sorry, sir.
Yes.
Bill number 16.
Lordship, this is the Lordship, the state has directed to take as per to withdraw the prosecution. Lordship,
ಎಲ್ಲಿ ಇವ್ರನ್ನ ಶಾಂತಿ ಭೂಷಣ್ ಅವ್ರು ಬರಕ್ಕೆ
Please, my lord. Please, my lord.
Please.
ಎಸ್ DSG ಅವರೇ
Please, my lord.
ಇವ್ರದ್ದೇನು ಅಫೆನ್ಸ್ 7 years ಏನು?
Below 7 years, below 10 years.
Within 10 years. Within 10 years.
Small, intermediate quantity.
ಎಸ್ NDPS
Yes, my lord.
ಎಲ್ಲಿದ್ದು ನೈಜೀರಿಯಾ?
Nigeria, yes, my lord.
ನೈಜೀರಿಯಾನ ಎಲ್ಲಿ?
Yes, my lord, Nigeria.
ಎಸ್ ಏನ್ ಮಾಡೋದು?
My lord, the state has to take.
No,
call
this
that,
case, my lord,
state has to withdraw it.
now we have taken steps to constitute a committee, my lord.
ಹಾ.
So your lordship grant us some more time, my lord, once the committee is put in place,
Yes.
the things will be smooth, my lord.
The learned SPP submits that pursuant to the direction issued by this court, a committee, the government is in the process of constituting the committee. Therefore, the SPP shall place before this court as to what steps have been taken to constitute the committee and why there has been delay in constitution of a committee, as was directed to implement the SOP that is brought in place by the government of India. Lest the matter on 10th, the instructions be sought by then. The constitution of the committee, if any, shall be placed on record on the said date.
And also other 6 to 7 orders passed.
No.
Same condition since from 3 months. No
Wait,
action.
ಏನು ಪರವಾಗಿಲ್ಲ ಇರಿಸ್ ಎಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡಿ ವಾಪಸ್ ನೈಜೀರಿಯಾ ಕಳಿಸ್ತಾ ಇದೀವಿ.
Yes.
ಅದ್ರಲ್ಲಿ ಏನು ಅರ್ಜೆನ್ಸಿ ಬೇಡ. ವೇಟ್.
Great.
Yes.
17.
Review and limitation.
ಇದು ರೆಡಿ ಇದೆ ಡಿಕ್ಟೇಷನ್ಗೆ. You can take it as ಎಲ್ಲಿ here ನೀವು ರೆಸ್ಪಾಂಡ್ ಈಗ. We'll take it as disposed. We'll restore the file. We'll allow it and restore the file.
Can the interim order continue, which is?
Interim order, if it is restored, will continue. Idರಲ್ಲಿ interim order ಇದೆಯಾ?
Yes.
That will continue, sir, obviously. I have
Till the
disposed it.
disposal of the writ petition.
No. Now the review petition will be allowed.
Yes.
Writ petition will be restored.
Yes, please.
Now disposal of the writ petition on the score that it was covered
Yes.
under the COVID so and so, that would go. Writ petition is filed by you, Allah.
No, it was filed by me. It's filed by me.
Review alla writ petition.
Writ was also filed by me, yes.
Writ was also filed by you.
It was dismissed, madam. It was
The writ was
dismissed.
dismissed.
It was dismissed,
Yes,
alva.
my lord.
Now it will have to be allowed. Allowed, or we'll hear it further.
Very well.
We'll restore it and list it for hearing.
Let it be.
We'll take it as review petition is allowed.
Yes, please.
All right.
It can be in the same further stage, so that.
Same stage, we will post it for further hearing on 2nd or 3rd.
I'm good. Great.
ಈಗ ಬರೆಯಕ್ಕೆ ಟೈಮ್ ಇಲ್ಲ.
It's all.
Yes.
Like interim protection, because it's.
ಇದ್ರಲ್ಲಿ interim order will continue, sir. Don't worry. ಆ ತರ ತೊಂದರೆ ಏನ್ ಮಾಡಿದ್ರೆ ಕೋರ್ಟ್ ನಂಗೆ ಮೂವ್ ಮಾಡಿ ಇಮಿಡಿಯೇಟ್ ಆಗಿ. Yes.
Number 18.
Reconsider the order.
This is disposal matter.
Why is it come again?
I think petitioner might be filed some applications, please. I don't know what is this application.
List after 2 weeks. Yes.
We have paid the entire amount. There is no any due. But that submission.
List after 2 weeks. ಹಾಕ್ಬಿಡಿ ನೀವು ರಿಜಿಸ್ಟ್ರಿ.
Please, my punishment.
ಎನ್ನ?
All receipts.
ರಿಜಿಸ್ಟ್ರಿ ಹಾಕ್ಬಿಡಿ.
Please.
With a memo ಹಾಕಿ.
Please.
Yes.
Orders.
Withdrawal in terms of P. Prasanna Kumar. R2 yaru?
No, the R2 Milord is the complainant in that case. Milord.
Private person?
Private person.
Steps ಯಾಕೆ ತಗೊಂಡಿಲ್ಲ? FPF, 2 weeks to do the needful.
Milord,
Next.
This is the matter, Milord, I mentioned yesterday.
ಏನು?
That Milord, she is the widow. The other cases have been quashed. Your Lordship may kindly see.
But complainant ಬರ್ಬೇಕಲ್ಲಪ್ಪ.
Milord, your Lordship may kindly modify the interim order to the extent that this will not come in the way of her consideration of compassionate appointment.
Oh, compassionate appointment da idu. Yes. The second respondent complainant is yet to be served. Pendency of this petition, however, will not come in the way of the authorities considering the case of the petitioner for appointment on compassionate grounds in accordance with law. Yes.
But the previous round, Milord, the complaint was there. All the proceedings have been quashed. 306, 498. They're deliberately not coming there.
I think modify ಮಾಡಿದ್ದೀನಿ.
Please.
Yes.
Great.
Next.
21.
2 weeks.
21, my lord.
ಏನಿದು?
Yesterday I could not appear. Sorry, my lord. Your lordship said today for that passport.
Renewal.
Renewal
She was arguing. Wait.
Please.
Yes.
One more submission, my lord. The matter itself could be disposed of. There is a circular, my lord. This is 45 lakhs total value under the Customs Act. My lord, there is circular issued on the Supreme Court says binding, my lords. They should not prosecute.
Wednesday, fresh matters.
Please. I'm so grateful. Please. Interim order till then.
Interim order will continue. Yes.
Great.
22.
Happy for the petitioner, my lords, in this matter. I have been given the details only in the morning today, my lords. I'll file an amended petition, my lords, but their application that they had filed for impleading, my lords, was not supported by an affidavit, and your lordship's specific direction was there to that effect.
ಏನ್ direction, sir?
There was no direction, Your Honor.
Memorandum of facts jate file ಮಾಡಿದ್ರು ಸ್ವಾಮಿ impleading.
Yes, whatever.
please.
List the
I will be
matter of
given a
two,
week time to
2
prepare.
weeks needful be done by then interim protection stands extended. Next 23.
My lord, I'm appealing for responsible too, my lord. Your lordship may kindly have it in the next week, my lord.
Lordship, there is a WP tagged with a POXO and an organized crime.
What's the matter?
WP is with respect to the maintainability of an appeal in the sessions court.
All right, next.
And next one is a POXO wherein husband has instituted a POXO on the wife. Show the alleged picture is of a child whom she doesn't know. It's a child custody petition fight, your lordship. And then the husband again lodged another FIR on her for organized crime.
List the Coca.
Yes, your lordship.
Husband and wife.
Husband and wife. Husband lodged.
My
It's
lord,
all-
that's not the case, my lord. I will put forth my submissions.
ಅದೊಂದೇ ಬಾಕಿ ಇದ್ದಿದ್ದು husband and wife ಮಧ್ಯ.
It's all to obtain the
Coca.
custody of the
Yes,
child.
all right.
Kindly.
We'll take it on Thursday. Next Thursday in the fresh matters. Yes.
24 adjourned, 25 disposed. Admission 26.
26, my lord. Dispute between the brothers. There is a suit pending, suit for partition.
Interim order ಇದೆಯಲ್ಲ.
Ordered by lordship judgment.
Interim order ಇದೆ ಇನ್ನೊಂದಿನ 23 ದಾ 23 ಆದ್ರೆ will take ಇವಾಗ ಆಗಲ್ಲ.
Trespass is the only allegation.
But 23 ಆದ್ರೆ will take it on an early date. That's 8 July. Yes.
Right in fresh matters.
8 July we'll see. ಎಲ್ಲ ಹಾಕ್ಬೇಕಾಗುತ್ತೆ ಆಮೇಲೆ.
Please.
27.
Withdrawal in terms of, sorry, charge sheet format. Next. All right. In consistency, madam. Pass that.
28. Allegations of 306.
2,000 rupees. When? Oh, ಅದಾ ಇದು ವಾಲ್ಮೀಕಿ.
Would like to.
SPP ನೇ ಬರ್ಬೇಕು ಇದಕ್ಕೆ.
Last date when your lordship.
ಬರ್ತಾರೆ. Don't worry. Yes. Second same stage. Yes.
There's no interim order.
ಅದ್ರಲ್ಲಿ ಯಾರು interim order ಕೊಡೋರು?
ಇಲ್ಲ, ನೀವು grant ಮಾಡುವಾಗ he said he is going to place some material to show nexus with the abatement of suicide. We have already challenged the charge sheet. There is a death note. No allegation.
Second. Yes, SPP ಅವರೇ.
Yes, my lord. Second, my lord, this is that Valmiki Corporation matter.
ಗೊತ್ತು.
where,
306.
Yes, my lord. Yes, my lord.
306 has.
This is the proximity is exist very. Proximity is very
Second.
clearly. Yes, my lord.
Second.
Fresh matter.
Interim order ಇಲ್ಲ ಅಲ್ವಾ? Fresh matters. Yes.
29 adjourned, 30.
30, 2 weeks.
Connected matters are posted on 14th, my lord.
14th, same.
14 is the.
ಎಷ್ಟು ಬೇಕ್ರಿ ಇಟ್ಟಿದ್ದೀರಾ ಒಂದೇನಾ? Yes.
31.
The offense is 108, my lord.
Huh?
108 of BNSS.
Interim order ಇಲ್ಲ ಅಲ್ವಾ?
There is no interim order. Last date of director to secure the.
Next, second in the fresh matters list.
30. 32.
I'll take notice, Lordship.
Huh?
File a complaint as a PM11. Covered by 223, it is not compliant.
ಭವಿಂದರ್ ವಾಪಸ್ ಕಳ್ಸೋಣ?
I will just check the
ಆಯ್ತು.
ordership. Just a day, that's all.
Same, second in the fresh matters list.
And 32.1, my lords.
Second, ಇಲ್ಲ, sorry, third in the fresh matters list. Yes.
32.1,
32.1 ಏನು?
that is ready for arguments.
I am not.
No. Petition is ready for argument.
ಆಯ್ತು. Yes. ಅವತ್ತೇ ಹಾಕೋಣ. Second.
It's just a short issue.
Second ಅಲ್ಲ, third.
Much obliged.
Obliged, lordship.
30?
33.
Lordship, appearing to the petitioners, your lordship. Anytime next week, your lordship.
Interim order ಇದೆಯಾ?
No, your lordship, it's only right, not to precipitate.
ಅದು ಒಂಥರ interim order. Yes.
Interim protection, your lordship. Next week, your lordship.
All right.
Also, the notice has not been sent, your lordship.
ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ವಾ? ಎಲ್ಲ ಬಂದು ವಕಾಲತ್ತು ಹಾಕಿದ್ದಾರೆ? Yes. List the matter on 15th.
Lordship,
Yes. Interim protection would continue till the next date of hearing.
34.
Mandatory provision of legal notice.
Interim order ಇದೆಯಾ?
ಇಲ್ಲ, interim order ಇಲ್ಲ.
Fresh. Monday, fresh, 6th fresh matters. Next.
4th is the case, my lord.
ಪರವಾಗಿಲ್ಲ, adjournment ತಗೊಳ್ಳಿ. Yes.
35.
Same, 6th fresh matters.
36. Impleading upon.
Give the petitioner, but like, I pray for 2 weeks time to file objection, my lord.
ಏನಿದು?
Waiting for R2 and pleading applicant.
They filed an impleading application, my lord. I'll
So I
file
am the
objections, my lord.
victim number 5 in the FIR.
What's the offense?
406 and 420.
Impleading ಯಾಕೆ? You are the complainant.
Victim number 5. I am a joint complainant.
In this
You want to
matter,
file objections?
please, man.
List the matter on 15th in the same stage. Objections, if any.
And also humble submission is that with respect to R2 they are settled. And with respect to other
ಅವತ್ತೆ
victims,
ಹೇಳಿ ಅಲ್ಲ. Yes.
Interim order may be
I'll
extended.
file memo.
Grateful, my lord.
Next.
37.
For the respondent number 2, your lords. Your lords,
2 weeks, I will.
your lords may kindly, a date may be fixed
Yeah,
because
Jagan.
your lords, after the amount has been repaid, 52,85,000 has been received under online account transfer for settling the bank loan and to repay my credit. Your lords, that has been repaid after I pledging the property in the bank. After receiving the amount of 55 lakhs including interest, the blank check which was paid given earlier the earlier occasion is
One
been
nimsh.
misused and the sale deed.
Seventh.
Fresh letters.
Yes.
In the fresh matters.
ಇದೇನು ಅಡ್ಮಿಷನ್ ಇದು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಲೆ ಬರಲಿ 7th. ಎಸ್ ನೆಕ್ಸ್ಟ್
38. Interim order.
For second respondent.
2
weeks time may be granted, my lord. File my objection to them.
2 weeks
2
IO
weeks.
SO by then. Next.
The interim order may kindly.
ಅದೇ ಹೇಳಿದ್ದಮ್ಮ.
Grateful.
Yes.
39.
G Pavan Kumar. ಹಾ.
Landlord tenant dispute.
ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ವಾ?
ಇಲ್ಲ, fresh matter.
6th fresh matters. Yes. Next.
Interim order may be.
ಎಲ್ಲೆಲ್ಲಿದೆ ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Yes.
40 disposed. Preliminary hearing 41.
41.
Fresh law.
Monday.
6.
41.
Monday 6th.
42.
Lords, appearing for the petitioner, my lords, case of 498A, proclamation has been issued, my lords.
Why proclamation?
Non-appearance in.
You are the husband.
No, my lords.
Sister-in-law.
Sister and brother-in-law of the A1, my lords. A1 is deceased.
Oh, A1 is dead.
Yes, my lord.
When is the next date?
30th, my lord.
Anyway, let's date. Heard the learned counsel appearing for the petitioner and the learned HCGP for the state. There shall be an interim order of stay of further proceedings quay the petitioner before the concerned court. This 85 format is 498 85 format. Yes, next.
Publication.
Yes.
43. Interim order.
Proceedings of the land grabbing court. There is a stay on LGC proceedings, your lordship. We'll file a
15th.
interim order may be extended.
Obviously.
Short date may be.
15th. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಆಗುತ್ತೆ. Yes.
Interim order may be extended.
Oh, yes.
Still number 60.
For the petitioner, your lordship.
ಇವತ್ತೆಲ್ಲ ಟೈಮ್ ಆಗಲ್ಲ. ನೆಕ್ಸ್ಟ್ 10th ಹಾಕಿ.
61.
Yes, my lord. For the petitioner, my lord, your lordship will recall on the previous date, adjournment was sought on the premise that there was a potential.
Admit ಆಗಿದೆಯಾ? Final hearing ಬಂದಿದೆ?
I don't know, my lord, how it has come. Your lordships are directed for listing on 25th to finally dispose it off because there's a vacating stay. My learned senior had taken an adjournment on the premise that there were settlement talks and it will come in the way of settlement.
List the matter on 7th under the caption interlocutory applications. Both these matters. Yes.
Because, my lord, it's a 21 petition, my lord.
No problem. This is 60. This is 2025 petition is what you appear, right?
No, my lord. Both I appear in 25 and 21.
Then on 7th. Yes.
Yes, I'm grateful. I'm grateful.
62 adjourned. 63, you know.
This petitioner.
This was 10th.
Interim order.
That will continue. Rohan.
64, my lord, for the petitioner.
Yes.
This is that Windsor matter, your lordship. I've been served with the respondent's reply today. Could I request any date after the 7th or 10th?
The learned counsel appearing for the petitioner submits that the objections are served upon him today. Would seek time to go through the same and file a rejoinder if any. List the matter on 10th.
10th, my lord.
Once finished, after this, Lordship, we have also filed a cognizance. Cognizance is also.
ಆಯ್ತು ಏನ್ ಹಾಕ್ತಾರ ಹಾಕ್ಲಿ ಬಿಡಿ, ರೀಜಾಯಿಂಡರ್ ತಾನೆ, ರೀಜಾಯಿಂಡ್ ಹಾಕಾರೆ.
I may not even need a rejoinder.
Criminal petition, writ petition ಇದು. Writ petition.
226.
Why heard in part?
ಅದು ಕೇಳಿದ್ರಿ, ಕೇಳ್ಬಿಟ್ಟು my lords, initially my lords it had come.
Oh, release the matter from the status of being part heard. Post the matter on 15th for admission. Alla, vacating stage, yeah? Illa alla?
ಇಲ್ಲ ಏನು
There's an interim order.
Interim order will continue, sir.
Very good.
A preliminary here. Interim
15th, your lordship.
15th.
not to
15th.
he won't do it.
My lord, Lords, one mention.
ಅದು 17th ಹಾಕಿ. Interim order will continue.
I may
One
be
mention,
pardoned.
Lords. List 1 serial number 73. The Lordship was pleased to allow it on the ground that it was quashed for.
ಹೌದು.
Lords, in that, Lords, for co-accused, liberty is reserved to the CBI. Lordship may reserve.
Same whatever company party ಮಾಡಕ್ ತಾನೆ. Same order will be passed. Yes.
I may be pardoned, my lord.
Oh, seriously.
I may be
Memo,
taken as orally.
I am in the chamber till 8 o'clock. ಅಲ್ಲೇ ಬಂದ್ಬಿಡಿ.
Please, my lord.
Come up to the chambers.
Afternoon, it is not.
No
my
problem.
lords.
You can come to the chambers. We'll start that practice also of taking the memo in the chamber. What,
Really
Avinash?
urgent.
What
It's
is all
really,
this?
really urgent, my lords. If not, my lords, I.
No problem, sir. You do one thing. You move the memo with the in-charge court. Monday I am not sitting. I'll move ಮಾಡಿ.
Lords, in that your Lordship may take me as objected because the written objections are not on record. My written objections are not on record, therefore I want.
List on Tuesday, my lord. Tuesday, my lord. Please, my lord.